kind indulgence to, my lord, mention one item, my lord, running in your lordship list as item number 92 in the monthly list. My lord, this, my lord, is a tender matter. Tender.
Mention on Monday because I won't be there for 2 weeks. Whoever takes up my matters, mention before that.
My lord, let the matter be appeared to before Honorable Justice Rajasri Bharadwaj. My lord, in your absence, my lord, I believe, my lord, Justice Bharadwaj is taking this matter.
I cannot choose benches. Sorry. No.
But let the matter not be appeared.
So whoever takes up the urgent.
So, my lord, let the
refused. Yes.
Apologies for mentioning or non-mentioning, dear Lordship. Seeking your leave. This is a tender matter. I had mentioned it, and it is up.
So this week, today I won't be taking up any mentionings. For
my lord, the only difficulty is that I have
mentioned
been
before whoever takes up the urgent matter.
My lord, if I can seek.
No, not today.
My lord,
Yes.
my lord, 457, my lord.
Today I can't take up any.
No, my lord, I'm praying for one position of this matter. My lord.
Yes.
My lord, your lordship may remember 2.5 weeks ago I came here, and because I'm going to leave, I'm waiting here. Your lordship said, okay, if it comes in the list, if not 2 or 3 days ago, come here, mention before me. Now, my lord, I'm leaving. I have a ticket I've given here.
I'm also
next
leaving.
Week. Yes, I know.
I won't be there for
I would have waited till Monday. But my lord, I'm leaving next week. So this matter, your lordship.
Whenever it is taken up, just mention, take leave to appear online, and I'll give you the grant you that leave and hearing.
No, my lord, if it could be fixed on a specific date.
No,
and
no,
time.
let me come back
My
to
lord,
you after.
My lord, because over there I have to be here then day after day all night.
Just be online there. But, ask online for a permission to appear online.
Yes, but,
as you do from here.
But if it, here I wait.
Permit you to appear online, Dr. Shah.
No, but my lord, without a time.
What is the difference between a foreign country and our country?
No,
it's online. It will be online. If seek for a leave, we'll grant you leave. No.
But I can give this.
No, why?
For the urgent reasoning.
No, Dr. Shah.
So how?
No, call on this.
Well, just the time.
No.
For judgment, item number 1.
And late by Mr. Devasiswamy, you have the respondent for the state.
1 minute just. Accordingly, WPA 18829 of 2023 is partially allowed, thereby setting aside the impugned decision recommendation of the Local Complaints Committee, North 24 Parganas. The LCC is directed to rehear the complaint of the respondent number 15 against the petitioner in accordance with law. While doing so, the LCC shall give adequate opportunity of hearing to the parties and shall serve prior copies of all documents which are relied on by the parties to their respective opponents before hearing the matter. While considering the issues afresh, the LCC shall advert to all the components of the written complaint made by the respondent number 15 and give ample opportunity to the petitioner accused to present his version of the case with relevant documents if necessary. Upon such adjudication afresh, the LCC shall come to a reasoned decision and communicate the same to all concerned. If the LCC decision refers to or is based on any expression, the entire context and backdrop of the usage of such expression shall be considered on the basis of the materials on record to ascertain whether there was any sexual overtone to such usage. Upon arriving at its decision, the LCC shall communicate the same in writing to the complainant as well as the accused within a week thereafter. Entire exercise shall be concluded by LCC within 2 months from date. It is made clear that depending on the outcome of the said exercise, it will be open to the LCC to take all necessary steps and measures consequential to its decision and commensurate with the alleged offence in accordance with law. Somewhere else I have held that LCC has jurisdiction to direct those penalties also. I mean, he will not act as a secretary and all those. Till the complaint is so decided, the petitioner will be entitled to pursue his profession in the institution in question. However, the petitioner shall not influence or seek to influence the fresh adjudication by the LCC or the concerned witness and or tamper with the relevant documents in any manner whatsoever. The petitioner shall also not have any interaction with the petitioner and or be a part of any major decision regarding the alleged victim stroke respondent of 15 during the entire tenure of the adjudication. It will be open to the LCC and or the respondent of 15 and or any other employee of the institution, if they so feel, to approach the state government for imposition of penalty for non-compliance with the provision of the Act regarding proper formation of an ICC, if any. Upon such complaint being lodged, the state government shall decide such question in accordance with law upon giving adequate opportunity of representation and or hearing to all concerned and pass appropriate orders in that regard. No orders to cause urgency debate copies. These allegations are not to castigate your client, but usual things when a trial is going on, sort of thing. Thank you.
Lordship.
Grateful.
Thank you.
Lord, may I, my lord, prefer one indulgence, my lord, my learned junior, my
Yes,
lord,
yes,
is
absolutely. What?
insisting for that. My lord, may we be represented by, my lord, a learned advocate, my lord, before the.
There is no bar in the statute. I checked up.
There is a specific bar, my lord.
There is a bar.
There
bar.
is subject to.
Oh, my lord,
Specific
I have
bar.
not seen that. I have not seen that. My
Cannot
lord,
be represented by a.
very well, my lord, I'll see to
If
it.
there's a
my lord.
bar, you have to
No, my lord,
make out reasons and
I
make out
didn't
an
know this. I
application
didn't
for
know
that.
this, my lord.
A bar should be out.
No, even if there is a bar, you have your rights. I mean, there are judgments, you know those.
My lord, I'm
You have to
enlightened,
comply
my
with
lord,
those
I
and
didn't know
this.
this. I'm enlightened. Grateful. Grateful.
Do we mention item number 2 for correction?
What correction?
Lordship,
Yes.
it has appeared at my instance. If your Lordship kindly come to Lordship's final order on 24th of August 2023, your Lordship has been pleased to direct the district magistrate to dispose of within 3 weeks. Lordship, unfortunately, it has been gone down to 3 months. If your Lordship kindly come to penultimate, last but penultimate paragraph. Instead of
In the order
Lordship,
dated,
another aspect. If your Lordship kindly to the first page of the order, last paragraph, since the petitioner is justified in arguing that the in statutory period of 60 days has long been expired and there is a justifiable cause for the application of the bank under section 14 of the Act to be pending, with the submission of the learned counsel for the petitioner on instructions that no challenge has been preferred under section 17 of the Act by the borrower and that there has been subsisting no stay order against the district magistrate. Lordship, the fact remains that they have preferred a challenge, but that has been dismissed on contest. Lordship, may I prefer?
no, make an application, proper one-page application then. The changes sought require a proper application to be filed. Full-stop. Leave is granted to the petitioner to file a short application on such score. File a one-page application. I'll make this.
Lordship, I have made a supplementary affidavit, just a single paragraph. See, Lordship, instead of Lordship, in spite of service, they have chosen not to appear. That has been
Make an
recorded in
application.
Lordship's order.
Make an application. Make a one-page application. I'll do that.
Lordship, yes.
Item 3 for release.
This pertains to what?
My lord, this pertains to group 5, my lord.
Since the matter,
municipality.
since it is submitted by learned counsel for the petitioner, that the matter pertains to group 5 of the classification of writ jurisdiction, comma, let the matter be released from my list due to lack of determination with liberty to the parties to mention for inclusion before the appropriate bench.
My lord, liberty to be given by to change the group and head, my lord.
Leave is granted to the learned advocate, leave is granted to the petitioner to carry out the necessary amendment accordingly in the A form annexed to the writ petition.
Grateful.
Item 4.
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
The
Respondent number 11 to 15, my lord.
Pardon?
I am for the respondent number 11 to
issue of the
15,
petition.
What is the intent?
and
This
my
is
senior is online number.
item 4. Why is it appearing?
My lord, there is urgency, my lord. Your petitioner is the lawful owner of the property.
Why appearing is to be mentioned?
My lord, I have directed to appear in the to be mentioned because there was a indulgence for of police in action, my lord. But this is not only the case of the police in action, my lord. There have been 5 direction from time to time by this
It was
honorable
mentioned on the ground that it is for regarding police in action. That's why I placed
Yes,
it.
I
into
think
mention.
that is the ground.
but only
Why should I place it of myself?
But,
You had mentioned it on the ground that it is appearing in connection.
but
to
my
police.
lord, in my humble submission is
Goes
that,
out
my
of the
lord,
list then. No. Don't
Only
make
police-
wrong submissions.
no.
Lordship, there is no urgency at all, your lordship.
For
Who is
police,
Surendra Kumar Sharma?
I am. I have prayed for the police help, my lord. My humble submission, my lord, from time to time, this court have directed for police help since 1999, my lord.
Entire prayer
There is a
with
order
regard
passed-
to, my lord.
There is an order passed by the Honorable
Justice
Justice Pinaki Chandra Ghosh,
Police in
Honorable
action.
Justice Thomas Kabir, Honorable Justice Rajsekhar Manta, Honorable Justice Champa Sarkar to provide and
Now it will be Honorable Justice Joy Sengupta.
my lord, but in spite of
Lordship, absolutely
My
free
lord,
to
the
matter
pertains to police, matter pertains to police in action. As such, this court does not have determination. The matter is released due to lack of determination with liberty to the parties to mention for inclusion before the appropriate. Next.
Extension of interim order.
And for the petition.
Item 5.
When does it expire?
It will expire on 15th September, my lord.
It shall extend for a limited period. What is the interim order?
The interim order was stay of the recovery proceeding before the certificate officer, my lord.
Achha. The interim order granted earlier is extended till now October 19, 2023 or until further order, whichever is earlier. The matter shall be listed for hearing on October 3, 2023 in the monthly list of October 2023.
My lord, item number 6 is same.
Same. 6 is same order in item
Same.
6 also.
6.
You're for the other side?
Yes, ma'am.
Right.
Grateful.
Thank you.
Contempt application, item 7.
Yes.
Complied, my lord. But
It is submitted by learned counsel.
after 6 months.
It is submitted by learned counsel for the parties that the alleged contemner has complied with the order of this court. Full stop. A report in that regard is filed by the alleged contemner, which is kept on record. Full stop. Hence, CPN 695 of 2023 is disposed of as infructuous without an order as to cost. Thank you.
Great.
I'm grateful.
My application for contempt.
Item 8.
My application on the contempt, my lord, your lordship passed the order.
May I clear to your lordship, then my responses. After your lordship's order, we have issued letter asking them to apply under procedure because it's a huge bulk connection. Your lordship knows the bulk connection will have to surrender. Now, my lord, they have make an application of their individual. That will be later part. First of all, we shall have to install complete the installation work. 315 kVA each transformer. We shall have to install 3 transformer. Initially, after various inspection, ultimately spot was identified, and the promoter has already applied under procedure B. We have issued quotation. Let them deposit the quotation. We shall complete the work, and thereafter they will get their individual connection. That's the procedure. Your lordship knows, my lord.
And let me submit, my lord. An order has been passed by your lordship, my lord, on 26th of November 2022. After moving the contempt application, now the quotation, we have come to know quotation is placed. Number 1. Number 2, as per the procedure we have already submitted as before your lordship's court during the hearing of the writ application, all the applications of the flat owners. This is an official space, office owners. They have applied separately for their individual connection. Now question between the promoter Merlin Group and the WBCB regarding the procedure B. We have nothing to do. Yes. He is admitting.
Yes, yes.
Now the amount will be paid by the Merlin Group. If the Merlin Group does not pay, as per the agreement terms, they have already collected when the earlier connection was obtained.
I'll give you to leave to add the Merlin Group also in the contempt.
Yes,
my lord.
Learned counsel for the petitioner submits that despite specific direction of court, the WBACDCL has not yet given electricity connection individually to the petitioner flat owners. To the flat owners in the concerned building. Full stop. Next para, learned counsel for the alleged contemners submits that as per due procedure, a huge transformer has to be installed, for which purpose the WBACDCL has already raised quotation. Full stop. However, unless and until the promoter deposits the due costs, the transformer cannot be installed. Full stop. Immediately upon the transformer being installed, the WBACDCL, it is submitted, shall take appropriate action to give individual connections to the petitioner, to the flat owners in the building concerned. Full stop. Next para. It transpires from the nature of the allegations that the brunt of the allegations, UNT, of the allegations have been made against the WBACDCL, although in the circumstances, it is the developer stroke promoter, who is now to pay the necessary amount. Full stop. Hence, leave is granted to the petitioner to implead the developer stroke promoter as an alleged contemner in the present application. Full stop. Necessary consequential correction to that effect shall be carried out by the learned advocate for the petitioner during the course of the day. Full stop. A copy of the contempt application shall also be served on the said added alleged contemner and an affidavit of service filed on the next date of hearing. Full stop. Let the matter be placed under the same heading on September 29, 2023
No,
for passing
already
further orders.
the last day, when last day, my lord, the advocate for the Marlin appeared.
Yes.
We have served copy on them.
Yes, my
One
lord.
advocate already served copy on
I
them.
pass my order, Mr. Bennett.
I have appeared.
Just to know
Yes.
carefully.
Call on the next one.
What is the copy?
Great. Thank you. Merlin will be implemented.
Yes.
So you will give your answers and you have to just pay the cost. If you pay,
We have already complied.
very well, whatever orders. On the next date, I'll pass comprehensive orders. In the meantime, Mr. Kohli, if they have complied, you try to take
Certainly,
action,
my lord, of course.
which will dispose of the writ
Yes,
petition
yes,
as
yes, of
infractions.
course. The moment they will
So
deposit the quoted amount.
any event that time had to be given to you,
Yes.
so let it be done.
Carefully.
No, they'll impede you, just intimate the court on the next date and I'll pass order locked. Keep
Carefully.
that receipt. But next.
Item 9.
9.
This matter, I am for the petitioner. Your
Yes.
lordship kindly have a look to my lord's order dated 18th of August 2023. Now, your lordship directed paragraph, relevant paragraph is paragraph second. 2 weeks time was paid by the state to comply with
Compliance
my lord.
report. File the
No,
compliance
I
report.
have served and they have received.
Yes. Where is the compliance report?
No, he is with me, my lord. He is my assistant. He yes. Well, now, on the last occasion, 3 advocates appeared. Today, none of them care to appear before my lord, though the date was fixed on the last date.
None appears for the alleged contemners at the time of call. Full stop. It is rightly pointed out by learned counsel for the petitioners that video order dated August 18, 2023 passed in connection with the contempt application, comma. It was recorded that the alleged contender number 3 shall file a compliance report on the returnable date regarding payment of costs to the petitioners as per the direction passed in the order of court. Full stop. However, comma, today none appears for the alleged contender number 3 when the matter is called on for hearing. Full stop. Next para. As a last chance to the alleged contender to file a compliance report, comma, the matter shall be listed on September 29, 2023 under the same heading. Full stop.
With regard to compliance of the central government, respondent number 1 and 3, 1 to 3, 1 and 2, they have not paid the amount as per my lord's order. They are not appearing in spite
number 3 was to file a complaint.
that is the state regarding the cost. Regarding the implementation of order of my lord.
Next para kore daw, ja bollam tarpor. It was also recorded in the order dated August 18, 2023 that it was expected that the alleged contender numbers 1 and 2 shall through counsel or otherwise, comma, indicate to the court on the next date as to the current status of the appeal preferred by the said alleged contemners. Full stop. Today, comma, however, comma, the said contemners are also not
Till date, nothing has been taken, my lord.
Pass my order, please. Full stop. Next para. It is made clear that in the event the alleged contemners are not represented or appear on September 29, 2023, comma, a rule of contempt will be issued against all the absentee contemners, and the said contemners shall be liable for the consequences thereof.
Every
service filed to be kept on record. If you can, please give another notice to the alleged contempt.
I will.
Copies of the order.
Along with my lord's order, I will.
I have not directed you, not required.
No,
But if you want, you can.
Item 10.
My lord, I am for the petitioner first
Yes,
time
please.
appearing. My lord, it's
First
related
time
to,
appearing, what is the contempt?
my lord, it's related to West Bengal Public Land Eviction and Authorized Occupancy Act, my lord.
No steps taken.
My lord.
No steps taken.
My lord, steps taken, DM after hearing directed the SDO. SDO directed the BL and LRO. And thereafter, nothing has been done. My lord, last SDLRO wrote a letter to the development officer, page 32, annexure G, my lord.
First, let me see my order.
My lord, my lord. My lord, after hearing, my lord.
So this inquiry is not yet complete.
My lord, inquiry completed, thereafter they
In the event the inquiry leads to a conclusion, the respondent number 2 shall immediately thereafter initiate appropriate proceedings.
my lord, that's been they'll remove the land.
So that
My-
has not been done.
No, my lord. Though there is a direction to the SDO to do it, thereafter SDO wrote a letter to the BL and LRO to remove the unauthorized occupants. So my lord, thereafter.
That is not a contempt of my order.
My lord,
That
there
is
is
not
a
a
two
contempt of-
part.
Second part is, it is made clear that respondent number 2 shall act in accordance with law. No, not that.
Accord-
In the event inquiry leads to a conclusion, occupation is unauthorized, 2 shall immediately thereafter initiate appropriate proceedings.
Initiate
Proceedings
appropriate
has not been initiated.
My lord, proceedings has not been initiated.
Very
to
well.
remove.
It is alleged by the petitioner that despite the order dated June 9, 2022 to initiate proceedings under the provisions of the 1962 Act, in the event the inquiry contemplated therein leads to a conclusion that the occupation is unauthorized, the alleged contender has not taken any steps despite specific direction of the district magistrate, in terms of the said order. Full stop. Next para. SDO is the contender.
My lord, contender is DM and BL and LRO.
Full stop. Next para. It is further argued that in view of the second part of the order under contempt having not been complied with by initiating appropriate proceedings, the present contempt has been filed. Full stop. The petitioner shall serve copies of the contempt application on the alleged contenders, indicating that the matter shall be listed on September 29, 2023, when the petitioner shall file an affidavit of service.
Grateful, your lords.
11 and 12.
Not, I'm appearing for the LS contender number 1. I'm filing my compliance report, madam.
Lord, appearing for the CSC.
I am for the petition.
Complied?
Milord, this matter pertains to installation of a block meter, Milord. Milord, we have made attempts twice, but Milord, unfortunately, the meter board is locked, and moreover, Milord, there is a motorbike which is placed absolutely in front of the meter board, which is denying the access absolutely to the concerned meter box. Milord, I have also got a photograph of the same.
What did the police do? You approached the
We have
police?
provided the police
Police had
protection.
been
Not
there,
we
Milord.
had been
So
there.
let's
Plus,
see if
there is
there-
an order
there
to
was-
break up the padlocks, Milord. The access could not be given.
My lord, kindly see the order.
Police report says not, it is under the position of a 110 and not on this chart, which your lordship will find from paragraph number of my LS container number, that is the paragraph 4. Paragraph 4, now your lordship kindly see. May I read it out?
Adequate police assistance, why doesn't it include removing the motorbike and all this?
And we have.
What is the necessity of police assistance? So that they for the giving the connection, they don't require any assistance.
It is on the log and your lordship give the.
Well, I'll indicate that. And a compliance report has been filed by the alleged contender. First up, it is submitted by the alleged contender that since there was no specific direction in the parent order dated March 17, 2023 to break open any padlock or remove hindrance, the police could not remove the lock affixed at the meter room. First up, learned counsel for the distribution license submits in addition, that apart from the lock, a motorbike is persistently kept in front of the meter room, blocking access thereto. First up, next para. It is seen from the order dated March 17, 2023, passed in WPA 2793 of 2023, that adequate police assistance was to be given by the officer in charge of the Southport police station, respondent number 3 therein, for the purpose of installing block meter and giving electricity connection therein. Full stop. It is implicit in the said order that for giving such assistance, the police would be at liberty to remove any hindrance thereto, including breaking open any padlock, if so affixed. Full stop. Next para. Hence, let such direction be read, READ, into the order dated March 17, 2023, and the police act accordingly. Full stop, next para. The matter shall be listed on September 29, 2023 for passing further orders. Full stop. In the meantime, comma, the CSC Limited shall attempt afresh to give electricity connection to the petitioner in terms of the direction dated March 17, 2023, and the police will give adequate assistance in terms of this order, comma, by acting on a server copy of the said order. Full stop. A further compliance report in that regard shall be filed by the alleged contemner on the next date of hearing.
My lord,
No, I've not said that you're in contempt, obviously.
He had been there, but the.
my lord, the number writ petition number, one is 2793, other is 4.
There are two contempt applications.
No, one contempt, block meter 2. Number be
Contempt is one. Oh, I've said that order was passed in
2 writ petition. So number be added. 4.
WPA देखिए एक बार না অর্ডারটা আমি ফাইলটা দেখবো
Let two separate orders be passed.
না 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 সেটা না বলেছে একটা WPA নাম্বার সেটা আলাদা নাম্বার
দুটো একই
দুটো WPA নাম্বার
ইয়েস যেখানে যেখানে ওই অর্ডারটা বলেছি WPA একটা নাম্বার দিয়েছি 2793 of 2023 যদি বলে থাকি তাহলে 4068 হবে মানে উইথ
Well, two separate orders are not.
No, one composite order, contempt one.
My lord,
P1.
Only one, next day I shall have to file by conference report.
Yes, file a short compliance report. We have given connection.
The report may kindly get them.
Yes, I have said that. Yes. Right. Next.
13 and 14.
This is my application.
Yes,
Millard,
so it's
for
a what contempt?
Yes. Lordship will remember, Millard, there was an
Contempt.
order in that where Millard they had retained an amount of my security deposit in another contract for Millard certain lands which were given to me under Millard the port. Now there are two orders. One is your Lordship's parent order of 2nd of March 2020. If your Lordship takes up CPAN 7.
You've got a copy.
This is
You've got a copy.
yes, Lordship.
Yes. What is the
Now,
copy?
Millard, they have preferred an appeal, but Millard, that appeal has been filed and no steps taken. There's a section 5 pending. Nothing has been done. In fact, your Lordship's last
How
order.
long will you take to prefer the move?
Millard, kindly take a look at your Lordship's last order. It will become clear, Millard.
Lordship gave me 3 weeks time.
18th of.
Lordship gave me 3 weeks time, Lordship.
What happened?
Then Lordship, I filed, matter was moved one day, then Lordship on the last week and this week, the court is not sitting, the Court of Chief. So Lordship, kindly allow me 2 more weeks, Lordship.
I'll give that as a last chance. Learned counsel for the petitioner submits that despite ample opportunity having been given to the alleged contemner, comma, the alleged contemner has not obtained any order in connection with the application for condonation of delay in preferring the appeal against the parent order and or in connection with the appeal till date. Full stop, next para. Learned counsel for the alleged contemner submits that although the application and the appeal were filed in time, comma, in time corona, filed duly, comma, the same could not be heard out due to non-availability of the appropriate division bench during a substantial period. Full stop, next para. Another chance of a fortnight, an extension of time for a fortnight is sought by the alleged contemner to move its application and pay for appropriate orders in connection with the appeal. Full stop. As a last chance to the petitioner, comma, as a last chance to the alleged contemner, comma, the matter is accordingly adjourned till September 29, 2023, when appropriate orders will be passed in the event the alleged contemner is not favored with any appropriate order in connection with the appeal or the connected condonation application.
This will be the order in item 14. In item 13, Millard, that's your Lordship's from your Lordship's order of 20th April 2023.
It's a different one.
Yes, Millard.
Connected.
Yes, connect.
So let both them. If they obtain an order in connection with the appeal, probably that will also.
So Lordship said parent order. It should read as
parent
both,
order.
Both orders. First, 2nd March is the parent order, and then 20th April, Millard, 2023 is the.
Well, uncle order, parent order.
Lordship, instead of 2 weeks, can it be 3
No,
weeks?
no,
Because
two.
this.
You asked for 2, I gave you 2.
No, because this week, Lordship, my lord is not sitting also.
No, Mr. Banerjee. 2 weeks. Next.
Obliged.
Lord, instead of 29th, could it be 28th?
No, 29th is the day I take up these matters.
Oh.
Let it be on 29th.
Very-
Let us see.
very-
15.
But I appear for the container lordship, the order has been complied with.
Yes or no, Mr. Banerjee?
Particle.
No.
Partial compliance. My lord, I don't deny that they have not done anything. They have done one part. That is the pole which was erected. They have heightened it. But the preceding pole through which the line passes, it has not been done. I have taken out photographs. I have attached to my.
What was the prayer in the writ petition?
Prayer in the writ petition was for shifting of the connection, high tension wires, which was passing through the property.
Vertical shifting lordship.
Look, there was no vertical prayer for vertical shifting. The word used was shifting. With that arrangement, that was their prerogative, how they will shift. I do not stand in the way. The work which they have done is they have erected a pole. As because the two poles were apart, it was very difficult for them to heighten the wires passing through my connection.
So shifting has not been done.
No, they have erected one pole. What they have done, they have heightened this pole. So now the ropes are passing in, the wires are passing in this condition. So where my house will exist, the wires are a portion of the house is free from the wires, but another portion, the preceding portion, is still have taken out photographs. Look, only they need to do that, and that there is no obstruction with regard to that, because that is a pole situated on the road, which can be easily done. Look,
But this is the affidavit on the last occasion.
and this is my reply.
Lordship, may I just
They are supposed to file it earlier and hand they have not even handed.
Right, take instruction and do the needful, rectify whatever you have not done.
We have done, even then if they want something more to be done, technically sound work has been done. That is the report I am just placing for Lordship. I am not technical man. 1 second, please. I am
Let us see the report once.
And Lordship kindly says, my lord,
report filed by the WBSADCL.
Yes. Container number 1.
Which page?
My lord,
It's an affidavit in opposition.
Yes.
Report is by the police authorities.
That is there. There. My affidavit, there was direction for filing affidavit. In that affidavit,
where is the report? Which page?
Compliant will not here, Lordship, so kindly come to my lord, page 51. That's the proceeding or the report prepared on spot. Page 51, Lordship, on 23rd of August. Wednesday, now, my lord, at 12:10, 11 km.
What is your photograph, Mr. Banerjee?
But I also Lordship, one photograph.
Which page?
Lord, photograph start from page.
Reply.
Page 10 onwards. Reply page 10 onwards.
What is that hanging thing?
Lord, kindly sees.
Page 11 probably. Right.
Page 11. Lord, this pole, if heightened, page 11, the lower left photograph. If this pole is heightened by 5 or 6 meters, 5 or 6 feet also.
Your house is a cemented one, immediately
The
adjacent.
cemented one from which the photograph has been taken.
Oh, from which it is?
Yes, it is very near. It is at arm's length.
So where is the hanging thing? I don't get it from the
Lord,
photograph.
kindly sees the.
It's sufficiently above.
Lord,
I mean, the arrangement is like, Mr. The arrangement is like that there in that locality.
No, my lord. The pole kindly sees the distance. The photo.
Show me pinpoint any one photograph where your argument is vindicated.
My lord.
I don't find anything from the photographs regarding
May I place it also at the same time parallelly?
Acha, very well. Yes.
Kindly see this.
Give a copy to them also.
Yes,
Mr.
I'll give it. Lordship, this is the photograph. The lower part shows the hanging on the Lord date 23rd when it was not done. Above photograph shows clearly it has been set up, settled, and keeping safe distance from both the.
Yes, Mr. Banerjee.
All the date mentioned there, Lordship.
Appears.
So what
kindly
more there are?
Annexure A at page 10, the top right and the right bottom photographs.
Right.
Look, these are the left wire is still passing very close to the the roof of the property. But the only difficulty is that sees the new pole erected that is at a height of 9 meters, and the wire which is proceeding to that pole is from a pole which is situated at a height of 6 meters. Now, just to cause it to pass above the house, look, the pole which is of height of 6 meters may be heightened to a height of 9 meters. Then the whole problem goes because it will pass above the house.
It is
the-
passing sufficiently above the house after
But kindly see the
top
photograph.
photograph of them.
That is from
I'll
the
give it to
below. The photographs taken from below. Well, kindly see my photos you have taken from the roof. It is below the roof. The page B, annexure B, page 11. The photograph is taken from the roof. The lower two photographs, lower left and lower right. And this is at arm's length. The wire which is near the house is at arm's length. Anyone who can reach out and touch it. That is difficult. If they heighten this pole, this is the pole I was talking of, the lower left one. If this pole is heightened by a 3 meter at least, then the problem goes away. This is of 6 meters.
This has been installed after your house was erected.
No, this was not. This is a preceding pole. What they have erected is the one which is falling from their
You
photograph.
cannot increase on your height of your building, and they will not be duty bound for that to go on.
But I have
increasing
not
the height.
increased my height. My house was of
That
this.
is what I asked you. This pole was there before or after you increased your height? You made your building.
No, the pole was preceding. I made my house after. This was an old connection.
No, for the no contempt.
And with regard to the police authorities, kindly
You cannot go on increasing height as per your.
The sanction is two-storied.
No.
The sanction granted was two-storied building. This is a two-storied building.
No, they cannot go on doing.
And one more thing, my lord, if kindly sees the annexure B, the top right photograph.
B,
top
Yes,
right
top right,
photograph.
right.
The vertical lining. If this is done also, then also the problem goes. Shifting the word user, I prayed for shifting. If this is done, if the wires are aligned virtually, then also the problem goes. Because we do not have problem with the middleware. The work has been done. But
there are so many wires already there, Mr. Banerjee.
Yes, but they have executed work in this purpose. But in this,
that's a general safety situation. Then you have to file a complaint before the appropriate authority. That is not covered by this contempt application. No.
They could have, because the prayer was for heightening and shifting. They could have shifted this vertically. What they have done, they have kept the wires horizontally aligned.
No, Mr. Banerjee.
And with one more thing with regard to the police, I have prayed for police protection. Kindly sees the WBSDC's report.
For what else?
Look, they did not come. The police never come. They were facing.
They have done it without the police.
Without the police. The police are in receipt of
counsel for the petitioner submits.
Of my life, I have done this.
And my report,
Two components of the allegation of contempt. So first, the shifting done by the WBSCDCL was half-hearted and partial. So it is submitted that there are two poles in the vicinity, one of about 6 meter height and the other 9 meter. Although the wires in question were increased in height vis-a-vis the 9 meter pole, the 6 meter pole height has not been increased, thereby the problem retaining its grievous nature. Next para. By relying on the photographs annexed to the affidavit in reply filed to the contempt application, learned counsel for the petitioner submits that the alleged contemners have only provided an eye wash and have not taken care of the safety scenario by increasing the height of the wires sufficiently. Next para, it is further alleged that the police authorities never gave any assistance at the relevant juncture, thereby also attracting the provisions of deliberate contumacious act on the part of the police. Next para, learned counsel for the police authorities you have filed a report, files a report and denies the allegations. Next para, learned counsel for the WBSCDCL also places reliance on two photographs handed over in court today, a copy of which is also given to the learned advocate for the petitioner, indicating that there were two lines which ran previously much below than their present position. However, pursuant to the direction of the court, those have been the heights of those have been increased as depicted in the top picture of the two handed over today. Next para. There is a dispute raised by the petitioner regarding whether the safety hazards were duly taken care of by the WBSCDCL. Next para. However, as it transpires, the 6 meter electricity pole was existing prior to the petitioner constructing his house to the present level. Next para. It cannot be the law that the distribution licensee shall carry on increasing the height of its poles, comma, at the behest of any and every person who chooses to make constructions adjacent to the pole. Full stop, next para. In the event the petitioner was of the opinion that due to safety hazards, comma, pursuant to subsequent construction made by the petitioner, comma, it was for the petitioner to apply at his own costs for taking further measures. Full stop. If such application is filed, comma, the WBACDCL shall take appropriate steps in accordance with law in connection therewith. Full stop. However, comma, nothing in the pictures shows that the WBACDCL has failed to comply with the order of this court, comma, since the wires in question have been shifted sufficiently high vis-a-vis the 9-meter pole. Full stop, next para. Insofar as the police authorities is concerned, comma, since the work has already been done by the WBACDCL, comma, a fact-finding exercise in that regard would be unnecessary and redundant at the present juncture. Full stop. Accordingly, CPA 892 of 2023 is disposed of. Full stop. However, comma, the petitioner will be at liberty as indicated above, comma, to apply for carrying out fresh shifting work at the petitioner's cost, comma, if the petitioner so feels necessary in future. Full stop. No rest of us.
My lord, may I place one thing with regard to
Police
the
report filed in court today be kept on record.
You filed regard to the police. My lord, even WBACTCL has averred that in spite of taking,
It has been given, Mr. Banerjee. I want to.
they have taken 22,000 for providing police help and they do not turn up. I have deposited the amount. It is in my contempt application.
If it is not necessary, why don't you return the police costs?
So that is all my pray for. They will return because they did not turn up. That
We have
is
not
already on record.
accepted, Lordship. Police has accepted that amount.
Police had accepted
We
that
have not
amount.
accepted.
I'm asking the police only, the state.
Lordship, regarding.
Police help was not required, Mr. Naik.
It was, we intimated them, but at the time of doing the job, since contempt is going on, my officer at his own life risk, because he has gone there, he has done the job.
In spite
Police did not come.
Police did not come.
পুলিশ রিপোর্ট একবার দাও তো বসো যে পর্যন্ত হয়েছে হয়েছে আর
That you have said in our.
পুলিশ রিপোর্ট আজ যেটা ফাইল হচ্ছে দাও তো স্টেটের রিপোর্ট হোয়াট এভার সেড ইন ইউর রিপোর্ট মিস দেওয়ার
Lordship. Lordship, page 28.
পেজ 8
28, my comprehensive. এটা তো না দিন। কোথায়? আমরা তো বুঝি। হ্যাঁ, এনারা জানিয়েছি। They have intimated that they have complied the order, Your Lordship, to the.
Then you return the police costs. It was not necessary. However, comma, চা বলেছি তাই? However, comma, since police assistance was not granted, comma, the concerned police station shall return the entire police help costs to the petitioner within a week from date. First, rest remains the same.
Great, Lordship. But EU has been filed and that is kept to the record, Lordship.
Whatever.
Great.
Oh, তুমি
16.
আমি বলে দিচ্ছি তো ঠিক আছে যা আছে ঠিক yes
16.
But I appear for CSC, my lord, the petitioner.
What is the contempt?
On the last occasion, my lord, your lordships held that the prima facie case
No,
of
no, what is the
has been
contempt?
made out.
That I always hold without looking into them.
Your instruction was to serve the.
What is the contempt, Alice?
Contempt, my lord,
What was the order? What did they not do?
my lord, they have not gave me the meter connection. Shifting has not been done yet. I have deposited the amount. Whatever cost was, bill amount was there, I have paid the amount.
Yes, Mr. Rai, what do you
Lord,
say?
there is no contempt on our part, actually, my lord. If your lordship sees your lordship's order, my lord, there were certain formalities, my lord, which were to be complied with, my lord, by the applicant there, not the writ petitioner. My lord, the writ petitioner was supposed to foot the bill. My lord, the writ petitioner has paid the costs. Thereafter, my lord, if your lordship sees the contempt application itself, page 23. Rather, my lord, before that, immediately after the order was passed, my lord, page 22.
Yes.
Page 22, my lord. we have, my lord, indicated, my lord, just above, kindly note that this offer letter above that, my lord, page 22, my lord.
Yes.
My lord, second paragraph from the bottom, kindly note that, my lord,
Yes.
thereafter, my lord, just above that.
90 days.
All the following compliances have to be met by you to enable us to provide the supply. Lord, please submit annexure B online. Please use such and such. And above that, the proposed meter board position and
So
shed kiosk
container numbers
details.
2 to 4 were to do this.
Yes.
Who is appealing for 2 to 4?
Lord, I am appealing for the containment number 6, but there are 3
There is no container number 6.
No, I am for the Jana post who has in math content in the proceeding.
Why didn't you do this 90 days, within 90 days? Page 22.
Only one today.
Please use the microphone. I can't hear you.
My lord, yesterday, day before yesterday, I got an instruction, I talked with my client. The difficulty, whatever my CSC, if my lord sees the content application, they have an allegation against the CSC. CSC.
Come to page 22.
I am on the 22, my lord.
Please come to page 22. The paragraph pointed out by Mr. Rai. Why didn't you do it?
Lord, I shall
To do it within 2 weeks. I want it to be done within 1 week actually. You will do this within 1 week.
3 weeks, because see,
1 week as a last chance, otherwise your client will be in jail.
No, Lord, kindly.
1 week is a grace to you. Learned counsel for the petitioner submits that despite the specific direction of this court, the order of the court was not complied with, full stop. Learned counsel for the CSC Limited points out to page 22 of the contempt application, wherein a communication by the CSC Limited to the alleged contender number 2.
And my lord, a subsequent.
Keep it with you. Dated May, Mr. Rai, please let me finish my order. Dated May 14, 2023 has been annexed, which shows that the CSC Limited had specifically asked for certain compliances to be made by the alleged container number 2, including submission of annexure B online through CSC post portal and payment of enclosed bill. Full stop, next part. Yes, what were you saying now? What is this?
Sorry, my lord, this also, my lord, was conveyed, my lord. This was also to be done by the writ petitioner. I mean,
So, a further instruction sheet, a further communication is handed over in court today by learned counsel for the CSC Limited, indicating that the meter board shed was to be extended and kiosk for street lighting service had to be installed, apart from the main switch to be installed. So, but these have to be done by them.
No, not by.
Since such works have not been carried out by the alleged container numbers 2 to 4, apparently the alleged container numbers 2 to 4 are in contempt, having deliberately violated the specific direction of the court. Full stop. However, as a last chance to the alleged container numbers 2 to 4, the matter is adjourned till September 29, 2023, when it will be listed under the same heading. Full stop. The learned advocate for the CSC Limited is requested to hand over a copy of the communication dated June 19, 2023, which has been filed in court today by the CSC Limited to the learned advocate for the alleged container numbers 2 to 4 during the course of the day, Mr. Rai. During the course of the day. Full stop. The alleged container numbers 2 to 4 shall comply with the requirements of the CSC Limited as disclosed in the said communication dated June 19, 2023 and in the communication dated May 14, 2023, annexed at page 22 of the contempt application, within within 2 weeks from date, full stop. Within 2 weeks from date, positively, full stop. In default, a rule of contempt shall be issued against the appropriate contemners on the next returnable date. I've given you 3 weeks actually.
Man, grateful to you. The copy we.
But I'm making a Xerox.
If possible, Mr. Rai, please take out another extra copy. Give a copy to your learned friend for the petitioner also. He will be knowing.
So, my lord, everybody has been served. Lord, I shall serve again.
Just yes.
Grateful to you.
Thank you.
Application item 17.
Lordship, this is an application for restoration. This is a changed brief. Delay is about 1 year, 4 months.
1 year, 4 months.
Lordship, service is could not be effected as the learned advocate for the state is not in the panel at present. Lordship, kindly give me a direction to serve the state and kindly restore the application.
After you serve only, no service could be effected. Full stop. Accordingly, the petitioner is directed to serve a copy of Can 1 of 2023 on the respondents, indicating that the matter shall be listed on September 29, 2023, when the matter shall be listed under the same heading. Full stop. The petitioner shall file an affidavit of service on the next date of hearing. Please give your name, ma'am. Next.
18.
Yes.
I appear for the petitioner.
Right.
Lordship, I am for the state led by Amrita Bajamoulik. Lordship, paying for short Passover.
No, refused. Yes, what is the matter?
My lord, the matter is very short. My lord, the petitioner had wanted to register an agreement for sale in respect of 536 sataks of land. My lord, he had taken out the query. In terms of the query, he had deposited the stamp duty and the registration fees. However, my lord, the presentation was refused. It was not registered. In terms of the provisions of the Stamp Act, my lord, I am entitled to adjustment of this stamp duties already paid against registration of the deed of conveyance when I'm finally doing it. So once the deed of conveyance was again put in for registration, my lord, and we had sought by an application adjustment of the stamp duties already paid. However, no response to that was received. Since it was already presented, my lord, we had put in entire stamp duties and the registration fees on the entire transaction again, my lord, for the second time.
Yes.
Now, my lord, we are only praying that the payments made of stamp duty made during the putting in the agreement for sale, my lord, that has to be refunded, my lord. That is the only.
What is the stand taken by them in their opposition?
My lord, their stand today is that under the Registration Act, my lord, there is a period of 4 months once a query is taken out from the date of execution of a particular document during which it has to be presented. Under the Act itself, my lord, Section 25 also provides that is extendable by another 4 months upon payment of fine. They overlooked this and the second 4 months period. They say that the 4 months period had expired, hence you were supposed to, that could not have been registered, and you cannot make any application for refund after.
Did you ask for that extension?
My lord. Now, my lord, not only that, my lord, the under Section 25, the fine that has to be taken for if I want extension of another 4 months period, my lord, even that was paid by us.
Oh,
even that was paid, and after that we sought registration.
You have disclosed that in your reply.
My lord, that was a part of my writ petition itself. My lord.
Yes, what do you say?
If I may,
Lordship, there has been, this is a changed brief for me, Lordship. I'll be very candid.
Pardon?
Lordship, this is a changed brief for me, Lordship. I'll be very
What happened is they presented the document for registration that was written initially.
Yes,
They
Lordship,
asked
I know that I am aware, Lordship. The only thing
give the refund.
Lordship, there is a certain dispute in regard to the name of the person who has given the refund, submitted the fine, I think. I'll just come back with
in the opposition.
Lordship, since I have been verbally informed about this, Lordship, can Lordship
If you
give
have
me
not
1
taken it
week's
in
time?
Ms. Punjab
Maulik.
Ms. Maulik, if you have not taken it in your opposition, cannot take it for the first time now.
Lordship, then I'll just come back on next Friday with the proper
Come back next
instruction.
Friday with some other matter. This
Lordship,
matter is disposed of right now.
Lordship, kindly gives me 1 week's time. I'll come back with the proper, because I'm being led by Mr. Oniban Ray, Lordship.
So what? No. I won't keep these matters pending unnecessarily. I'm refusing inclusion in the list every week. I'm being embarrassed before advocates. I don't want to be further embarrassed. In the one breath, you are asking for time in almost every matter. And in every matter, advocates are shouting at the top of their breath why I'm not taking mentioning before the Chief Justice, asking for release of the matter. This cannot go on together. I'm sorry. Court also has a limit. So I'll not grant any further time. An adjournment is sought by the respondents on the ground that certain further instructions are required to be taken by the state. Full stop. However, comma, due to long pendency of the matter, comma, such adjournment, such prayer for adjournment is refused. Full stop. The matter is taken up for hearing. Full stop. The grievance of the petitioners is that initially the petitioners placed a document for registration before the appropriate authorities and had made a query. Full stop. However, comma, subsequently the registration did not go through that time and the document was returned to the petitioners. Full stop. Next para. Although the petitioners did not apply, did not take necessary steps within the statutory 4 months, comma, within an extended period, comma, upon payment of the requisite fine, comma, the petitioners had sought for a refund of the excess amount deposited. Full stop. Next para. Subsequently, the registration actually took place when, comma, for abundant caution and in order to avoid unnecessary complications, comma, the petitioners deposited the entire stamp duty again. Full stop. However, comma, the amount of excess payment made by the petitioner was never refunded to the petitioners by the respondent authorities. Full stop. The writ petition merely seeks such refund. Full stop. In their opposition, comma, the respondent authorities have placed reliance on certain provisions of the relevant statutes, comma, without taking note of the fact that the petitioners had already sought extension and had deposited the fine for obtaining such extension. Full stop. Next para. Although it is hinted by learned counsel for the respondents on instruction, on oral instruction, comma, that there might be certain discrepancies regarding the name of the person depositing the amount and the one refunding the seeking refund of the same, comma, such point not having been taken in the opposition, comma, cannot be opened for the first time at hearing. Full stop. Next para. As the petitioner has annexed all relevant documents and have disclosed on oath their identity in the present writ petition, comma, there cannot be any hitch on such score for the respondents to refund the amount to the petitioners. Full stop. Accordingly, WPA 12864 of 2019 is allowed, comma, thereby directing which respondent should be directed. Either of you.
My lord, respondent number 2, my lord.
Directing respondent number 2, the Inspector General of Registration and Commissioner of Stamp Revenue, to ensure that the excess amount deposited by the petitioner as stamp duty be refunded to the petitioner, comma, positively within 3 weeks from this date. Full stop. No arrest to cause 3 weeks. Can such and such is accordingly disposed of as well.
I'm grateful, ma'am.
19.
19, yes.
Lordship, I am for the petitioner. This is restoration application. Matter was dismissed for default.
When
on
was it dismissed for default and when was the application?
January 2021, and we filed the restoration application November 2022.
Why the delay?
Lordship, actually during the pandemic period, Lordship.
21, 22?
Yes, Lordship.
Not during pandemic.
Yes, Lordship. 21, Lordship, that online.
After that, you got so much time.
When we inquired the matter.
Have you served copy on the other side?
Yes, Lordship. My affidavit of service is there.
Checked up, good service.
Yes, Lordship.
Since despite service, none appears for the respondents. Full stop. Since sufficient reasons have been given by the petitioner, comma, can 1 of 2022 is allowed, thereby recalling the order dated January 7, 2021, passed in WPA 11098 of 2020, and restoring the said writ petition to its original file and number. Full stop. The writ petition shall be listed in due course before the appropriate bench. No arrest to cost. এক্ষুনি লিস্টে দিতে হবে writ petition.
Petitioner, you are the
20.
Yes,
please,
Sabha.
Lordship.
Addition of party.
There is an application for addition of party, which is filed by us, but there's no affidavit which has been filed by my learned friends.
Lordship, where for the petitioner, actually, former senior has gone through
For
LS.
the petitioner,
For petition or for the writ petition?
Petition.
For the writ petition, Lordship, my senior has gone through LASIK surgery. That's why he has not briefed.
You were there.
No,
When did you
Lordship,
go for LASIK surgery?
last week, but due to some
You got
contingencies,
time before that also.
yeah, Lordship, we know. Lordship, praying for just 1 week's stay.
Refused. I'll take up the additional
Lordship,
part.
kindly.
No adjournment. Yes. Yes, what is the addition of, what is the writ petition for? What is the addition of party application?
My lord, in the addition of parties, I am told the advocate record has changed and the new Vokalatam has been filed by one Kartik.
I'll dismiss it for default.
My lord, I'm
No
not sure.
adjournment. No, sorry.
I'm not sure whether he's appearing for the same advocate.
No, I am appearing in, my lord, there are 2 applications for addition of party. I am appearing in Can 2 of 2022. I believe my learned.
Who is appearing in Can 1?
I'm told I'm in Can 1, my lord.
Oh,
Can 1 I'll dismiss for default, Can 2 I'll take up.
It's a change brief, my lord, kindly
No,
consider.
change brief, so that's not the problem of
I
the
don't
court.
have a copy of the.
No,
my
definitely
advocate is
not.
also here, my lord. Only for a day's time, my lord, I'm praying, my lord.
Can 2 Mr. Pagal dispose of immediately, either reject or allow, whatever way, and the other matters will go out of the list for the time being whenever they appear. Yes. What about Can 2?
My lord, Can 2, my lord, we are the applicants here. Your lordship, my lord, I'll very briefly indicate, my lord, what is our stand. Here, my lord, the case is with regard to your JN Ray Shishu Sheba Bhavan. This is actually a building, my lord. It's a building which has been now I'll indicate what is the writ petition and how they have come up. My lord, this they say was donated by the governor and it belonged to one Mrinmoy Roy. Mrinmoy Roy had two, my lord, had a son, adopted son, my lord, Tanmoy Mukherjee. Tanmoy Mukherjee and his wife Meenakshi Mukherjee are the main parties. They are not before your lordship. My lord, here there was a will. Tapan Mukherjee, I stand corrected, my lord. There was a will in 1977, 21st July 1977, where all the properties and, my lord, J.N. Rai nursery and hospital was, my lord, bequeathed to the son, Tapan Mukherjee, by, my lord, Mrinmoy Rai. Now, my lord, this was probated, the will
What was
probated.
it? A society, registered society?
It's actually a building. It's actually a building
So
from
it was
where
her own property. Her own property, she donated
her
to
own property. It's a building, my lord, and this is where, my lord, this hospital and nursery were being run from that property.
They were not registered somewhere.
No, my lord, that is our case. That, my lord, this
That's very
registration is also of a society which is of a similar name, but that society's property is not this building.
Very well. Then
now, my lord, there was a probate of this will on 9th of June 1978. My lord, the probate was granted in 1989. It was probate case. I'm not going into that details, my lord. Few doctors decided that they'll establish this society in 2011. But that is where the society was first registered in 2011 under the Societies Registration Act. And, my lord, it was registered in the same name, J.N. Roy Sishu Seva Bhavan. The name remained the same, but it's actually a building. And the name, they deliberately did this, my lord, so that there is a confusion created between the society and the property being the building, which is not a part of the society.
how are you related to the son who got the property?
My lord, we are not related to the son.
You are related to the hospital.
To the hospital, my lord. We are the ones who, there was a subsequent memorandum of understanding. My lord, I'll be very brief here. My lord, the hospital was being run. Hospital was being run. They were facing a loss in running the hospital. They could not run the hospital. It's a charitable hospital.
Is this your version of the matter?
It's my version of the
What is the writ about? First tell me that, then give your version.
My lord,
Yes, I'm hearing you, Mr. Bag. Please continue.
yes, my lord. The writ, my lord, the primary prayers in the writ is a declaration, my lord, that the respondents renew their registration. So the registration has come to an end. Their license to run the hospital has come to an end. Their case is that this license was in their favor and they are the ones who are authorized to run the hospital. Our case is you don't have any authority to run the hospital. There was a memorandum of understanding which was entered into between the, my lord, the doctors and the, my lord, management and us. We are, my lord, a separate entity. We are Shobhana Medical Foundation. It's a partnership firm, my lord, where the partners were involved in running, my lord, this hospital through a memorandum of understanding. That memorandum of understanding, we say, was for a period of 20 years. It was entered into by the hospital because they were struggling to remain operational.
Right.
That is our case. So, my lord, whatever be their reliefs that they are praying for,
why was it not renewed? It was previously running in their name only.
it was running in their name. They could not run the hospital. Hence, my lord, a memorandum of understanding. The memorandum
What's the
of
ground for
understanding,
refusal to renew?
my lord, their ground for refusal was that they, my lord, it's in relation to a trade license, which was not renewed.
So that is pertaining to them and the authorities.
Yes,
How are you interested as a party to this?
My lord, the reason,
Claim your rights before a civil court.
no, my lord, the reason would be because they have, my lord, indicated that this is a institution, the hospital is being run by them and not by us. We are the ones who are running the hospital, my lord. So we are interested in, my lord, the petition. Because today, if they say they are trying to usurp, my lord, the entire management. So we are definitely a necessary and a proper party in the proceeding. Let the writ petition be heard out.
No, no, you are not a necessary party. Why
Yes,
should
my
the
lord,
writ
we are.
petition
My
be
lord,
unnecessarily? Yes.
May I indicate, my lord, here the writ petition is only limited
Yes.
to, if your lordship takes up the writ petition, they have in paragraph 7, this is their main point. They, in paragraph 7, they say 2016, this honorable court was pleased to allow the society to operate for medical help of the society. 2022 paragraph 8, I'm reading page 4.
Please, yes.
My lord, 2022 petitioner applied successfully, uploading all documents and for renewal of certificate of registration from 1962 till date. I pause here, my lord. This is where if they want to renew, my lord, they are renewing their certificate of registration of the society. My lord, they are trying to confuse, my lord, between the building and the society. So, my lord, we are objecting to that renewal because that renewal in our very respectful submission cannot be granted. The reason being, if your lordship takes up, my lord, paragraph 10. This is actually the cause of action is paragraph 12, where the, my lord, 2016 order is what they're basing it on, saying that even after this order, you are not renewing our registration. The reason, my lord, they have not disclosed why this is not being renewed. According to us, the reason is because this society's registration, my lord, is bad in law. They could not have asked for registration in the first place. They have not submitted the documents which are necessary for registration in the first place, and now they are asking for a renewal. So there is where, my lord, our rights come in.
Will say, Mr. Bag, the authorities will say,
My lord,
you are setting up a conflicting right with them.
Yes, we are.
With the society.
We are.
Definitely you are entitled to, but this is not the forum for that. A writ petition has been filed. They allege that there is inaction on the part of the authorities in renewing their society. Even if it is renewed, even if you direct the authorities to renew, if I take it there,
Lordship,
even then your rights cannot be affected. And I'll observe that in my order today, that your rights cannot be affected in any event. Even if the authorities are directed to renew in their favor, that does not create any civil right in their favor. You have your civil rights, go before a civil court, restrain them from doing it.
We had,
and I may also observe in my order that this will be subject to whatever order is passed by a civil court, which it has to be.
My lord,
I'll not touch your rights. I cannot.
Only one document may I indicate to your lordship. My lord, page 22 of our petition.
Yes.
This is, my lord, our application under Right to Information Act on 21st of July 2022.
Right.
My lord, we requested, my lord, why this rejection? Because kindly see, my lord, paragraph 1 there. This is the information we had sought for. My lord, Jitendra Narayan Rai Society, Benefit Society having.
This is why their application was rejected.
Yes.
All right, let us see.
We wanted to know this, my lord. And in response is paragraph 24.
Page.
I am sorry, my lord. Page 24.
Right.
Application has been rejected. That's the first paragraph. Second paragraph. In the comment box, reason for rejection has been mentioned as matter is sub judice, a complaint received questioning the authenticity of the entity. This is our case, my lord.
This is not your complaint.
This is, my lord, our complaint.
You had complaint to the registering authorities also?
Yes, my lord. This is paragraph, my lord, page 22, your lordship would find.
No. Did you complain before the authorities? You never complained before the authorities.
My lord, Shubhrangshu Bhakto is, my lord, a part of the Lord, part of Shobhana Medical Foundation. That is, my lord, the applicants before your lordship.
No,
it is by us.
Who lodged the complaint?
We lodged the complaint.
Oh.
We lodged the complaint. That is why we are, my lord, submitting that today. If this is the reason, my lord, that matter is sub judice complaint received questioning.
This is what I was asking. What is the reason for the rejection?
This is the reason, my lord. This is the reason.
I'll add them.
I'm very
The rights should not be vindicated.
Lordship,
very grateful.
Yes.
Page number 29, first of all.
29?
Page number 29 of the writ petition, Lordship.
Right, 29 of the, yes.
That is the registration, what they've submitted. That was the registration. First, it was registered.
True.
After that, it was not registered and it was kept embossed for a long time. And we recently in 2022 applied for before the register for renewing for certain reasons they have rejected. On that ground, for JN Ray Benefit Society. The name of the society is Jitendra Narayan Ray Benefit Society.
No, they have, due to their complaint, it has not been renewed.
No, Lordship.
That is the answer given to them.
Yes, Milord.
These
That's page
RTI
24.
reply to them. You cannot have any direct knowledge of this at all. So then their necessary party on their complaint, your renewal
Lordship,
application.
they are not related with this society in any way.
You have not applied for renewal of Jitendra Narayan Ray Benefit Society.
We have applied for renewal for Jitendra Narayan Ray Benefit Society.
That's an admission.
And they have an memorandum of understanding with another society named Jitendra Narayan Ray Sishu Seva Bhavan Society.
That will decide in the writ petition. I'm not deciding the rights only for the purpose of adding them. They are necessary parties to the writ petition. Can 2 of 2022 is taken up for hearing. Next para. Although learned counsel for the writ petitioner prays for an extension of time to file opposition, comma, such prayer is refused, comma, since the matter is pending for quite some time and the direction was given previously. Next para. The writ petition has been filed challenging the refusal on the part of the respondent authorities to renew, comma, on the writ petitioner's application, comma, the license to the writ petitioners to run the concerned society, that is the Jitendra Narayan Ray Benefit Society. Next para. Learned counsel for the present applicant submits that the applicant, one applicant or several?
Milord, one applicant.
That the applicant is a necessary party, comma, as it
Applicant and partners, Milord. So, Milord, it's Shobhana Medical Foundation and
as it is the present applicant stroke its partners, comma, on whose objection, comma, the renewal of the registration was refused to the writ petitioner. Learned counsel for the applicant places reliance on a reply given by the concerned authorities under the Right to Information Act, comma, to queries made by the applicants, comma, dated July 25, 2022, comma, which disclosed that the reason for the rejection of renewal to the writ petitioners was that the matter is within double inverted sub judice, double inverted clause, and that a complaint has been received questioning the authenticity of the entity. Next para, it is argued that the applicant had lodged the complaint through its partners, comma, due to which the renewal was refused. As such, comma, being the complainant, comma, the petitioner is a necessary party to the writ petition. Next para. The application for addition has not been filed in the present case, comma, merely to canvass the rights of the applicant vis-a-vis the writ petitioners, but also to raise a challenge to the renewal, comma, which has been sought by the writ petitioner in the present writ petition. Next para. Hence, comma, upon hearing parties, comma, it transpires that, comma, in the capacity of a complainant, comma, the applicant in the application for addition of party is undoubtedly a necessary party and is required to be heard in the writ petition, comma, for the purpose of ascertaining the scope and veracity of the claims of the writ petitioner regarding renewal of the writ petitioner's application for license. Next para. Hence, can 2 of 2022 is allowed, comma, thereby impleading the applicants therein as parties to the writ petition. The office shall carry out the necessary consequential corrections to the cause title of the writ petition within a fortnight from date and place the writ petition, comma, along with the connected pending application, that is can 1 of 2022, comma, for hearing before this bench. full stop, no orders to cause urgent certificates. Can 2 have allowed? They'll be implemented. Office will carry out the necessary corrections.
Can one
Can 1 remains pending? It will appear along with the writ petition whenever it appears.
I'm deeply obliged, my lord. Deeply
Actor line should add the 1 line I'll add Mr. Bag to allay his apprehension. It is made clear that the merits of the respective contentions of the parties in the addition of party application regarding the concerned rights of the parties to the entity in question have not been gone into by this court, and it will be open to be decided at the time of hearing the final hearing of the writ petition.
I'm very deeply obliged. Very deeply.
21.
Yes.
In this matter, my lord, I'm appearing for the distribution company.
I appear for the applicant, my lord. It's my application for recalling of this order passed by your lordship.
Recalling in the nature of a review or what?
No. Since, my lord, this order was obtained with a bad hands, my lord. They have forged document, entered before this court and obtained this order, my lord. This thing was done in the trial court also in the civil suit where 340 proceeding was
Would you
initiated.
like to use an opposition to this?
No, my lord, I am appearing for the distribution company who have given the connection, my lord, in terms of your lordship's order dated 6th of July 2022, my
Lord, I am for the writ petitioner.
No, your allegation is against the writ petitioner.
Yes, yes.
Yes. Do you want to use any opposition to this?
Lord, I can. Lord, before that, Lord, the order which sought to be recalled here, Lord, this writ petition became infructuous in view of the fact, Lord, in subsequent writ petition, I obtained the electric connection. Lord, the same documents were placed.
So let me hear them first then.
This writ petition,
If you don't want to use an opposition, I'll hear it out and dispose it of yes.
this writ petition, they have came up before for electric connection, wherein my lord has directed them to apply for new connection and act accordingly, my lord. Kindly comes to page 83, my lord. Hence, WPA is disposed of by granting liberty to the petitioner to apply for new electric connection in the name of petitioner before the WPA, and it was disposed of. My question is, or I am not on this issue, my lord.
Yes.
I am not on this writ petition. They have filed, my lord. My kindly comes to page 39. Is the annexure
Page 39 of
this application, my lord. These document 39 and 40, these two documents, 39 and 40, these trade license and 40, this agreement, these two documents are forged, and seeing this forged document in the court of record, this order was obtained, my lord. But kindly see the original document, but kindly comes to page 81, my lord. Page 81. Kindly sees, my lord, page 81. It relates to 81 where 2017-2018. This was blank. Thereafter provisional. This was also blank. They put papers there and make it Xerox, my lord. This was a thing done by them, the writ petitioner. Now, my lord, kindly comes to the agreement. That is page 42. Page 42, second paragraph.
Yes.
This is a handwritten doc, page 42, second paragraph. This is a handwritten portion, my lord. Now, my lord, kindly comes to the original document, which starts at 73.
Give me half a minute.
এটাই তো না কোনটা 75, my lord. There is nothing, my lord.
18 to 21. I can 23.
But this is a court of record. They are making illegal documents here and obtaining order. This writ petition was disposed of ultimately. 340 proceedings should be initiated, my lord, for this, my lord. I am not on the issue of electric connection or not, my lord. But a document which is illegal, which is mala fide procured by them, and they are obtained this order, my lord.
There is no scope of recalling the order.
But let 340 proceeding be initiated against the writ petitioner. This is a court of record, my lord.
Yes, what do you say?
Lord, regarding Lord the page 42, page 42, Lord, this was renewed by inserting the Lord the year date.
No,
this was renewed, Lord.
Never.
And Lord, I had the intention, then it could have been erased. Lord, that was not done, Lord. Even Lord, it was Lord.
the notarized and the document was placed before the learned civil court, before this honorable.
Same thing was done in civil court, 340 proceedings
And
pending there.
the honorable, the learned civil court also directed them there and the electricity board to restore the connection. They disconnected, but they did not. Then, Lord, I approached before this honorable court by filing the first writ petition. And regarding, Lord, the electric board has effected connection in pursuance, Lord, the second writ petition. Lord, kindly see the second order.
No, what about page 39? Page 39 verses 81. Provisional and all these were omitted.
Nice to do.
Yes, what was the second writ petition? What happened there?
Lord, these are the order, Lord. The second writ petition.
What happened? Tell me. Yes.
Lord, in connection with the second writ petition, Lord, the electric board, Lord, the effective connection in my premises.
What was the occasion of the second writ petition after this?
Yes. Lord, after disposal of the first writ petition, I applied for the new connection and all the documents were placed before the board and the board refused the connection only on the ground they resisted. And no objection is required. That is why board asked me to obtain the no objection. And on that ground, Lord, the second writ petition was allowed, setting aside the order. Lord,
Yes, Mr. Bhattacharya, I'll give you liberty to proceed with the 340 before.
Already 156 proceeding in
the bearing with the no question of recalling that.
Well, I'm not pressing on recalling.
Application is for
But I am only praying. Kindly comes to a prayer, my lord.
Yes.
And initiate proceeding under 340, my lord.
FIR করেছেন নাকি?
না, এটা আগে FIR ছিল। On this same ground, you've already lodged FIR 156.
Your prayer in this application is for recalling only.
And my kindly comes to and initiate proceeding under 340.
340, I'll give you liberty to proceed with the trial court. We don't have the infrastructure to go into these factual assessments. No. What is your reply to this? Page 39, I'll only hear that. 79 verses 81.
Yes,
you have to have a good reason for that. How do you explain this? Yes.
But something is missing at page 39. If it is tallied with the page 82, that
obviously,
is,
yes.
This is apparent on the face of record, Lord.
So why not 340 on this? Where did you obtain this page 81 document?
This is with us, my lord. This is with us.
The original. How did you obtain this?
Yes. It's from municipality, my lord.
Right.
Yes. This expired in 2017-2018. This is with us, my lord.
Learned counsel for the petitioner has sought for a recall of the order dated July 6, 2022, passed in WPA 12911 of 2022, as well as for initiation of a proceeding under 340 of the Criminal Procedure Code on the allegation that the writ petitioner produced certain documents in court, which were forged. First up, by comparing between the annexures at pages 39 and 81 of the present application, it is argued that whereas the applicant obtained the page 81 document from the concerned municipality, the one annexed at page 39 was annexed to the writ petition by the writ petitioner, conspicuously, several digits and words are missing in the copy produced by the writ petitioner. comma, for example, the word within double inverted provisional, double inverted close, comma, double inverted with the 2017-2018, double inverted close, and the year 2018 at the bottom of the certificate. For sub next para, it is further alleged that the writ petitioner also annexed the document, comma, which is purportedly a deed, comma, in the internal page 3 of which at page 42 of the application, comma, certain insertions by hand appear, comma, which are absent from the original copy of the same annexed at page 75 of the present application. Full stop. On such grounds, comma, it is argued that the relief sought in the application be granted. Full stop. Next para, learned counsel for the respondent hands over a copy of a subsequent order dated August 3, 2022 and contends that the order passed in WPA 12911 of 2022 has in any event been rendered infructuous, comma, since by the said order, comma, liberty was given to the writ petitioner to apply for electricity connection. Full stop, the same having been applied for, comma, could not be given due to obstruction by the present applicant, comma, for which the writ petitioner obtained the order dated August 3, 2022, passed in WPA 16770 of 2022, comma, directing the WBACTCL to give such connection. Full stop, hence, comma, it is argued that there is no scope of recalling the order passed in WPA 12911 of 2022. Full stop, next para. Insofar as the prayer for recall is concerned, comma, learned counsel for the writ petitioner stroke present respondent, comma, is perfectly justified in controverting the same, comma, since the alleged forgeries, comma, even if correct, comma, did not have any material bearing on the outcome of the writ petition, comma, since even with or without the insertions in question, comma, the order would have been similar to as was passed at the original juncture. Full stop, next para, that apart, comma, since subsequently the order passed in WPA 12911 of 2022 has merged in the order dated August 3, 2022, passed in WPA 16770 of 2022, comma, there is no scope of recall of the order as sought for. Full stop. However, comma, on the question of forgery under section 340 of the Criminal Procedure Code, comma, the present applicant has made out a prima facie case. Full stop. It is also submitted that a similar allegation has been lodged before the concerned civil court, where the same documents were produced by the writ petitioner stroke present respondents. Full stop. Hence, comma, the application is required to be heard on the limited question as to whether appropriate orders ought to be passed under section 340 of the Criminal Procedure Code, comma, read with section 195 of the said code. Full stop. Next para. In the light of the above observations, comma, the respondents shall file their affidavits in which respondents? Only 5 and 6.
The writ petitioner respondent number.
Right. The writ petitioner stroke present respondent numbers 5 and 6 shall file their affidavit in opposition to Can 1 of 2023 within 3 weeks from date, comma, inter alia disclosing and explaining the discrepancies in the documents as indicated above. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The matter shall be listed in the monthly list of November 2023 for hearing for the purpose of ascertaining whether proceedings under section 340 of the CRPC shall be initiated.
That should be respondent number 7 of the Can. Brand Street was the writ petitioner.
Only 7?
My lord.
তাহলে যেখানটা বাকি সব ঠিক আছে, writ petitioner stroke present respondent number 7, 5 and 6. Thank you.
Grateful.
Come up on November.
After 10 minutes. Sir.
Number 6.
I'll come back on from No, I'll be coming after 2 weeks.
This matter.
Oh, this matter will be coming back in November monthly, after puja vacation. So enjoy your puja. After that, his client will be in somewhere else. I'll come back in 10 minutes for the next matter.
22.
Lordship, I'm for the petitioner, Lordship.
Yes.
Pursuant to your order dated, Lordship, 23rd March 2023.
Right.
Can 1 is a restoration application that has been allowed. And can 2 is, your Lordship, that day direct me to act as party respondent, necessary party, Lordship. I had taken an application which on can 2. Lordship, kindly allow this application and
Well, I am appearing for the WBACDCL. As my lord, WBACDCL is not a necessary party, my lord. My lord, kindly.
So I'll delete your name.
Yes, my lord.
Learned counsel for the applicant submits that the Power Grid Corporation of India Limited and not the WBACDCL is the necessary party in the writ petition, comma, since the reliefs substantially claimed are primarily to be directed towards the Power Grid Corporation, full stop, next para. Accordingly, can 2 of 2023 is allowed, comma, thereby impleading the Power Grid Corporation of India Limited as a respondent to the writ petition, full stop. The learned advocate on record for the petitioner shall carry out the necessary consequential amendment to the cause title of the writ petition.
I filed an application on this regard, Lordship. That is can 2.
I'm allowing that.
Oh, Lordship.
Please carry out the necessary
Lordship,
correction in the cause
Lordship.
title of the writ petition.
Lordship.
In the cause title of the writ petition during the course of the day, full stop, next para. You delete the name of the WBACDCL then. Do you have any relief against? So who should be deleted? Tell me.
9.
1 to 5.
My lord.
1 to 5.
Yes, my lord. WBACDCL is not a necessary party, my lord.
No, 3 to 5. Accordingly, respondent numbers.
3, 4, and 5.
No, not even 3.
4,
4 and 5. only.
subdivisional, 4 in BDO, 4 is
Accordingly,
additional.
deleting respondent numbers 4 and 5 from the cause title of the writ petition as well. Are deleted as respondents from the cause title of the writ petition as well. Full stop. Leave is granted to the learned advocate on record for the petitioner to carry out corrections to the cause title of the writ petition on such score as well. Score through 4 and 5, add them as party, Power Grid Corporation as party, just sign, say as per leave of court.
My petition 4 is my lord BDO, Block Development
4
Officer.
is not you.
5, my lord Regional Officer, Manager, West Bengal Electricity Distribution Company, my lord.
Only 5 has been deleted, Lordship.
Oh, acha.
Only 5.
Oh, I was looking at the application. Tell respondent numbers 4 and 5 na kore, respondent of 5 should've kore. Rest remains the same. Thank you.
Get my lord.
Next.
23.
Well, on the last occasion, your lordship has already directed that the writ petition will be heard out and the application may appear along with the main writ petition. I think, my lord, this
application heading is
Perhaps, my lord, the application can be disposed of.
No, your lord, that
if
is
there's a direction, the writ petition has to be heard along with it. The writ petition was directed by the previous order to be listed for hearing along with the application, but is erroneously appearing under the heading application, full stop. Accordingly, let the writ petition be listed under the heading upgraded matters in the list on September 25, 2023, along with the pending application.
My lord, my learned senior, Mr. Ratnako Banerjee is not there on 25th September, my lord.
only one thing, my lord, it is may not appear as upgraded matter because your lordship has noted this NCLAT proceeding is pending.
Oh, I'm sorry. Then not as an upgraded matter.
The monthly list of October, my lord, your lordship.
Very well. তাহলে এটা কেটে দিন যে অর্ডারটা বললাম আমি আরেকটা দিচ্ছি It is rightly pointed out by learned counsel for the writ petitioner that the matter is erroneously appearing under the heading application, comma, since the writ petition itself was directed to be heard along with the pending application, full stop. Hence, comma, let the matter be listed for hearing in the monthly list of October 2023 along with the pending application.
Right.
Thank you. Thank you. এটা এমনি হেডিং আসবে
24.
My lord, this is my application for recalling of your lordship's order. I am a new entrant in this matter, but it is entirely because I, first of all, I apologize because when your lordship passed the order, The
Yes.
council then engaged, they were engaged in other courts, could not appear before your lordship and could not point out the fact. May I just hand over, order is not annexed. May I just hand over a copy of the order?
Yes.
This is regarding removal of direction upon the registrar to remove the name, to comply with the provisions of the act, to remove the name of my client as director of the company. Your lordship, in the second paragraph, has observed, since the present writ petition is not adversarial as such, I am saying that it was our duty to point out. We could not point out in the writ petition itself. My application for application, I have filed an application before NCLT praying for an order not to remove me as a director. That is pending. It is hotly contested. Kindly see, they have admitted. I have annexed the writ petition without annexure. Kindly come to.
Yes, who is appearing for the?
Kindly come to paragraph 21, just for a second. Page 18 of my application. I have got, this is a paragraph 21 of the writ petition.
Yes. Yes.
Upon due response. No, I'm sorry.
Para?
I have just indicated the parameter. Just a second. They have admitted. They have stated. Just give me a second, my.
Yes.
Yes, para 27. Rekha Ginodia, my client, had also filed an application being CP number such and such under section 241 and 242 of the Companies Act 2013, challenging her removal as a director. Now, I could not get an interim order, next para, and then I filed an appeal. I could not succeed in the appeal, but my application is pending. 242, I have a right to apply under Companies Act, that is pending. So pending this, my lord, the direction upon the registrar may be, in my respectful submission, premature. At least they should wait for whatever the outcome, good, bad, indifferent. I filed an application. This is my submission.
Yes, you are for the writ petitioner.
Yes, your lordship, I'm
What do you say?
opposing.
Yes.
Your lordship, the private respondent was removed by an extraordinary general meeting. They have challenged this general meeting in the NCLT by filing a petition. Your lordship, they failed to obtain any ad interim order of injunction either in the NCLT or the NCLAT. Your lordship, even in the appeal, there was no. So, your lordship, today, as on date, the private respondent stands removed from the board of directors since the EOGM has not been interfered with. Your lordship, my only prayer today is that your lordship, may I only point out what is the law with respect to removal of directors. If your lordship may kindly take up Rule 11 of Companies Registration Offices and Fees, Rules 2014. Your lordship, may I just hand it over? Please. Your lordship, I do not think it will be there in the.
I don't think so. No. Yes.
Lordship, this rule provides that once a DIR 12 has been filed with the registrar, your lordship, he will have to take a call whether he has to, if it is in accordance with law, he'll have to allow it. And if he is of the opinion that it is not in accordance with law, then he'll have to refer it to the regional director. And the regional director will then have to take notice of it. I have to take a call on it within 90 days. So, your lordship, today, since there is no stay from any competent authority removing her, staying her removal, your lordship, in terms of Rule 11, lordship, the ROC will have to act on it. And your lordship, they have tried their luck before each and every forum. Your lordship, they have lost in
the scope of sections 241 and 242 ones.
Yes, your lordship.
We'll have a look 242.
What happens if they win in that application under section 241? It can be reversed again.
Yes, your lordship, she'll remain as a director, but only if she wins.
I was just going through the section. Just
yes.
42, your lordship will see.
Yes.
42 subsection 2.
If he wins, he has to apply again
manager or any director.
That's by operation of law.
Now, I was just thinking, my lord, that so this is, you can remove. If the power of removal is there under section 21 of the General Clauses Act, the power to set aside removal. That is my application. So I am only saying.
So this will be subject to that, and that adverse. Adversarial fact, adversarial
No, I'm not saying, I'm
Yes.
trying to protect me to that extent, my application that,
need
Your
not be
Lordship,
recalled
may I-
for that. No,
Recalling
no.
whom?
no, I'm not saying recalling my.
Whatever right you have in law, you have. Well, in my reasonings, I can give this, that
Yes,
if they
fine,
win
fine,
there,
fine,
in any event, they, yes.
Yes,
Your Lordship,
that's only thing.
Yes.
so may I only indicate, today, suppose your Lordship, they win in the 241, 240, then the NCLT will direct the ROC to include their name.
Exactly.
But today, your Lordship, I have a suit filed wherein, your Lordship, my specific case is that they, on the basis of this master data, your Lordship, that is also annexed.
Yes.
On the basis of this master data, your Lordship, they are going on representing to the third parties, that is my business associates, that she's still in the company
No,
and
no,
is appropriating money.
This order remains. The order which I passed, that remains. This
Lordship,
will be subject to whatever orders they obtain.
your Lordship, Lordship, subject to correction, that will again lead to a confusion, and my learned friend's client will again use this. Your Lordship, if today, your Lordship, there is no stay and she's been validly removed and her removal has not been interfered with by any competent court, your Lordship, she ought not to be reflected as a director in the master data. Now, your Lordship, what my learned friend is doing is basically, your Lordship, showing this master data, she's misrepresenting to the third parties.
That. That is
Lordship, there's a suit filed, injunction order against them. Lordship, they're in violation of
that suit has been filed by you on the allegation that they're misusing, they're not, their name is not there, but they're still.
Yes, your
But
Lordship.
that will also be subject to 241, 242.
Yes, your Lordship, but subject to what happens. But your Lordship will kindly
Subject
appreciate
to what
today.
happens, everything is subject to 241 and 242. If they get
Lordship.
a favorable order there, the suit goes, this also goes.
Your Lordship, then there will be a direction by the NCLT to.
Has to be.
So, your Lordship, till as on date, your Lordship, she's not a director.
No.
Then, your Lordship, then her name should not reflect in the master data.
No, that's why the order remains.
Lordship, that is what I am seeking. But your Lordship may kindly not add a caveat which creates further confusion.
No, I will do that. So that it creates further complications for the court to have some business. Learned counsel, Mr. Banerjee, won't open your mouth. You are for
No,
the
no, I am, my lord, I am for the ROC.
ROC, yes.
So I will comply with whatever my lord says.
So meek and timid of you, Mr. Banerjee, unlike your usual persona.
Sometimes, my lord, I must
You
agree
have
to what my
yes.
lord is.
The learned counsel for the applicant submits that it was erroneously recorded in the order dated August 16, 2023, passed in WPA 3901 of 2023.
I did not submit erroneous. I did not submit my.
It was erroneously কথাটা বাদ দিয়ে বাকিটা continue করুন. That the writ petition was not adversarial. So it is further pointed out that in the writ petition itself, in paragraph number 27, it was mentioned that the present applicant Rekha Ginodia had filed an application being CP number 43/KB/2022 under sections 241 and 242 of the Companies Act 2013, challenging her removal as director of the petitioner number 1 before the NCLT, Kolkata bench. It is submitted that the order of removal ought to have waited till the decision, whichever way, arrived at in the pending application of the applicant. Next parallel counsel for the writ petitioner submits that in any event, a suit has also been filed by the writ petitioner against the applicant, where the writ petitioner has obtained an injunction, thereby alleging that the applicant is misusing the retention of her name in the register, despite the law being that her name ought to have been removed by now. Next para. As such, the order dated August 16, 2023, it is submitted, need not be recalled, having been passed in accordance with law. Learned counsel for the writ petitioner also places reliance on Rule 11 of the companies within bracket registration offices and fees bracket closed rules, 2014. Next para. A perusal of the said rule indicates that if the registrar, on verification of documents finds that the company has violated any of the provisions of the act or rules, he shall refer the matter to the regional director concerned, who shall inquire the matter by giving opportunity to the person who has been removed or vacated as director and convey the decision of the matter to the registrar within 90 days from the date of reference to him by the registrar. Full stop. When the order dated August 16, 2023 was passed, comma, the said time frame had already expired and, comma, as such, comma, it was the incumbent duty of the registrar of companies, comma, in any event, comma, to remove the name of the applicant. Full stop. Next para. Hence, comma, irrespective of the pendency of an application under sections 241 and 242 of the Companies Act 2013, comma, there is no infirmity in the order dated August 16, 2023 in any manner. Full stop. Next para. Insofar as it was recorded that the writ petition was not adversarial as such, comma, the same also, comma, since the fact that by operation of Rule 11 of the 2014 rules, comma, the name of the petitioner was to be removed, comma, could not have been in contention therein. Full stop. Next para. The limited context of the present application is the pendency of the applicant's challenge under sections 241 and 242 of the 2013 Act. Full stop. Next para. In any event, comma, it will always be open to the applicant, comma, if favored with an order in the said proceeding, comma, to take appropriate consequential steps before the appropriate forum. Full stop. Next para. Hence, comma, there is no scope of recalling the order dated August 16, 2023. Full stop. Accordingly, can such and such, can one or two, can ja ache numberta is dismissed in the light of the above observations without any orders to cost.
Your Lordship, since no affidavit has been called for.
Since no affidavits have been invited, comma, it is made clear that the allegations made in the applications are deemed to be denied by the respondents.
Only
Grateful,
one
Your Lordship.
interference with the last order should be done, my lord. As I pointed out on the last day for Mr. Tiwari to earn his bread on that day, my lord. That should
Date.
be yes, my lord, the correction of the name.
Yes, Mr. Tewari, please write it on a piece of paper.
Yes.
Take the trouble to do that. It will not be repeated.
That is the only submission I have. Grateful.
Grateful, Your Lordship.
25. Yes.
My lord, I am appearing for election to India, my lord.
Yes. Why online?
My lord, I am having suffering from back pain, my lord. I am under treatment, my lord.
Very well. Hope you recover early.
My lord, I have recovered, but sometimes it is
Definitely.
traveling, my lord.
Who is for the petitioner?
My lord, it is the application, my lord, moved by the election commission, state election commission.
Right.
My lord, it is with regard to that issue, my lord, whether the assistant professor can be drafted in the
Oh, that,
election
right.
duty without assigning any reason. My lord, what?
Oh,
happened-
that the central rules were taken note of.
Yes, central rules have taken
You've
note.
got a point there. Who is appealing for the writ petitioner?
Writ petitioner, my lord, the earlier order, we are trying to serve upon the learned advocate, my lord, he is the difficulty, my lord, on instruction. My lord, he is avoiding the service. That
Sub
is,
directly.
then the
Sub directly
petition.
come back on 20. This is an application.
Yes, my lord, application for recall.
So come back on 29th, which is the next application date when I'll be sitting. I'll
29th.
direct you to serve copies. I'll record something in my order. You are for the
In this matter, Mr. Shishona Bandyopadhyay appearing in behalf of state, my lord.
learned counsel for the applicant has raised a valid question as to whether the order dated August 18, 2023 passed in WPA 14861 of 2023 ought to be recalled, comma, since the court apparently proceeded on the premise of rules governing the Election Commission of India, comma, to adjudicate an issue which referred not to the Election Commission of India, but to the State Election Commission, comma, which operate on the basis of different legal frameworks. Full stop. Next para. Since such a prima facie case has been made out for hearing of the application on merits, the applicants shall serve copies of the application on the. You have obtained a copy.
I have not, still now I have not.
On the respondents, indicating that the matter shall be listed on September 29, 2023. An affidavit of service shall be filed by the petitioner on such date.
I'm grateful, Your Lordship.
I'm grateful, my lord.
Thank you, Mr. Chairman.
I'm grateful, my.
Next.
Top matter.
Item 26.
Respondent number 12. My lord, in compliance of your lordship direction, we have filed an affidavit, my lord. Of course, very rightly cost was imposed, but anyway, that has also been paid.
You came in after the costs were imposed.
No, just ask me what he left, go and put the cost.
Lordship,
Reply, yes.
Lordship, I am for the petitioner. What has happened is in the meantime, the advocate on record of the
Yes.
petitioner
Yes.
has given a no objection yesterday. So therefore, I am not prepared about the matter. If a fortnight,
Would you like to use a reply?
yes, I'll appear in the matter as a counsel.
I'll
And
adjourn
I'll
for
give my
2 weeks.
reply.
I'll give time for two weeks to file reply.
As your lordship, the only thing is this, my lord.
Yes.
Today, I don't know why the archaeological department is absent here. My lord, the articles which are lying over there, because my client is not expert. His intention is to set up a very nice museum, judicial museum, and the then Chief Justice, my lord, he agreed to that and agreed to allot a land near it, New Secretariat anyway. So he started collecting some articles, of course, being authorized. He may say he's not authorized. So he got some informations that was some articles lying over there. So he visited that place. There's a correspondence between the persons who has kept there and my client. Initially, they agreed very well to that, but there is some problem that, well, he apprehended, he's not an expert, there is some fake thing, huge quantity of. So my Lord Justice Moshe was very right. My authority to move the writ application, that was also taken, that was raised. But Justice Bhattacharya observed, no, there is public, because the very valuable articles are there for national interest. I must look into this. So he passed an order. He directed the archaeological department to inquire and to ascertain what is that. So my lord, that's why my lord, I don't know why they are not here.
They're online.
Are
Are you
online.
suffering any interim order, Mr. Banerjee?
Me?
Yes.
My lord,
Is there any interim order against you, your client?
it wasn't like, na.
I don't think so, because the question raised by them was that this person is an agriculturist. He collects these items and forcibly you forcibly seized.
From the agricultural field.
Let us not be sarcastic.
Let
That
me
Mr.
get prepared
Banerjee,
with the
some
matter.
people are there who are engaged in cultivation, but I've met some of them also. I mean, they are very interested in these things and they have some acumen more than us,
I
more
appreciate,
than me at least. Yes.
no, I appreciate my lord, but the
Yes.
question is the number is such.
No, an allegation has been filed before a court of law, Mr. Banerjee. We have to go into the. If you
Of course,
forcibly
my-
seized,
No, of
then
course.
adequate compensation has to be given.
Of course, my lord. So,
If there is no, if you set up your museum and whatever, there is no hindrance to that. But
no,
the scope of this is only whether you took those by force or not from this person. If there are historical, because I have also recorded in my order, Justice Bhattacharya also probably recorded certain antique pieces, that is an admitted position, antique pieces and artifacts and materials of historical value. So those have public importance, no doubt on that. So you do whatever, Mr. Manager, just extend the time for filing replies.
no problem. Let him come with a reply.
Learned counsel for the petitioner submits that a change has been obtained from the erstwhile learned advocate, and as such, comma, the time for filing reply be extended. Full stop. You filed the opposition today.
Yes, we filed it today.
The affidavit in opposition filed today by respondent number 12 be kept on record. Full stop.
Two opposition, two sets.
One to the main writ petition and one to the sub.
Very well. The
And
affidavits.
cost, kind of record cost is also deposited. No, my lord. Court's order we must obey.
Affidavits in opposition filed by the respondent number 12 today be kept on record. Full stop. Since the costs are submitted to have been duly deposited as well, comma, the time for filing reply is extended for till September 29, 2023, when the application shall be listed, when the matter shall be listed next for hearing.
My lord, I don't know what is the reaction of the learned counsel appearing in the Basco. I'm sorry, I mean, virtual. He's appearing, my lord. I don't know what is his stand.
Your Lordship, we have filed our report. The direction was limited to filing of a report, whether on the last date I had made a submission, whether the articles are genuine or not, the archaeological department has not gone into, because separate tests have to be taken. And those numbers are in 1500.
Report you have filed already?
Your Lordship, on the last date it has been filed.
Consider.
Yes. One copy may be served on us so that we can understand what.
Right for a copy, they'll serve you. Yes.
Chalo. And in the meantime, sorry.
No, usual question.
But since there is no order to ascertain whether it is fake or some articles are fake, as he says, let them a direction, let them ascertain whether it is fake or not. unless the direction.
Your Lordship, that would take a lot of money and time for the archaeological department, whether the going into the genuinity of the articles.
Consider that, yes.
May I leave, my lord? May I leave, my lord?
Yes, Mr. Banerjee.
I'm good.
27. My lord, I'm pleading for the petitioner.
Yes.
My lord, the matter has been resolved, my lord. The prayer of the petitioner has been readdressed to the Aadhaar card authorities and it
has been
readdressed.
resolved.
My
Yes,
lord.
my lord, I have also got that instruction.
Yes, yes. What are you doing, these appointments and all this? Yes. Learned counsel for the petitioner submits that the matter has been resolved in the meantime. So accordingly, WPA 9471 of 2023 is disposed of as infructuous without any orders to cost.
Grateful, my
My lord.
Yes.
$28.
20.
Lord, I appear for the petitioner. My lord, the petitioner before your lordship.
Service.
My lord, at the very first instance, may I indicate that except for the two private respondents, everybody has been served. The private respondents' addresses, etc., are not available to us at all.
Can we pass an effective order without them?
Probably, my lord,
I
not.
don't think so.
Probably
because
not.
What is the nature of the allegation?
The allegation is the petitioner before your lordship is a volleyball player and quite accomplished. She has represented India even at international level, national level, and has, my lord, been able to secure medals and ranks.
What the
Now,
private respondents?
private respondents, my lord, are two persons who have been selected in the team which would represent the volleyball team of India in
The
Asian
number
Games.
of the contingent is limited.
Yes.
Oh, then if this person is selected, then the others go.
That is the difficulty. But my lord, we have no my lord, means to serve on them because we do not, because my lord, we have served on the respondent federations who must be aware of their whereabouts. My lord, if your lordship so pleases, it can be
Are there
directed
even
that
parties here? Which respond numbers? Which are the respond numbers? Yes.
no, my lord, they have not been made a party though.
Then implead them. You should have asked for an address in writing from the authorities that their
Yeah,
organization.
my lord, my lord, there was a complete haste on the part of the petitioner also. My lord, may I do it, my lord, today?
During the course of the day, do you know their addresses?
No, my lord. The Volleyball Federation of India, my
I'll
lord.
give you a 1 week's time. I'll give you liberty to correct the amend the cost title, implead them, and serve copies on them. Can you do that implead? Maybe you have to write to the organization and get their addresses first.
Organization के साथ
Yes.
आशे नहीं क्यों तो my lord, I'll
I'm on behalf of the respondent number 1 and 2, and I'm seeking leave from your lordship to join through virtual mode.
Mr. Nundi, no, Secretary Sports Minister of Youth Affairs, they
But
can.
we do not have any role to play here because the Indian Olympic associations were formed an ad hoc committee. But
Yes.
they are looking after this selection procedure, selections of men's and women's team for Asian, entering Asian.
You're right, Mr. Nundi, yes. So you cannot furnish the addresses also.
Lord, let me write to them.
It transpires, act order. It transpires from the nature of the challenge that the persons who were already selected, comma, by the process which has been challenged by the petitioner, comma, are also required to be implemented as party respondents. Full stop, next para. Learned counsel for the petitioner submits that the petitioner could not, comma, despite her best efforts, comma, obtain the addresses of the said persons. Full stop, next para. However, comma, it is submitted fairly that the petitioner shall make endeavor to have obtain such addresses from the appropriate associations concerned. Full stop, next para. To enable the petitioner to implead the said persons, comma, the matter is adjourned till September 29, 2023. Full stop. No, in the meantime, I'll give you these liberties.
My lord, the only difficulty is the last cutoff date is 23rd because that is the date on which the game starts. Before that, everything needs to be done if at all. Lord. Association has not replied to us.
What is the interim relief you have sought?
Not
you have asked for reconsideration of yourself.
Yes, and my lord, to transmit before this honorable court, my lord, all the papers which form the basis of selection, my lord, because nothing has been disclosed to us. We have also asked for that, and we have also asked for staying of all process pursuant to publication of the notification concerned. Lord,
the last sentence ki bolam Meghna? না এই লাস্ট সেন্টেন্সটা শুধু কেটে নিন, ইন অর্ডার টু থেকে কেটে দিন, তার আগে পর্যন্ত যা আছে আছে। Next para. Since this bench will not be available for the coming fortnight, comma, due to the circuit bench at Jalpaiguri, comma, leave is granted to the petitioner to mention the matter for obtaining interim orders before the bench having determination in the meantime, and to take appropriate steps in the meantime to obtain the addresses for the purpose of implement of the persons as indicated above. Take that, yes.
Just Millard, I have been told, Millard, though she is not briefed in the matter, she has been sent by the concerned respondent, ad hoc committee, Volleyball Federation of India, who will be knowing everything.
Take the addresses from her, do it tomorrow, and mention it before the appropriate bench on Monday. Otherwise, the entire thing will become infructuous.
Yes, Millard.
Don't let her leave the court before getting the address. Yes,
I will.
Next one.
Gratefully.
Thank you. Yes, thank you, Mr. Nandi. Yes. Next.
29. My lord, I am for the petitioner.
Yes. Yes, move your mat.
My lord, the last occasion, my learned friend submitted 2 documents. It is regarding the tender of the maintenance of medical equipments for entire West Bengal except 42 super specialty hospitals.
Right.
My learned friend has produced 2 documents regarding the pre-bid meeting.
Regarding the
Pre-bid.
pre-bid, yes.
Pre-bid meeting. My lord.
Yes. Now it will be post-bid, yes.
Now, my lord, Mr. Chaudhuri, my lord, on the last occasion said, and my lord has sought to give an impression to your lordships that, my lord, that it is my client who has made the suggestion, and it is the same person.
Yes, yes, this is the matter you are on the verge of committing suicide because he submitted something. Yes. Yes, yes. That you had made a wrong statement or something like you took it upon yourself. He did not say so. Yes.
Yes.
You said you would not be appearing in the matter if he.
No, Millard, if I find
he was wrong then.
He was not properly instructed at that point.
Oh, I see. Yes. What is the proper instruction, Mr. Vasu?
No, Millard. Kindly sees, Millard, that the suggestion that we have made, Millard, in the pre-bid meeting. Suggestion the pre-bid meeting, Millard, first of all, Millard, 3 dates.
Yes.
Millard, May 2023, Millard, is the first date of tender. There is the original tender. Amendment came, Millard, on 3rd August 2023. And Millard, the pre-bid meeting, Millard, held in between, Millard.
Please repeat the dates once again, Mr. Vasu.
Millard, May 2023.
Yes.
Is the first date of the date of the tender, original tender, Millard.
Right.
Now, Millard, amendment, Millard, came, Millard, on, Millard, 3rd August 2023.
Yes.
And the pre-bid meeting, Millard, was held on, Millard, June 7, 2023. And Millard, I have not mentioned the date, Millard, 23rd May 2023, tender floated.
Right.
Now, Millard, Mr. Chaudhuri, Millard, was instructed to submit before your lordship, Millard, that the suggestion, Millard, that has been made by my client, Millard, that is absolutely incommensurate with the, Millard, the premise of the amendment. So there is no conflict. So now I cannot turn around and, Millard.
One component of the amendment.
One component.
Yes, yes.
Now, Millard, first, Millard, my proposal.
Yes.
Page 15. 14 and 15. Clause 30. My client name is Cyrix Healthcare Private Limited.
This is a writ petition.
No, that was handed over to your lordship, Millard, during the course of submission. Pre-bid meeting, Millard.
Oh, that. Yes.
This is not a part of the Millard writ petition.
Page 14, 15, what are you saying?
Of the Millard, the document, the compilation that has been handed over to my lord. Pre-bid meeting, Millard, minutes.
Minutes of the
Minutes of
pre-bid meeting document.
Pre-bid meeting documents, which includes, Millard, our suggestion. আমার
But it's,
এইখান থেকে এইখান থেকে
May I hand up another set?
no, need not.
Yes, that is the one.
This is the one.
Yes.
Right?
Milord, is that,
Now, Milord,
please change.
Yes.
Yes.
Thank you.
the first, Milord, the clause as per REP
Yes.
amendment requested, please change this clause to below. The bidder should have, and then Milord, my client's name, Cyrix, justification for amendment.
Yes.
Now, Milord, please change this clause to below. The bidder should have serial number 30.
Right.
Yes. Now, Milord, my client said to allow more technically competitive vendors to participate. Sorry, Milord, please change this clause to below. The bidder should have experience of handling similar comprehensive maintenance of biomedical equipment project in any state of India during the last 3 financial years, that is such and such, certified by the ordering authority, competent authority of the facility of the respective facility wherein the project value should be at least rupees 100 crore cumulative for 3 years. This enable more bidder with required experience to be qualified for this bid, and the authorities can get more competitive bid rates, thereby having best utilization. Now, Milord, page 110 is the of the writ petition is the amendment, Milord. Page 110 of your lordship's brief.
Yes.
Yes. Now, Milord, the bidder should have experience of handling any single biomedical equipment maintenance project, any Milord single biomedical equipment maintenance project in any state of India worth rupees 100 crore for 3 years. That means per year for 3 years. It comes around, Milord, 300 crores. So my suggestion in clause 30 of the document, and Milord, the incorporation, Milord, made by the authority by way of an amendment,
It
Milord.
is exactly the. It is not exactly the same. You say should be at least rupees 100 crore cumulative for 3 years. This cumulative is not there, you say.
Cumulative is not there. Per years, Milord, it comes around. Now, Mr. Chaudhary, Milord, had sought to, Milord, impart upon your lordship that net asset value, the asset value of the Milord equipments is 1400 crores. Milord, the tender is for a period of 6 years. 4 years, Milord, must, and 2 years subject to satisfactory performance. Now, Milord, 4 years, Milord, if your lordship, Milord, kindly, Milord, takes pain, Milord, to take, Milord, note of the situation. Asset value 1400 crores, 80,000 equipments. We have quoted a rate based on, Milord, the maintenance cost, Milord, 5% of the asset value per year maximum. Now, Milord, if it comes around, Milord, Mr. Chaudhary's client, Milord, said, Milord, estimated cost. What is estimated cost, Milord, and what is the actual cost for maintenance? That has not been, Milord, disclosed, Milord, in the tender document. Suppose, Milord, in your lordship's room, Milord, the asset value, which includes, Milord, the air conditioned machine. Suppose, Milord, each machine, Milord, it costs rupees 36,000. Milord, the maintenance cost cannot be, Milord, more than 6% annual maintenance contract. This is a basic thing. Now, Milord, Mr. Chaudhary's client is required to make, Milord, my suggestion, clause 30, and this amendment, Milord, first of all, Milord, this is, Milord, clearly, Milord, distinguishable that this is, Milord, absolutely far away from the suggestion that we have made to them. So, Milord, it cannot be said by any stretch of imagination that the suggestion has been accepted. Even then, I question the propriety of the tender document. Am I clear to my lord?
Yes.
Now, Milord, second. Now, Milord, this next E, page 11111. Milord, the bidder should have robust financial capacity and have an average annual turnover, gross receipt of a minimum of rupees 180 crores for the last 3 financial years, such and such, should be certified by chartered account to be certified by accuracy. Milord, this 6E, this is also, and it says, Milord, before that, Milord, the bidder should not, Milord, sorry. Now, Milord, this particular 180 crores for the last 3 years turnover, Milord, this is also a part of amendment. We are agreed by and dissatisfied with this because the first 2 clauses, Milord, number of bed, Milord, my respectful submission before your lordship, Milord, that the qualification, Milord, it is the actual domain of the government. Freedom of contract, Now, my lord, government can exercise discretion. My lord, the plethora of judgments, my lord, stand against me with regard to, my lord, the discretion exercised by the court, my lord, under 226 is very limited. But it is not said, my lord, under any circumstances, the court is precluded from. Now, my lord, the term arbitrariness or, my lord, unreasonableness action must be given some color. What are those circumstances in which, my lord, the court can, my lord, interfere? Now, my lord, reasonableness in unreasonableness in action has to be adjudged in the context of, my lord, two things, two aspects. First, my lord, what are the jobs that is to be assigned to my client? And what are the requirements, my lord, that has been fixed by the government? This must be relatable to the work, my lord, to be done. Now, my lord, when my client in no uncertain terms has said, my lord, that the competition, fair competition, and my lord, the number of bidders must be increased, those who are armed with this kind of experiences in maintaining biomedical experiences, in support of which my client has, my lord, in the pleading and in the document evidence has said, my lord, in other states, Kerala, Andhra, and the other states, my lord, we have been selected for, my lord, doing this kind of jobs. And, my lord, the number of beds in the hospital, my lord, is much more higher than that of the subject to correction. Now, my lord, where, my lord, the scope of interference, my lord, by the read court in this particular aspect is this, that this silence maintained by the government in not assessing, my lord, what is the estimated cost, my lord, is a gap where, my lord, the government can play and, my lord, make this contract is a tailor-made contract. Because the person, my lord, who will be selected, because I have a right, my lord, subject to correction.
Why do you say it is tailor-made? Because it does not suit you, you are saying that.
No, my lord, question is, my lord, even if it does not suit me, that does not become the contract tailor-made.
I mean, what turns on this 180 crore? Is it a magic figure?
No, I do not know. I do not know, my lord. 180 crores, my lord. It
you
is,
don't know, Mr. Pusu, you don't have any challenge.
no,
Count of challenge.
no, my lord. I said that it must be relatable. What is the basis of assessment? It does not disclose any basis. Now, my lord,
robust financial capacity is not something which is relatable. Yes.
No, robust financial
Unless you have
capacity.
a financial capacity,
No,
you
my lord,
cannot do the project.
No, my lord, yes, absolutely.
Yes,
My lord,
yes.
to that, my lord, my respect to submission, my company, my lord, has a turnover of rupees 90 crore. I have specified per year turnover. Now, my lord, I said if the value of asset is 1,400 crores, and my lord, if this requirement has been fixed, my lord, he has to show that this is the requirement which, my lord, must be made by the author. That
1,400 crore is the value of
asset. Asset means the value of the machines. Every year, my lord, depreciations counts.
The asset for the proposed work.
Asset means, you know, the cost of the machines. That means
you know what is asset, but asset of what? I mean, regarding the proposed work in this tender.
Yes.
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 So where do you get that? Is it reflected somewhere in the tender?
Yes, page 39.
Yes.
Sorry. 138, will not kindly take spin.
138.
Page 1.
না আমার সাথে মিলছে না তো না 99 রিট পিটিশনে বলছে এই পাতাটা আলাদা করে রাখ
Page 99, table 1.
Yes. 3 divisions, Millard Presidency, Bardhaman, Jalpaiguri, total 1,400 crores. Millard, it excludes, Millard, this Millard, it is the estimated cost of equipments. Now, Millard, estimate cost of equipments and the take quote and Millard, why, and Millard, second page, the division of work, Millard, the Barashat HD.
What is the proposed work? What do you have to do?
Yes, Millard, that is at page, Millard, 60, clause 16 of the contract, Millard. That is at page, Millard, starts from 38.
54.
60.
Page 54.
Yes. Millard, what is my job? The service provider in consultation with the WBMSCL, that is Mr. Chaudhury's client, shall design, print and stick durable unique barcode sticker on all equipment under the contract at the hospitals and healthcare unit within 1 month from the award of contract. The service provider will develop, deploy a web-based application with the option of one web-based call logging, application-based call logging and IVRS to aid Health and Family Welfare Department.
It's basically repair and maintenance.
Repair and maintenance. Suppose, Millard, and Millard.
What nexus does it have? Why are you citing this total asset worth?
Asset worth, Millard, because they
this is your asset worth to see your integrity. That has no nexus with
No,
the
the
value
asset
of the
work
assets.
means the
Yes,
value of the machines, my lord, which I am required to maintain
yes,
throughout the year.
yes.
My lord, the cost of the machine is
Yes.
1,400 crores.
Right, right.
Right,
But what,
for
what
which-
nexus does it have with this
But
one?
that is on the basis of the net value of the
Yes.
my lord machines. They have my lord estimated 180. 60 has been enhanced to 180, 100 crores per year. I said this has no relevant. This is not relevant, and this has no my lord reasonable nexus with the object my lord sought to be achieved. Suppose, my lord, if I say that I have a 90 crores per annum income, and I quote, my lord, that the maintenance, my lord, required, my lord, your lordship kindly, my lord, imagines a situation where, my lord, if they say is 80,000 machine, my lord, worth rupees 1,400 crore, my lord, all machines, my lord, will not be collapsed, my lord, in one day, my lord, and my lord, I am required to, my lord, replace all the parts.
They are asking for only 180 crores.
180 crores.
Your robust financial, to see your financial capacity to do the maintenance work. This has no connection with the entire value of the assets.
No, but the basis of 180 million has million. They said million on the last occasion. 180 comes million.
Why do they say that?
No, on the submission was made. Why did this we make?
I'll
this
ignore that submission. It is not reflected from the.
Not reflected. Then Miller's this 100 per annum, which comes to 300 crores.
No, 100 per annum is something else.
Yes.
180 is something else. We are now on 180 crores.
180. It
Please
was
come to page
yes,
11 of your writ
yes.
petition.
Millard, now 180
What
per
is it?
year.
You have not heard
180
what I have
no,
said. You are saying is.
No, I am saying Millard.
Please come to page 11 of your writ petition.
11, yes. Bidder should have robust financial capacity and have an annual turnover, gross receipt of minimum rupees 180 crores for the last 3 financial years.
What nexus does it have with that total asset worth? It's your financial turnover, your financial capacity. You have to have a robust financial capacity. If you don't have that, you participate, give a low bid, and then you can't do the work. That is the reason they want to ascertain your robust financial capacity.
Millard,
What is the nexus between this and 1400?
This one, no, your lordship is asking me that this should be the my client's capacity, financial. It does not have any relation with this. I said, Millard, yes, Millard, I said in the first 23rd May 2023, this was 60 crores.
Yes.
Now, Millard, this 60 crores has been enhanced to 180 crores.
Yes.
I said this enhancements must be relatable to the nature of job that is to be assigned to me. Why it is 180
How
crores?
is 60 crore related?
Millard, 60 crores, Millard, your lordship.
Because you have that capacity.
No, Millard, that
you have
was
90 crores.
No, 90 crores.
So
Now,
just
Millard,
because it has gone
no,
beyond yours.
No, I said, Millard, that 60 crores, Millard, while I quote Millard, a particular Millard, they make this quotation, Millard, I have to assess Millard taking certain Millard parameters. Support Millard, what is the qualities of the machine? What is the annual maintenance contract, Millard, must be based upon taking into account the relevant different factors. Now, Millard, question is the 180 crores.
Why is 60? Why is 60 good and 180 not good?
60, according to me, is reasonable.
Why?
Because reasonable, because Millard, they did not Millard spell out what is the estimated cost.
Why do you say 60 is reasonable?
60
180
is reasonable.
Mr.
It is
Basu,
not-
please let me complete one sentence.
I'm sorry.
Why do you say 60 is reasonable, 180 is not? Tell me this.
60 is reasonable, Millard, taking into account, Millard, the net value of the asset. And Millard, I tell.
Show me the maths. How is it related? 60 and 1440.
Paragraph 30 to 12. Paragraph 13, page 12.
Yes. Yes.
Millard, that is my understanding. I may be wrong, Millard, subject to correction, Millard.
Yes.
The petitioner states annual turnover of the petitioner company is around 90 crores and the quarterly billing of the project of the respondent is expected to be more or less 16 crores and for the petitioner will be able to execute the project without financial constraint. The following table will clear the scenario and arbitrariness of the tender. Total asset value of the tender 1,400 crores. Maintenance charges 5% we quote. Estimated revenue per annum 70 crores. Estimated maintenance cost for applicant assuming 10% net margin 64 crores, required working capital 60 crores. So, Millard, this is our assuming quarterly billing for this project, the petitioner would need only 16 crore working capital to execute the project, and for that, ideal working capital turnover ratio of 1.5 to 2 is generally considered good. By this logic, a turnover of rupees 14 crore to 30 crore per annum
This is exactly what I was asking you. Yes. No, I get it. Yes. What else, Mr. Basu?
No, Mr. Then I said,
Yes.
the technical criteria made in clause 6C1 is never seen as an eligibility criteria in similar tenders in other states. Petitioner places of references of similar tender for same work in the three states, Andhra, Kerala, and Goa. Comparative study of the tender documents in the said three states will clear the discrepancy in the tender document. Now, the state of West Bengal can say, I am not required to follow those. But the question is, Millard, that
fairness for ascertaining fairness and
yes, Millard,
definitely. Yes.
and Millard,
Yes.
And after this amendment, then our copy nahi?
Yes, yes.
Aita copy koi.
Very well. So that is on 180.
Yes.
And 100 crore, Mr. Basu, apart from your suggestion, anything on merits?
I said, Millard, the suggestion I have made, Millard, I have.
So your suggestion you have clarified that
Yes.
it was not your suggestion, that
Not
is your
my
suggestion.
And
Yes.
100 Millard comes, Millard, 300 crores per year.
But apparently what they have done, please come to page 9 once. They say the bidder should have experience of handling any single biomedical equipment maintenance
The
project.
single biomedical was not there.
You finished then?
Sorry, Millard.
No, you finished then I'll start. Yes.
Kindly excuse
The
me.
bidder should have experience of handling any single biomedical equipment maintenance project in any state of India worth rupees 100 crore per year for 3 years. So that is there. Now that has to be worth rupees 100 crore. Suppose it does not meet your suggestion. Let us be clear of that. It is not on the basis of your suggestion. Why do you say this is not acceptable?
Yes, Millard,
Yes,
because the
yes.
clause 28 of the contract, page 54 of your lordship's brief, Millard,
Yes, yes.
they are required to, Millard, address my grievance.
Yeah.
Initially, Millard, when the matter was taken up for my lord's consideration,
Right.
I was wrong in making the submission that, Millard, my client did not make any, Millard, representation to the authority in terms of the contract by which the authority could get the position of my client, so that, Millard, the authority could redress the issue. So, Millard, the fact remains that I made representation. Neither, Millard, I made suggestion in the pre-bid meeting. Thereafter, I made representation. Millard, nothing was redressed.
No. What was your suggestion on this 100? That 100, your 100. That was not accepted. They have the choice.
Your lordship can say, Millard, that silence amounts to rejection. They did not decide the issue.
Yes.
They did not decide.
Only silence. They chose something else.
They chose something else.
So even if your suggestion was refused, that itself is not a ground for challenge.
No, I am not saying.
So why do you say this is absurd?
Now, I said,
100
Millard,
per year.
100 per year, it comes to, Millard, 60 crores per year, Millard, if it is 100, I said, Millard, cumulative 100. They said 100 crore per year. That means, Millard, 100, Millard, goes to 300. That is also three times.
Why is it absurd?
Absurd means, Millard, that is, if Millard, this assessment is relatable to the work that has to be assigned. That is the only contention. Otherwise, the question of reasonableness, Millard, every tenderer, successful tenderer, if your lordship asks them, Millard, to place, Millard, the
Why do you say 100 for 3 years is more reasonable than 300?
Because, Millard, the logic, Millard,
yes,
in my suggestion,
yes,
page 14 to the আমার এখানে আছে দর্শককে দেন হ্যাঁ Millard, I said, Millard, in the page 15, the experience of handed, it starts from, Millard, this enable more bidder with required experience to be qualified for this bid, and authorities can get more competitive bidder rates, thereby having best utilization of public revenue. Now, Millard, last day, that is, Millard, they are not bound to accept my suggestion.
The less it is, there will be more participation.
Millard, if I can, Millard, conclude, Millard, only one thing, Millard, last submission.
Yes.
Millard, public interest, public element, Millard, must be there, Millard, in choosing, Millard, the tenderer. It is at the end of that, it is a public interest. Now, Millard, subject to correction, Millard, I have understood, Millard, the term public interest, Millard, that by this process, government can, Millard, augment its revenue. And this is clear. Second, Millard, the government, by reason of this amendment, Millard, can ensure, Millard, the quality of service, Millard. The other experiences of, Millard, the tenderer, Millard, with this financial capacity, Millard, that has to be adjudged with in the context of, Millard, the quality of service. Because at the end of the day, Millard, if I am competent, Millard, public will be made to suffer. Now, Millard, the question, am I clear, Millard? Now, Millard, only thing.
Why do you have this apprehension that you are not clear? I mean, I could not understand or what?
No, Millard.
What is the reason for your repeated?
Millard, I do not have this audacity, Millard. my lord,
You have
only-
other order cities, Mr.
No, no, nothing. My lord, I'm a small fry. Only, my lord, only. My
Again,
lord.
fry. You can go beyond fish.
No. My lord.
Yes.
My lord, only indulgence, my lord, I'm seeking. The government is not bound to accept my proposal. But
Even
often-
then, they have to be
even
reasonable.
then, this reasonableness will not contain, my lord, in the element of public interest. The government has to show clearly that they cannot explain, my lord, why this conduct through affidavit. It must be clear from, my lord, the clauses itself. That is my understanding. And our key.
Amendment
And my lord, this is the CIRIX, my lord, my client has made the representation, which is not a part of this document, that Mr. Chaudhuri has submitted, my lord, which, my lord, requires to be gone into, my lord, because, my lord, we have clearly stated, my lord, why these are required, my lord. Only, my lord, okay, দিয়েছিস? Copy. একটু দেবেন,
You
Judge?
cannot hand over like this, Mr. If it is not in the then
My lord, after amendment, my lord, they say the bidder
petition
should have-
itself is your representation.
No,
No. If I decide it
yes,
either way,
yes. My lord, the bidder should have experience of handling similar comprehensive maintenance of biomedical single, my lord, that has gone. My lord, biomedical equipment project in state of India during the last 3 financial years, certified by the ordering authority, competent authority of the respective facility wherein the project value should be at least 120 crores cumulative for 3 years, or the bidder should have experience of handling single biomedical equipment maintenance project in any state worth rupees 30 crore per year for 3 years. 100 million stack comes down to 30 that they have given, and 180 million comes with 120. 240 comes to 1.
No, which notification you relied on? That is your suggestion.
Technical bit, dated tara financial bit porchi, data ball.
I can't get you, Mr.
8/8/2023.
You relied on something to say 30 should be the thing. 30 per year.
No, I said yes.
Where do you get that? That is your suggestion.
Not my suggestion. It is my suggestion. After the amendment, Millard, this is Millard change required. I said this is not in the Millard.
That session you made already. If it is 100 for 3 years, divided by 3, it comes to around say 30 per year, 33 per year. Yes. Right.
But in reply, be very brief.
Yes.
No. Why do you think I'm like that?
Yes. Yes, Mr. Yes. He's a small fry, he admitted. Yes.
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 Now he says that you've taken my phone. Why should I take his phone?
Yes. He gets nostalgic whenever something related to fish is. Yes.
And then he loses control.
Yes.
The writ petition.
Yes.
Filed, my lord. I'll just, my lord, break it up, my lord. Writ petition filed, challenging, my lord, 2 alterations.
Yes.
To the tender conditions.
Right.
Page 8 and page 9.
Right.
Page 8, my lord, my response was.
Page 8 and page 11 actually. Yes. 8-9 is one.
Yes, my lord,
and
your
page
lordship is
10-11 is
I'm
another.
sorry, my lord, 8-9 is one
Yes,
and
yes,
10
you
and
placed it
11
on the
is
last
the
one.
other. my lord.
Right.
These are the 2 changes.
Yes.
Argument is that these changes are illegal, tailor-made to suit somebody else, therefore malevolent.
Unreasonable.
Unreasonable.
Arbitrary. Yes.
Arbitrary. In response, my lord, our submission number 1 is that 8 and 9 is at your behest. My lord, the argument which was being advanced is
Yes.
the third part, which is second and the third part, which have been replaced. My lord, please see page 9, my lord. Bidder should have experience of handling similar comprehensive maintenance facilities, etc., of 1,000 beds during the last 3 financial years, or my lord, 10 facilities of 500 beds. This should not have been done away with to put in, my lord, a net worth. This was the argument. To that, my lord, our, my lord, first answer is that if your lordship is pleased to see the pre-bid meeting document, my lord, kindly take it once, my lord.
Yes.
To see serial number 30.
Right. Page 15 is the relevant portion.
Yes, my lord, but may I, my lord, place from page 14?
Yes.
My lord, please change this clause to below.
Yes.
And why? To allow more technically competitive vendors to participate.
Yes.
Partially accepted.
Now, my lord, kindly see what is the clause. B and C is that bed on the basis of 500 beds and 1000 beds. First column, the existing clause.
Yes, yes.
And the change should be on the basis of project value. That is accepted. That rationale is accepted. Now he says that's why it's partially accepted.
I get you. Yes, yes.
He says it should be 100 for 3 years. We
The
say
fulcrum shifts from bed to project value.
yes.
I mean,
That is
financial
at his request. So the argument that this alteration could not have been done, Milord, that Milord doesn't lie in their mouth, to put it that way.
Yes, yes.
Secondly, the writ petition doesn't contain either the request letter or the subsequently partially accepted request or the subsequent letter which has now been placed.
Yes.
That's number 2. This is not my first argument. So 50% you can't complain except as regards the value because it was on your request, which the writ petition doesn't speak of.
Yes, yes.
Second is for 100 crores cumulative for 3 years, there is a rational basis. And my lord, we had, in fact, I can give your lordship the method for the calculation.
You have made it 100 crore per year.
Yes,
Yes.
it has to be, my lord, 100 for each year, really.
Yes.
My lordship sees, my lord,
Each
100
year,
crore
yes, yes.
oblique year for 3 years. So continuity must be there for 3 years, and handling a single biomedical equipment maintenance project worth 100 crores. So every year, the value of the project should be 100 years and you should be doing it for 3 years in a row. You know, it's not compulsory that the project value would be 100 into 3. It's
All right, all right, all right.
that's Milord, it's 100 crores and you must do it for 3 years. Now, this 100 crores has also been, Milord, reached by a logical basis. We have, Milord, the service charges for 2 districts, and we, Milord, 1400 crores into that percentage, Milord, gives us 100 crores. If required, Milord, we can show that. There's no difficulty.
Not necessary right now. Yes,
Right now,
yes.
but there is a basis. Now, for the second clause,
Yes,
which has been altered,
Yes. 180.
that I have, my lord, shown your lordship the 2 notifications, the central government and the state government, which, my lord, resulted in that on the last occasion. If
Just
your
into
lordship
that,
sees,
yes,
my lord,
Yes.
the clause, and if your lordship sees, my lord, the notification of 17 December 2002 of the central government, that says, my lord, average annual
Notification dated?
the dated, my lord, 17 December 2002.
Yes, yes, got it. Yes.
Average annual, my lord, page 3 of that notification.
Right. Yes.
This is, my lord, eligibility for civil or electrical works. This is also, my lord, taken into account. Then average annual financial turnover during the last 3 years, ending such a 31st March of the previous financial year, should be at least 30% of the estimated cost.
So he also hinted, Mr. Basu, that you did not tell the estimated cost. I mean, that was-
Estimated cost is, my lord, taken out
yes.
by a formula which is derived from a state government notification, which I also handed up, my lord.
Yes, yes.
No, my lord, that was not handed over.
That's my mistake then.
12th March is not that.
No.
Yes.
State government is notification.
No,
reading.
no, no.
12th March of 2015.
No, 12th March. 12th March দিয়েছে তো না কিন্তু সেটা তো সিভিসি সিভিল না
You are not relying on the 12th March notification.
12th March 2015.
That is for 240 crores. Now, my lord, here your lordship will see at least 30% of the estimated cost.
Yes.
Now, how do you, my lord, calculate estimated cost is the question I asked my client.
Yes,
And
yes.
they, my lord, replied by placing reliance on the, I'm sorry, my lord, this is manual for procurement of goods. It's not, my lord, state government. This I had handed up earlier. My mistake. This I've shown you.
No.
You give a copy to Mr. Basu. Will continue after recess.
Yes.
Go through this. Yes.
এটা দিইনি তো আগে
না এটা আমি পাইনি আমাকে তুই 12ই মার্চ দিয়েছিস আর 2022 দিয়েছিস।
Now, this says
Yes.
that estimation of cost, my lord, is at page 28.
Mr. Chaudhary will continue after the recess. Give him a copy so that he can go through
Yes,
the
yes,
copy
of
at
course.
least. Yes, yes.
Now,
Please.
deeply obliged.
This manual, yes.
So I need to respond to this.
He has not yet spoken on.
Oh, no.
Behaving very badly with you.
Yes.
ফোনটা তো নিচে রেখে দিচ্ছি নে।
It will be a pre-bid response. Yes. Yes, Mr. Chaudhary.
That he is, my lord, making accusations against me which are not becoming of such a senior lawyer, my lord. And that also after, my lord, the kind of help I have been giving him.
In what? Matters which can be spoken of in court or?
Yes, yes. He lost his phone. I searched it out for him.
Yes.
First, my lord, he gives me only 100 rupees bokshish. Then, my lord, other accusations he's making.
His phone may be, I mean, searched for by all the authorities. Yes.
Right, but with that, my lord, bokshish which I got, my lord, I went and bought, my lord, certain fish articles.
Fish,
and
You cultured fish.
Yes, his chamber juniors and I, my lord, had it
He's
together.
becoming very fishy, very fishy. Yes.
Now, my lord,
Estimation.
my lord, estimation, which is your lordship would see. I've shown your lordship, my lord, the 17th December 2002 document.
Yes.
That average annual financial turnover during last 3 years ending 31st March should be at least 30% of the estimated cost.
Right.
For estimated cost, my lord, the manual for procurement of goods, my lord, page number 29.
Yes.
My lord, other methods for establishing estimated cost in the indent and tender evaluations are A, estimated rate in past incidents, in past indents of the same goods.
Yes. Yes.
Now, my lord, this is the calculation which we have made. Here, this is a continuing
Keep it with you,
contract.
need not, yes. But you are ready with the calculations.
Yes,
It's
yes,
there.
my lord, it is all here.
Yes.
So, my lord, that is why this clause, my lord, has come into operation.
Yes.
And the argument that let me, my lord, meet the 3 years argument also, since he has made it. My lord, kindly take the writ petition once. He has, Lord, page 12, paragraph 13. Now, this annual turnover, according to him, should be 90 crores. The reason is,
Yes.
that's because he is, my lord, 90 crores, he's made this.
Yes.
Now, in this case, it should be at least 100 crores because, my lord, total asset value is correct. The maintenance charge, he puts at 5%.
Yes.
Maintenance charge will be 7.2% because that is the average of, my lord, the maintenance cost in the districts. We have that calculation also ready. Now, that's what the tender committee, and if your lordship does that, it will go over 100 using the other figures in the same calculation. So, my lord, there is nothing wrong with what has happened. There is a total reasonable basis. Number two, he says malafide tailor-made. Tailor-made for whom he doesn't say.
Tailor-made against him. Yes.
Against him. There's a conspiracy theory. The world is not conspiring against him.
Yes. Yes.
That, my lord, doesn't work in law. And lastly, my lord, this is a very important tender because it relates to maintenance of medical equipment in all hospitals, my lord, all over Bengal. It's a very important tender, which is why these benchmark, my lord, parameters have been kept. Even if there is nobody there in the first call, we'll reduce it in terms of, my lord, the tender manual in the second
This
call.
covers the cancer hospitals also in West Bengal.
No.
Do not cover the cancer? Oh.
No, I don't think government has any.
Yes.
No. I will, my lord, make necessary interrogation after the
Yes,
matter.
please do that so that he cannot appear in future.
I used to, I know a little bit, Mr. Pratik, my Lord Justice Pratik Prakash Banerjee used to tell me little, but now, my lord, I have other ways to find out. Straight, direct interrogation.
Yes. Very well. Yes. Yes.
Only two plots. What to do? First of all,
May I have my
Yes. Yes.
Mr. Shah's reliance, Mr. Chaudhury's reliance, my lord, on this manual, my lord, kindly sees, my lord, the first. It is a manual for procurement of goods. Has the lordship got it, my lord?
Yes.
No, my lord, this is, my lord, Government of India, Ministry of Finance, Department of Expenditure. When the state has, my lord, its own financial rules, my lord, under the Financial Act, my lord, the government has to, my lord, say that I have incorporated or by reference, we have adopted this. Be that as it may, my lord, manual for procurement of goods. But we are, my lord, we are to be engaged, my lord. Our service, my lord, is a maintenance of a machine, service. So, my lord, it is not, my lord, relevant at all, my lord. Second, my lord, the estimate, my lord. My lord, page 28 of this. Estimated of cost, estimation of cost, my lord, which I was harping, my lord, from the beginning. The estimated cost, has your lordship got it? My lord? Estimated cost, my lord, E, clause E. Page 28.
Estimation of cost.
Estimation, sorry, the estimated cost in the incident is a vital element in various procurement processes, approvals, and establishing reasonableness of prices at the time of evaluation of the bids. Therefore, it should be worked out in a realistic and objective manner. The prevailing market price ascertained through a market survey or budgetary quotations from one or more prospective suppliers or published catalogs, maximum retail price printed on the item is the main source for establishing the estimated cost of items for which there are no historic data available. It may be noted that MRPs usually include significant margins for distributed wholesalers and retailers. But how does it apply? I put this question to myself. I am willing to maintain, my lord, the goods, not go the instrument, medical, biomedical instrument. So, my lord, it is absolutely, my lord, it is blissfully misconcept, my lord.
Yes, it is.
Misconcept.
What misconcept?
No, not kindly. No, not
what
kindly.
misconcept?
No, not sorry.
I'm sorry, you are addressing the court, Mr.
Blissfully misconcept.
Peacefully, sir. Yes.
I'm sorry, Milord. Kindly sees, Milord, his passionate reliance on this, Milord, 17th December.
He was not very passionate. He was very objective. Rather.
Objective. No, sorry.
Yes.
Milord, this is, Milord.
Passionate reliance on what?
On, Milord, the memo dated, Milord, 17th December 2002. 17th December 2002.
Yes, yes.
Now, Milord, kindly comes to, Milord, clause 4. The above list is illustrative while framing the pre-qualification. I'm sorry, Milord.
No, it's all. Yes.
Milord, clause 4. While framing the pre-qualification criteria, the end purpose of doing so should be kept in view. The purpose of any selection procedure is to attract the participation of reputed and capable firms with proper track records. The PQ, that is the primary qualification conditions, pre-bid qualification condition should be exhaustive yet specific. The factor that may be kept in view while framing the pre-bid qualification criteria includes the scope and nature of work, experience of firms in the same field, and financial soundness of the firms. Now, Milord, this is very, Milord, it lends meaningful assistance to my argument for the simple reason, Milord, I said exhaustive yet specific. Now, Mr. Chaudhary cannot supply reasons, Milord, when, Milord, the tender document, Milord, it is vague and uncertain. So, Milord, law demands, Milord, certainty. I said, Milord, it must be relatable to work. The government also says, Milord, while framing, it includes the scope and nature of work. In law, Milord, everything is with reference to context. Then I said, Milord, my nature of work, Milord, the quotation I have given, that what is the estimated cost? Estimation of cost, Milord, the Mr. Chaudhary's reliance on the central government, Milord, circular or the rules, Milord, it absolutely with regard to goods. Price items, price tags, suppliers, distributors. This is not a question here, Milord. It is out of context. So, Milord, the state virtually has made no submission, Milord, as against, Milord, my submissions for, Milord, because I, Milord, said that I do not have any right to be selected, Milord, in the process. My right to, Milord, take part in the selection process, this absolute, Milord, the prevention, they prevent me from participating means, Milord, they close the door of transparency, Milord. It is not a conspiration theory. It is a theory, Milord, I says, at the end of the day, it should be logical. Logical means that you say and prove through the tender document that your assessment discloses public interest. To me, public interest means, Milord, the enhancement of public revenue. And second, Milord, it relates to, Milord, the quality of service by incorporating this. So, Milord, the rules of game that has been changed in the midway. And, Milord, the fourth last submission, Milord, yes. It is not Mr. Chaudhary's case that 10 bidders, Milord, who had taken part, Milord, in the pre-bid meeting, Milord, none of them has, Milord, quoted this rate. So, Milord, there was no consideration based on the materials of record, Milord, which forms the opinion, Milord, on this issue. So, entire exercise that has been made my lord, by the authority, my lord. It is not a case of Mr. Chaudhary, at least from his submission or from record, that the other bidders, my lord, has, my lord, submitted that yes, this should be the rate. And that is why the government found it, my lord, logical and accepted the other parties. So it was nobody's case, my lord, that yes, the government has considered. The government has considered something, my lord, which was not on record. That is my respect. So, my lord, I should be allowed to take that. Sorry. So estimated cost is conspicuously absent, and without there being any estimated cost, all calculation based thereupon is imaginary, my lord, and irrational. I'm extremely grateful, my lord. May I take one?
Yes.
Deeply obliged.
Learned counsel for the petitioner. No, the petitioner has challenged amendments of 2 tender clauses where the petitioner participated. Full stop, next para. Learned counsel for the petitioner contends that both the said amendments were dehorse the principles of of reasonableness and lack transparency, being devoid of any objective basis. Full stop, next para. It is argued that the first amendment, whereby the bidder should have experience of handling any single bio-medical equipment maintenance project in any state of India worth rupees 100 crore stroke year for 3 years, is absurd, being without any material basis. Full stop, next para. By placing reliance on the suggestion made by the petitioner in the pre-bid meeting held in connection with the impugned tender process, it is submitted that the petitioner suggested a rational alteration, of a clause that the project value should be at least rupees 100 crore within single inverted cumulative single inverted close for 3 years. Full stop. As opposed to the same, the impugned first amendment is rupees 100 crore per year for 3 years, which is exorbitant and defies all logic. Full stop, next para. Learned counsel for the petitioner argues that the second amendment brought in was that the bidder ought to have robust financial quality capacity and have an average annual turnover stroke gross receipt of a minimum of rupees 180 crore for the last 3 financial years. Full stop. It is pointed out that the previous clause stipulated a minimum of rupees 60 crore for the last 3 financial years, which was increased 3 times, also without any reasonable basis. Full stop, next para. Learned counsel for the petitioner places reliance on the calculations depicted in paragraph 13 of the writ petition to argue that annual turnover of the petitioner company is around 90 crore, which is the actual annual turnover suitable for the project contemplated under the tender in question. Full stop. It is argued that the total asset value of the tender is 1,400 crore, whereas maintenance charge should be calculated at the rate of 5%. Full stop. Taken so, the estimated amount which is required would be around rupees 90 crore. Full stop. However, the amount introduced by the amendment was double the same. Full stop, next para. Learned counsel appearing for the respondent author. Learned counsel for the petitioner also places reliance on certain judgments of the Supreme Court to argue that under certain circumstances, a writ petition is very much maintainable against arbitrary action of the state in tender matters. Full stop, next para. Learned counsel for the respondents, while controverting such arguments, places reliance on the minutes of a pre-bid meeting. First up, it is contended that originally the clause was that the bidder should have experience of handling similar comprehensive maintenance of biomedical equipment project in any state of India, which was on a per-bed basis. First up, it is the petitioner who suggested that the project value ought to be the relevant determinant. First up, hence, the petitioner's suggestion was partially accepted. Full stop. However, since the respondents were of the opinion, on objective basis, that rupees 100 crore would be the appropriate worth of the previous work, the same was stipulated as a yardstick. First of next para. Learned counsel for the respondents also places reliance on an office memorandum dated December 17, 2002, issued by the Government of India, Central Vigilance Commission, wherein for civil stroke electrical works, the average annual financial turnover during the last 3 years, ending 31st March of the previous financial year, was stipulated to be at least 30% of the estimated cost. Full stop. Next para. Learned counsel also places reliance on a manual for procurement of goods issued by the Government of India, Ministry of Finance, arguing that one of the clauses thereof, pertaining to estimation of cost, stipulates that other methods for establishing the estimated cost in the indent and tender evaluation are, inter alia, estimated rate in past indents of the same goods. First up, it is argued that the respondent authorities in the present case are ready and willing to place on record the relevant calculations, on the basis of such yardsticks. First up, hence, it is argued that the petitioner's challenge to the amendments made, are misconceived and ought to be turned down. First up, next para. Insofar as the scope of intervention of this court in the writ jurisdiction is concerned, learned counsel for the petitioner is justified in arguing that under certain contexts, the writ court can very well intervene, where there is total arbitrariness, bias, malafidis, and or other such circumstances warranting interference. Full stop. Next para. The judgment of the Supreme Court in NG Projects Limited versus Vinod Kumar Jain, reported at 2022 SCC Online SC 336, is squarely applicable in such context in the present case as well, as is the proposition laid down in Airport Authority of India versus Center for Aviation Policy, Safety and Research, reported at 2022 SCC Online SC 1334, where it was held that the court could interfere where there was discriminatory treatment in the matter of evaluation of tenders and there was no fair and equal treatment. First up, next para. Learned counsel for the petitioner also relies on Larsen and Toubro Limited and another versus Union of India and others, reported at 2011 5 SCC 430, where it was observed that the standard of eligibility laid down in the notice for tenders could not be changed arbitrarily, as that would be hit by the provisions of Article 14 of the Constitution. Full stop. Next para. However, insofar as the last citation was concerned, the same is not squarely applicable in the present case, comma, since the respondents did not within single inverted change the goalposts after the game had begun, single inverted close, comma, as the amendments were brought sufficiently prior to the commencement of the bidding process. Moreover, comma, the respondents invited the participants in a pre-bid procedure, comma, which was availed of by the petitioner in the present case, comma, ventilating the grievance of the petitioner and seeking clarifications. Hence, comma, on such score, comma, the impugned amendments cannot be set aside. The context of the amendments, comma, taken comprehensively indicates that insofar as the first amendment is concerned, comma, the petitioners sought a change by way of shifting the pivot from the test of minimum capacity of beds in the last three financial works for the previous work of similar nature done by the participant to the project value regarding the last three financial years. Next para. To such extent, comma, the respondents accepted the petitioner's suggestion and amended the bed-strength test to be project value. Next para. However, comma, insofar as the exact quantum of project value is concerned, comma, it was for the tendering authorities to decide what would be an appropriate cutoff mark for meeting the standards sought in the participants by the tender issuing authorities. Next para. The amended first clause in dispute herein stipulates that the bidder should have experience of handling any single bio-medical equipment maintenance project in any state of India worth rupees 100 crore stroke year for 3 years. There is some doubt as to whether the same means that the total project would be worth rupees 100 to be done for each of the 3 years, or that the valuation pertains to rupees 100 crore for each of the 3 years regarding the worth. Be that as it may, comma, merely because the petitioner suggested rupees 100 cumulative for the entire period of past 3 years, comma, the same does not become sacrosanct with regard to the quantum. Next para. The respondents, comma, in their wisdom as the proposed employers, comma, stipulated the standard at rupees 100 crore per year for 3 years to be the worth of the previous single biomedical equipment maintenance project undertaken by the participants. It is not the case that there is no participant in the tender, comma, who cannot prospectively meet such qualification. Nothing on record indicates that the said quantum is impossible to achieve. Next para. Insofar as the basis of the second amendment is concerned, comma, it is not for the court, comma, sitting in the writ jurisdiction or otherwise, comma, to determine as to what would be the exact actual annual turnover stroke gross receipt, comma, which is required to be met for a particular project, comma, of maintenance of equipment of all hospitals in West Bengal as contemplated in the present tender. Next para. The reliance of the petitioner of similar projects in other states is misplaced on 2 counts. First, comma, each of the states, comma, in a federal structure, comma, have their own particular haves and have-nots, comma, which have a direct bearing in any tender process for maintenance of equipment of hospitals or otherwise. Next para. The particular parameters to be met in case of each of the states of India are unique and different from each other, and comma as such comma per se cannot be a determinant of comparison regarding tender processes. First of next para. Insofar as the other states referred to by the petitioner are concerned, comma, most of those placed reliance on the bed strength for arriving at the yardsticks of participation. First of, however, comma, it is the petitioner itself which suggested the project worth test and cannot now result from the said yardstick. First of next para. The bidder, the respondents in the present case, comma, being the tender issuing authorities, comma, as is well settled in law, comma, have complete discretion with regard to the tests which they require to employ to assess the worth of the prospective participants in their project. Full stop, next para. In the present case, comma, the tender issuing authorities increased the financial capacity sought in the participants from rupees 60 crore for the last financial years to rupees 180 crores for the same period. Full stop, next para. Only because the petitioner has similar worth to the tune of rupees 90 crore, comma, the petitioner cannot have a handle to challenge the said increment. Full stop, next para. In fact, comma, it is also well settled that the inconvenience or convenience of a particular bidder cannot be the test for ascertaining whether the tender conditions are arbitrary or unreasonable. Full stop, next para. Some basis, comma, in the present case, comma, has been shown by the respondent authorities by replacing reliance on certain notifications of similar works. Full stop, next para. Although the manual in question, comma, which was relied on by the respondent authorities is a manual for procurement of goods, comma, the yardsticks thereon can very well be applied to the present case as well, comma, with suitable modifications, comma, to suit the needs of the present tender. Full stop. In the said manual, comma, the second chapter pertains to need assessment, comma, formulation of specifications and procurement planning. Full stop. Since the said manual pertains to procurement, comma, the estimated rates in past intents were with regard to the goods procured. Full stop. However, comma, there is no reason why the same standards should be followed in case of service tenders, comma, like in the present case, comma, which deals with maintenance and repair of hospital equipment for the tenderers. Full stop, next para. Thus, comma, I find no unreasonableness or arbitrariness and or malafidez in the present case sufficient to interfere with the amendments made by the respondent authorities well within time as contemplated in the tender. Full stop, next para. As such, comma, there is no scope of interference. Accordingly, WPA 20920 of 2023 is dismissed without any orders to cost. Sorry. Yes.
Grateful.
No. Item 30.
No, 30, I am for the petition.
Yes.
I have solved all, my lord.
Ganesh Pujo?
Yes, my lord.
Yes.
My lord, since 2014, my lord, we are holding this Ganesh Pujo, my lord.
Yes.
My lord, now, my lord, kindly straight away, kindly come to page 77.
Yes.
The ground on which, my lord, my permission was negated, my lord. I have been directed to inform you that the Board of ADDA in its 149th meeting held on such and such date took a decision regarding Choturango ground at City Center Durgapur, wherein it has been mentioned that henceforth the permission of using the said open space shall be restricted only for conducting government programs and for Durga Puja with requisite permissions for appropriate authorities. And they are, my lord, permitting, my lord, Durga Puja to be conducted, my lord, on the same, my lord, ground, my lord, whereas, my lord, our prayer was turned down, my lord.
What is the ground meant for actually?
My lord,
What
that,
is
my
it?
lord, ADD will, my lord, he is here.
Yes.
My lord, I'm appearing.
You are for the?
I'm for the ADD.
For the?
ADD, Asansol Durgapur Development.
Right, yes, yes.
My lord, there is a board resolution wherein it was resolved in the year 2022 December that in case of this land, my lord, only Durga Puja and government functions, my lord, will be allowed. And that's why, my lord, based on that, this order has been passed. My lord, I need to justify the order first. My lord, offering of prayers and worship at any place or any location, my lord, is not a
This
fundamental.
is a gender bias against male gods.
My lord, I answer that as well.
Why only Durga Puja and government? I mean, I'm not referring to government in that sense. I mean, but even then, yes. Why?
But
What?
first of all, this is not a
What is the fault of Lord Ganesh? I mean,
this is not a fundamental.
Only for 4 days, man.
not a fundamental right under Article 25. Yes.
That is not a fundamental. My lord, I'm not relying on the judgment, lordship.
Yes.
It's
You're right on that. Yes.
Lord. As far as Durga Puja is concerned,
yes,
lordship, there is a very recent judgment of our court as well, our high court, lordship is well. My lord, Durga Puja is a semi-secular activity.
Oh, that. Oh, yes. Wow. Ganesh Puja. Why is Ganesh Puja not a semi-secular activity? Justify that judgment first, then yes.
My lord, because Durga Puja, my lord.
No, maybe it's not. I mean, not so culturally widespread as Durga Puja in West Bengal. Yes, maybe. But this is a ground for refusal. Only Durga Puja and government functions. What is the similarity between Durga Puja and government functions?
Not government functions.
Only I can see only one similarity which I cannot say in open. Yes. But which I hinted at the outset. Yes.
Well, government functions, my lord, these are completely, my lord, functions, my lord, undertaken by the state.
Yes.
So these cannot be, my lord, objected to.
State cannot undertake any function.
My lord, the program
under the secular structure.
Under the my lord, programs, my lord, programs are made by the
state cannot sponsor a particular function, religious function.
But it's not festivals; it's other my lord, my lord, other my lord activities of the government.
Because it's secular, but this resolution is taken before that judgment.
My lord, so my lord, this judgment, my lord, it is my lord, judgment, my lord, it's there, my lord. So my lord, I can defend my stand.
Secular. Durga Puja is secular. Ganesh Puja is not. Explain why Ganesh Puja is not.
My lord, because as far as Durga Puja is concerned, there is a large, my lord, gathering of people, my lord, and as far as West Bengal is concerned, my lord, Durga Puja has a special significance. And that
cannot be a good ground for refusal. Although I cannot imagine Mr. Ganguly performing Ganesh Puja, even then it's not personal. He's representing somebody, must be.
Well, only from 18th to 21.
But Mr. Ganguly, the difficulty is this will open a floodgate.
No. But I am
Durga Puja, then Ganesh Puja, as I told you at the time of then Itu Puja will be done Barwari. I mean, it will be public function.
From my lord, I am
then
giving
these
an
brothos will
undertaking.
be done
Yes,
publicly.
my lord.
No. There has to be an end to it.
My lord, I am giving an undertaking from 18th to 21, my lord, 21st, my lord. My lord, we will, my lord, on 21st, there will be the immersion, my lord. We'll, my lord, dismantle the pandal on 21st.
Is this month, 18th?
Yes, yes. 18th to 21st.
And obviously, you'll abide by all the other laws and
everything.
I'll give that.
All permissions, my lord, I'll be
my submission. Lord.
Oh, definitely.
Because I'll hand over, my lord, this.
Yes, side
can
that
I
also.
get a copy of the?
But I rely on.
Yes.
1994 6 SCC, my lord. Paragraph 78, my lord. Of this judgment.
Ismail Farooq, yes.
Oh, Pradikshita.
Right. Para 77, right.
77 and that part is in 78.
Yes, right.
Effect of 25,
True,
Article
true.
25. Page.
I got it. Yes, you have marked it actually. You were there in this matter.
360.
For the state, my lord, my instruction is this is my instruction. If they apply, we'll consider that in accordance with law.
They have applied.
Yes.
They have not
No,
applied.
my lord, unless and until I get
See.
the ground, my lord, I can't.
The last paragraph, basically.
My lord, and your lordship's judgment, my lord. Paragraph 38.
Yes.
Paragraph 38.
Yes. Learned counsel for the petitioner contends that the respondent authorities, being the Asansol Durgapur Development Authority, refused permission to the petitioner to observe the occasion of what is the Siddhi Vinayak Puja? What
No,
are
my
the-
lord, Ganesh.
the occasion of Ganesh Puja on a particular plot, which is a public plot belonging to the ADDA. Full stop. Next para. It is argued that the ground on which the permission was refused was dehors the law and the fundamental rights of parties. Full stop. By placing reliance on the same comma, it is argued that the Adda authorities held that in a meeting dated December 9, 2022, it had took a decision that henceforth the permission for using the said open space shall be restricted only for conducting government programs and for Durga Puja with requisite permissions from appropriate authorities. Full stop. Next para. Next para. Learned counsel further submits that there is no reasonable distinction between the Ganesh Puja and the Durga Puja or other government programs insofar as public properties are concerned. Full stop. Next para. Learned counsel appearing for the Adda authorities cites Ismail Farooqi versus Union of India, reported at 1994 6 SCC.
Page 360.
360.
360.
Page 360. Full stop. It is argued that as per the said judgment, there is no right to property under Article 25. Full stop. The right to practice, profess and propagate religion guaranteed under Article 25 of the Constitution, it was held, does not necessarily include the right to acquire or own or possess property. Full stop. Similarly, this right does not extend to the right of worship at any and every place of worship, so that any hindrance to worship at a particular place per se may infringe the religious freedom guaranteed under Articles 25 and 26 of the Constitution. Full stop. Next para.
Also in paragraph 78.
Yes. It was also held therein, as pointed out by learned counsel for the Adda authorities, that while offer of prayer or worship is a religious practice, its offering at every location where such prayers can be offered would not be an essential or integral part of such religious practice unless the place has a particular significance for that religion so as to form an essential or integral part thereof. Full stop. Places of worship of any religion having particular significance for that religion, to make it an essential or integral part of the religion, stand on a different footing and have to be treated differently and more reverentially. Full stop. Next para. Learned counsel also hands over a copy of the decision taken by the Adda authorities, which has been cited in the refusal dated August 14, 2023. Full stop. As per the said resolution, the board decided that henceforth the permission for using the open space in question shall be restricted only for conducting government programs and for Durga Puja with requisite permissions from appropriate authorities. Full stop. Next para. Learned counsel also places reliance on an unreported judgment of this court in WPA 17704 of 2023, within bracket, Manav Jati Kullan Foundation and another versus the state of West Bengal and others, comma, where it was held that in the context of Durga Puja, comma, which was also similarly sought to be organized, comma, the court observed that Durga Puja festival has a semi-secular nature, comma, for which the reliance on Article 25 was misplaced. Full stop, next para. As distinguished from the said case, comma, it is argued that Ganesh Puja, comma, at least in West Bengal, comma, does not have a significance of the magnitude of a Durga Puja festival, comma, the latter being much more inclusive and widespread. Full stop, next para. Learned Counsel for the state hands over a written instruction and submits that the state is agreeable to consider the application for the petition by the petitioner, comma, if so made for the purpose which is the subject matter of the present writ petition. Full stop, next para. A perusal of the justification of the refusal by the Adda authorities in the present case indicates that the sole ground for refusal was a resolution by the board that permission for using the open space belonging to the Adda, comma, which is a public authority, comma, was that it would be restricted only for conducting within double inverted government programs, government G capital, double inverted close, and for within double inverted Durga Puja, double inverted close, with requisite permissions from appropriate authorities. Full stop, next para. The question which arises in the present case is more fundamental than Article 20, than a restrictive approach towards Article 25 of the Constitution itself. Full stop, next para. Learned Counsel for the Adda authorities may or may not be justified in arguing that Ganesh Puja festival is not so widespread and does not have a secular and composite nature as a Durga Puja festival in the state, comma, even apart from such secular aspect of the matter, comma, there are other considerations which are germane in the present case. Full stop. As per the ratio in the cited judgment of this court, comma, although Ganesh Puja may not be a semi-secular festival insofar as West Bengal is concerned as of date, comma, the issue herein is not of violation of Article 25 of the Constitution, but of Article 14 of the Constitution of India. Full stop, next para. A perusal of the relevant paragraphs of the judgment of Ismail Faruqi versus Union of India Supra clearly shows that the entire consideration therein was in the context of Article 25. Full stop. In paragraph 77 of the same, comma, the Supreme Court went on to observe that the right to practice, comma, profess and propagate religion guaranteed under Article 25 of the Constitution does not necessarily include the right to acquire or own or possess property. Full stop. More importantly, comma, the Supreme Court held that the right does not extend to the right of worship, double inverted with the right of worship, at any and every place of worship, so that any hindrance to worship at a particular place per se may infringe the religious freedom guaranteed under Articles 25 and 26 of the Constitution. Full stop, next para. The Supreme Court went on to observe that while offer of prayer or worship is a religious practice, comma, its offering at every location where such prayers can be offered would not be an essential or integral part of such religious practice unless the place has a particular significance for that religion, or as to form an essential or integral part thereof. Full stop, next para. In the present case, comma, undoubtedly, comma, the petitioner has not made out any case that the property where the petitioner proposes to hold the Ganesh Puja has a particular religious significance for the performance of the worship in question being Ganesh Puja. Full stop, next para. It cannot, comma, by any stretch of imagination, comma, be said that the place in question has an essential significance or the worship of Lord Ganesh in the said spot is an integral part of the Hindu religion. Full stop, next para. The present consideration is not on Article 25 at all, full stop. Hence, comma, the ratio laid down in Ismail Faruqi Supra is not germane in the present context. Full stop. The right claimed by the petitioner is one under Article 14 of the Constitution of India, comma, read with Article 21 of the Constitution of India. Full stop. The right to life, comma, which is vested in every citizen of India, comma, has a right to live with dignity and in proper manner, comma, which includes, comma, broadly, comma, the right of a person to practice his festivities and ceremonies as well, comma, irrespective of the component of religion therein. Full stop, next para. In the present context, comma, it cannot be said that the petitioner is otherwise precluded from observing Ganesh Puja even publicly, comma, subject of course to the petitioner not violating any other law or creating a public nuisance. Full stop, next para. The refusal of the Adda authorities is on the specific ground that the ground, comma, which is admittedly a public one, comma, has been restricted for conducting Durga Puja and government programs. Full stop. If Durga Puja is allowed, comma, which is also a festivity of Hindus, comma, there is no reason why festivities of other religions or the same religion, comma, be it of other idols, etc., or on other premises, comma, should not be allowed on the same. Full stop. The differentia sought to be projected by the Adda is not intelligible at all, comma, to come within a reasonable classification within the contemplation of the body of laws regarding Article 14. Full stop, next para. More absurd is the equation of government programs with Durga Puja festivities. Full stop. There is nothing in government programs per se, comma, which can be put on an equal footing with the occasion of Durga Puja ceremony, comma, more so in the present context. Full stop. If Durga Puja can be said to be on an equal footing with government programs, comma, there is no plausible reason why Ganesh Puja or some other performance of public religious activity should not come within the purview of the same. Full stop. The petitioners seek to hold and organize a Ganesh Puja, comma, which has a public facade and is not an exclusive private family affair. Full stop. As such, comma, the petitioner is justified in citing Article 14 of the Constitution of India on the ground of equality before law, comma, for the present purpose. Full stop. In view of the above discussions, comma, the decision of the Adda authorities to refuse permission to the petitioner on the grounds as enumerated in its communication dated August 14, 2023 are palpably absurd and dehorts Article 14 of the Constitution of India. Full stop. In such view of the matter, comma, WPA 21235 of 2023 is allowed, comma, thereby directing the respondent number
respondent number
five. 4 or 5. Respondent numbers, I'll put it on both. Respondent numbers 4 and 5 to grant the necessary permission to the petitioners to perform Ganesh Puja on the plot in question, comma, subject to the petitioners complying with other due formalities in law and obtaining the requisite permissions. Full stop. It is, comma, however, comma, made clear that nothing in this order shall give a charter to the petitioners to violate any law or create a nuisance in the name of Ganesh Puja on the said plot. Full stop. As per submission of learned counsel for the petitioner, comma, it is made further clear that the festivities in question shall be observed by the petitioners within September 18, 2023 and September 21, 2023 and by September 22, 2023 the respondents shall make all endeavor to hand over vacant position back to the Adda authorities.
Petitioner,
Petitioner, I'm sorry. The
My lord,
petitioner.
there are two rejections letters, my lord. Kindly, my lord, mention that, my lord, later dated 14th August 2023.
Yes.
As well as later dated 10th August 2020.
Same ground.
Same ground.
It was reiterated on the next.
No, 10th, no. 27/6/2023 and my lord 14th
একটা জায়গায় August 14 বলেছি ওখানে and
27/6/23.
June 27, 2023. Thank you.
Deeply appreciated.
Thank you. এটা ফেরত।
Can I get an urgent your certificate?
It will be on the server today itself. They are present.
Mal.
এটা ঢুকে।
I am for the petitioner.
Yes. What is the challenge?
My lord, it's not about the challenge, my lord. The petitioner is accused in a case which is bailable in nature. Now, the opposite party to that, my lord, case is a learned advocate of a particular, my lord, bar association. Now, my lord, since the case is of bailable in nature, when I was arrested on that very date, I was granted bail. Now the bar has taken a resolution that no one will appear, no one will give surety, no one will give anything. I will not allow to, my lord, get the certified copy. My lord, so, my lord, even after getting bail, I am still in custody. Now, my lord, I cannot furnish bond, I cannot do anything, my lord. Even I am not getting the certified copy, so that I can, my lord, approach the higher court in the criminal forum. So, my lord, my only prayer is that my lord, my lord, the bail bond to be changed as the PR bond, so that I can be released, and my lord, to withdraw the resolution of the bar association that I have annexed as page 14.
The first order, can I pass in writ jurisdiction?
Yes, my lord, because
yes,
my lord, in appellate side, to apply in the criminal side, my lord, I have to obtain the certified copy, and then only, my lord, I can approach the my lord, there. My lord, since, my lord, resolution is that I cannot do anything, my lord, because the law clerks association also given the resolution that they will not perform. No one will perform. So, my lord, the question of my liberty is involved here, and my lord, my right to have the judicial my lord, remedy that I have, that also I am not getting. So, my lord, on the question of liberty and, my lord, the right to have the judicial, my lord, the statutory right I am having.
You've already obtained an order of bail.
Yes, on that very day, my lord, because it's a bailable offense. But I cannot come out because of that only. My lord, kindly change that to a PR bond. My lord, then, my lord, I can come out, and, my lord, to the bar to, my lord, withdraw the, my lord, that kind of.
You're appealing for the bar?
No. I'm for the state only.
What is the service on the bar?
My lord, bar within 1 day, my lord. Yesterday I take the, my lord, liberty, and I have served only the state. My lord, the bar
could not be served.
But cannot be, my lord, because it is.
But I want to give a direction on the bar itself. What can the state do actually?
My lord, it is a
state has no control over the bar.
My lord,
should not also have. Yes.
My lord, second issue, my lord, kindly keep it. And, my lord, so far the PR bond, my lord, as an interim measure, my lord, kindly allow me so that I can at least come out from the jail. Even after having getting bail, my lord, I am not getting that.
Where is the bail order?
My lord, I am not getting the certified copy on that very.
Where have you stated in the writ petition? Yes. Regarding the bail.
My lord, paragraph 8.
8, yeah. Yes. Due to extreme urgency in the matter, comma, as the petitioner is behind the bars despite having got an order of bail from the trial court, comma, the matter is taken up for hearing without prior service on the respondent number 2, comma, the concerned bar association. Full stop, next para. The petitioner and the state are represented through counsel. Full stop. The matter is being considered for interim orders. Full stop, next para. The petitioner alleges that the petitioner has been arrested on a bailable offense, and was granted bail by the criminal court concerned, comma, on August 29, 2023. Full stop. However, comma, since what sort of bail was granted to you?
Malad, I have to give surety to that. Malad.
But since the bail was granted on certain conditions, comma, which could not be fulfilled due to the non-cooperation of the local bar and the clerks association, comma, the petitioner is still in incarceration. Full stop, next para. Accordingly, the petitioner seeks to be released in terms of the order of bail on personal bond. Full stop, next para. It is also submitted that since the complainant and alleged victim is an advocate of the concerned bar association, comma, the local bar association as well as the clerks association are unwilling to take up the matter of the petitioner and have taken resolutions to that effect. Full stop, next para. It is argued that the petitioner's fundamental right to get justice is being hampered due to such resolution. Full stop, next para. The petitioner has made out a strong prima facie case for hearing of the writ petition on merits, comma, since the right to have access to justice is implicit in Articles 14 and 21 of the Constitution of India. Full stop. Right to equality before the law includes the right to have proper access to justice and have legal assistance for being represented before a court of law. Full stop. Article 21 confers the right to life, comma, which also includes the right to freedom, comma, which is being denied to the petitioner apparently due to no fault of the petitioner, to the extent that the petitioner has already obtained a bail, but due to no personal bond having been made a condition thereof, comma, the petitioner cannot avail of such order. Full stop, next para. As such, the respondents shall file their affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Full stop. The interim relief sought in clause small e of the prayers of the writ petition is granted, comma, thereby directing the petitioner to be released on bail upon furnishing personal bond. Full stop, next para. Although the court is aware of the fact that the present order, in a sense, tantamounts to modification of the order of bail passed by the trial court, comma, since the petitioner has alleged that the petitioner is not even getting certified copies of the concerned order and or having access to the concerned court, comma, the said order is being consciously granted, comma, to ensure that the petitioner, comma, who is armed with an order of bail, comma, gets the fruits of the same. Full stop, next para. The concerned criminal court shall ensure that the petitioner is accordingly released on bail upon furnishing personal bond to the satisfaction of the you have been arrested.
Yes.
So it has to be to the satisfaction of whom?
Of the learned court, because he has been produced before the court.
Very well.
Court has
To the satisfaction of the trial court.
The jurisdictional magistrate.
To the satisfaction of the jurisdictional magistrate. Full stop. All parties, including the trial court and the jurisdictional magistrate shall act on the communication of the learned advocate for the petitioner, coupled with a server copy of this order, without insisting upon prior production of a certified copy of the same. The writ petition shall be listed for hearing in the monthly list of October 2023. মেঘনাদ এটা টাইপ করে আগে করতে প্রথমে সই করে আপলোড করে দিতে যাতে পেয়ে যায় আজকে না এটা আগে এটা করে এটা আলাদা করে আগে আপলোড করে দিই তারপর অন্য
original side matters. Any mentioning?
May I, my lord? My lord, we were taught, my lord, some matter we should not mention. But due to, my lord, the anxiety of the client, my lord, I'm mentioning, don't take it amiss, my lord. I also know, my lord, lordship's workload. My lord, this matter, my lord, which involves, my lord, a date of 350 crore. Lordship, the matter was CAV on 17th August. And, my lord, the date before the NCLT is 18th September. So, my lord, again, my lord.
What is that? What is that matter?
This is the matter, my lord. I have mentioning on notice.
Sale of the loan exposure of the client.
Lordship hard it extensively, my lord.
Sale of the loan exposure, my lord.
Has been assigned to me. I am the
By asset recovery company. By a bank to an AS.
What was the interim order made by you?
Well, the interim order, there is an order of stay operating, my lord, from in respect of taking up the matter before the NCLT. So that is the problem.
The interim order is till 15th of.
No, I cannot do it before 2 weeks now. Why did you mention today? Why didn't you mention earlier? That's a thickish sort of thing.
Yes, yes.
No, not possible. Who are you? You are for the?
I am for the respondent number 2. I am for the respondent number 2.
Yes.
My lord, his date, my lord, the date, his date, my lord, assigned to me by the bank.
Yes.
No, my lord, I have filed an application before the NCLT. As a matter of fact, bank has filed. My lord, I have filed, my lord, an application for substitution in place of, my lord, State Bank of India.
Yes.
This is the case, my lord. So, my lord, my judgment has already been, lordship has reserved the matter for judgment.
Yes. So what is the urgency of?
My lord, 18th September is the date before the NCLT.
NCLT date for what? I mean, clarify.
Well, there is an interim order passed by your lordship.
Yes.
By
yes.
virtue of that, my lord, there is, my lord, a stay operating in respect of the say section 7.
Stay of the NCLT matter also.
Yes, yes, yes.
Fine. So the next date is fixed on that date. It will not proceed since there is a stay.
Well, that is my that is the thing I am sub.
Court is not sitting from Monday.
The interim order is till 15th of September.
Court is not
So extend the interim order.
Oh my God. In my mentioning, you will extend.
As it is, yes.
So we try our luck before the.
Yes.
Lordship, don't take it.
My lord.
No, no. Yes.
I mentioned just item number 8, your lordship has kept it a stop to submit the written notes of argument. My lord, it is ready. Can I file it by 4? I have prepared it. My lord, just check it and submit.
By 4 o'clock?
By 4 o'clock today.
Sure, sure. Why not?
My lord, I have just got another point also. Section 10 of the West
So we'll
Bengal.
consider when 8 is called on. If I don't call it before that time, before
I shall file it by 4, my lord.
I am for the respondent number 3 in this
keep
matter.
somebody if I call it before 4. If I
Yes.
don't call it before 4, mention before I rise and file it. Yes, yes.
Deeply obliged.
Call. Yes.
For judgment, item number 1, Messrs. WPIPL IL Limited versus
Thus,
State Bank of India.
WPO 2429 of 2022 is disposed of by directing respondent number 5 to refund the amount of rupees 19 lakh lying in the destination account of the Dalhousie branch of the Yes Bank at Kolkata, bearing account number. I've given the account number 0190511405067 to the petitioner within 3 weeks from date. Liberty is granted to the petitioner to take appropriate steps against the respondent number 1 bank by way of a civil suit and or other competent forum as well as before the criminal court for addressing the grievances of the petitioner with regard to alleged fraud as well as for recovery of the balance amount transferred erroneously by the SBI to the destination account at Yes Bank Dalhousie branch. No orders to cause urgent settlement. এটা সই করছি না কারণ লাস্ট পাতাটা চেঞ্জ হবে করে গিয়ে ওখানে গিয়ে করব
Item number 2 and 3, Gauri Prasad Goenka versus State Bank of India and others.
Lord, before my learned friend begins, the supplementary affidavit in these two matters, I've checked. Lord, this was. Oh.
No, I had returned the supplementary affidavit,
Yes,
but
yes,
it
I
went
take-
down in the order.
Yes, I taken it back because.
I'll rectify that portion of the order. Yes. Yes.
No, I'm filing it today.
No, I refused it because the hearing was at an advanced stage probably.
No, but there was no refusal. I wanted to tender it saying that these contain all legible documents of.
Oh, that.
And then I was told that there are certain new documents. Your Lordship said that you take it back and you look it up. I've looked it up. Your Lordship might as well still retain it.
No, yes.
But the only thing is this has some new documents, but these were served in advance before the hearing commenced. This
No,
was
at
served
the,
on
at the hearing of the matter, no, Mr. Banerjee.
16th of August, before the hearing commenced, we had served it. Nothing
No.
was submitted on that body. No, we have not referred to it in course of our submission. Whatever is referred. I can do it in course of reply.
No,
but then I'll have to
not in
reply
course
to
of
that.
reply. Mr. Banerjee did not submit on that at all during your first argument. Now he's in reply. At this stage, why should I permit you to put
That is
in?
true.
Yes.
But with regard to Srivardhan Goenka's matter,
Yes.
certain points regarding jurisdiction, because of whether I was a promoter or not, that was argued. There are certain documents here which will show that we were not promoters. Now, these documents were given to them before the argument was advanced. Now, if
No,
we
in the arguments, this was never argued. No.
this was never shown. That is true.
Not argued. This point was never argued.
Well, Srivardhan was not even actually argued before your Lordship. But because he has started arguing, so therefore Srivardhan was argued. Not argued is.
No, both the matters arguments were taken up together. Yes, you argued on both the matters. Yes.
But second. We
All
had
along,
just-
both the matters are appearing.
Correct. So we had just, I'm told that we had very briefly given the points in Srivardhan matter. But let it be. I had not shown any of the documents in the supplementary affidavit. It's true, but the supplementary affidavit was served in advance. In course of reply, if my learned friend had said they could concede on that point. If he concedes, that's fine. But if he wants to show some document to show, because that is also not there on record.
No.
If he wants to show some document that I am a promoter, then your Lordship will allow me to just highlight in respect of Srivardhan these documents. Lord, then let them show that document, Lord, so that I can reply on that, Lord, because if something was served upon me, not pressed before your Lordship, not shown, Lord, why will I, my Lord, go through those documents, Lord, which are not relied upon?
No, you won't rely on any new document in your argument.
Definitely, because I am in reply, my Lord, because.
You'll rely on new documents which are not on record.
Yes, my Lord, not in the writ petition, Lord, because they have not annexed that in the writ petition, Lord. Those are our documents, Lord, which will have to
Affidavits are
bring-
directed in this matter.
No.
Then Mr. Rai will allow them. Yes.
Affidavits have not been directed. Lord, then in that case, Lord, let them make their submissions on that, Lord, because I need to counter it. I can counter it only, my Lord, if something is submitted on it, Lord.
True.
Document, my Lord,
In
submitted.
reply, Mr. Banerjee, this will never end then. If you
That's
don't
true.
submit
That
on
is
that
true.
in reply, you cannot.
How will we? Correct. That is
No.
absolutely right.
Yes.
So,
then the entire arguments have to be reopened from this section.
no, only thing is then, my Lord, if he can conclude with regard to GP Goenka today,
Yes.
and for Srivardhan Goenka, Lordship will keep it any other day. He has a copy of the supplementary affidavit. We'll just show from those two documents because it's a jurisdictional fact. Lord, then let us come back, Lord. Then let us
I think
come
that
back,
will be
Lord.
easier.
Lord,
Yes.
that way,
So
my
I'll
Lord,
take that supplemented affidavit on record.
Yes,
I'll give you liberty to use.
because I'm not having that supplementary.
No.
today,
It is not done in this fashion.
Very
Mr. Rai, then you use your opposition to that supplemented affidavit. I'll give you that liberty. In that, you annex whatever documents you want to. Because you
But
can
I have
also
not-
now annex documents.
I have not used affidavit to the main writ petition also, my Lord, and I have proceeded. Affidavits have not been directed in the main. My Lord, let them rely on the supplementary, my Lord, if need be, my Lord, if your Lordship considers.
So it is not done in this fashion. Then I'll direct affidavits in the matter. I'll hear the hear.
Lord, the interim order is continuing. That is the problem.
What is the interim order? Yes.
Lord, that we will not act on it. Anyways, my Lord, the publication part, my Lord, it happens with the order. My Lord, photograph publication, your Lordship will interdict the photograph publication. We are not doing. The order was, my Lord, I'll just indicate. First committee as well as the respondent shall remain restrained till August so and so from acting upon or giving effect to the impugned orders. So this will mean sending it to CIBIL. The only protection I have is this, they'll not send it to CIBIL or any of these credit. Sent, my Lord, with the passing of the order, my Lord, because that we don't know. But I
Civil
know
sent
that
immediately. I'll just
publication
check
of
up
photo.
the original order passed. Yes, the
Yes,
first,
Manoj.
yes. What is the date?
This is 8th of August, 2023. At page 2, the interim order is there.
No, at this stage, Mr. Banerjee, then I'll not permit you to file a supplementary evidence. After review committee, no.
Very well. Malad, only thing is that because affidavits have not been completed, I understand it will get very cumbersome in how we are trying to do it.
Or we may do this. I mean, Mr. Banerjee, I may vacate the interim order and exchange your affidavits.
Your lordship
Yes, because this does
that's
not
true. It doesn't end
take us anywhere. No.
So
no,
it doesn't, lordship, let it be now. Let him complete. Then before he files his affidavit, I'm sure he'll take some time to file his affidavit. If he doesn't want to file an affidavit, then the test will
No,
be different.
Mr. Rai, you go through these documents. If you have any anything to counter, any documents to produce, if those are, if those are disputed documents, I'll have to direct affidavits in. Otherwise, I'll direct you to produce your documents. Give your copies also to them.
That's it.
So exchange whatever documents you have to
Very
annex.
well.
Yes. Sure. So hand over those supplementary evidence today. That is already recorded. It has been recorded to be on record. Yes. একটা order pass করছি একটু note করুন। It was erroneously recorded on September 6, 2023 that supplementary affidavits filed in court today that date were kept on record, whereas the said finding was due to inadvertence, as there was a doubt as to whether the petitioner seeks to incorporate certain new documents as well, along with legible copies of documents already annexed, for which the affidavits were returned on that date to the petitioner. Full stop, next para. When the matter is called on for hearing today, the petitioner, learned counsel for the petitioners in both the matters contends that the documents primarily pertain to both the matters, but there are certain required to be produced before the court for proper and complete adjudication of WPO 1488 of 2023 in particular. Full stop, next para. Learned counsel for the respondent bank submits that the said documents were never relied on by the petitioners during their opening arguments. Full stop, next para. The question which has been sought to be primarily dealt with by the petitioners in the supplementary affidavits also pertain to the pertain to the issue as to whether the petitioner in WPO 1488 of 2023, namely Srivardhan Goenka, was a promoter of the defaulting company at all. Full stop, next para. Since such issue might have a relevant bearing on the adjudication of the writ petition, the supplementary affidavit sought to be filed by the petitioners is taken on record and accepted. Full stop, next para. Learned counsel for the State Bank of India is granted some time to peruse the said documents. Full stop. In the event the bank has any dispute regarding any of such documents, it will be open to the respondent bank to canvass such arguments in their reply. Full stop. If necessary, the respondent bank will be eligible to produce further documents, in controverting the said limited issue at the time of giving its reply. Full stop, next para. Mr. Rai, since I have not directed affidavits in this matter, I won't put in anything in this order to permit you to produce new documents. If you want to file new documents, then we'll have to consider. Then affidavits maybe have to be directed. Or you have 2 weeks. Would you like to exchange your affidavits in the meantime?
Lordship directs me.
Let them use that supplementary affidavit.
Or because he is there, I don't mind him giving me a copy of those documents also, and we can look into it. Your Lordship being so kind to us, he's also very fair. I don't have a problem
So
with
up
that.
to this, it's all right, Mr. Banerjee. If
He
they
can
want
just
to
give it to me, my lord. I will.
if they want to
Yes, yes, that's up to him. But
yes.
for his convenience, we want to
If
just
you
give
have
us the
those documents, Mr. Rai, would you be able to do it within 1 week?
Lord, 10 days, your Lordship will
Difficult,
give me,
yes. So I'll give you 10 days. Suppose till today we are on 8th. I'll give you till say 19th, 18th. Would it suffice? If that be so, I'll take it up after 1 week thereafter. Then যা লিখেছি সেটা থাক। Over and above, comma, the respondents are also directed to file their comprehensive affidavit in opposition to the writ petition within September 18, 2023. Full stop, reply if any shall be filed on the next returnable date with advance copy to the learned advocate for the respondents. Full stop, the matter shall next be listed on September 25, 2023 for hearing.
Great.
Come on.
I'll give it to him by the 24th.
Yes. I've not given it dates.
No.
Between you and Mr. Rai, no, definitely. Not only you, Mr. Shah also. I mean, you.
Grateful.
Yeah, thanks.
Grateful. My lord, then I'll use affidavits, my lord, in both the matters. Otherwise, my lord, it will.
Affidavit যেটা বলেছে এটা plural করে দেবেন।
Yes, my lord, because it will be deemed, my lord, as if. No,
Yes, yes.
all that we will not. It will be cumbersome for me, but anyway, my lord,
For you.
yes, my lord, drafting, my lord, appearing for.
What do you mean cumbersome for you?
My lord, appearing for institutions itself is a cumbersome.
It will be cumbersome for everybody. The size of the documents which you are threatening the court with. I mean, yes.
Grateful.
Grateful. For hearing, item number 4 to 7.
Yes.
No, this was concluded. This was a scheme, PSC. We were to give a written.
Mr. Chatterjee is there, my lord, online. Perhaps, my lord, there is
But
some.
I am there online, but I can't, my lord, the video is not working for some reason.
Yes. You can make you can make
My lord,
faces.
yes, my lord. No, my lord, I don't have any reason to do that.
Yes. Yes.
My lord, just gives us a little bit of time, my lord, to use our my lord, notes of argument. Your lordship is anyways probably not here for 2 weeks, if I'm not mistaken, my lord.
No, you're not mistaken.
Give us a little bit of time, my lord. It will be ready,
I'll
my lord,
put it on September 25th on the date when I next see.
Yes, my lord. Yes, my lord.
Filing your written notes now. That is only left.
That's the only left.
That's
Fair. The time for filing written notes of arguments is extended. The time for filing written notes of arguments is extended till September 25, 2023, when the matter shall be listed at the top for such purpose.
Grateful.
Extremely grateful, your lordship.
Thank you, Chair. এটা টপে দিয়ে দেবেন।
Item number 8, Sunny Rock Estates and Developers.
Not ready as yet.
My lord, it is ready. Only minor corrections are there. By 4, I can submit, my lord. Just only one thing, my lord, I would like to highlight.
My lord, my notes of argument is ready.
Ready? You can file it.
It is ready only, my lord, only just minor correction. But only one thing I would like to show to your lordship.
Yes.
While preparing the notes, I came across section 10 of the West Bengal Building Regulation of Promotion of Construction and Transfer by Promoters Act 1993. Lord, kindly just, I'll give my friend also a copy of
That's
this.
a new argument. They have to meet it also
So,
then.
which clearly says that it has to be either cooperative society or owners association.
No, keep it
That
with you.
has been repealed, my lord. Promoters Act. That act has been repealed, my lord.
No, you are entitled to give an answer to that then. Then I'll put it on 25th with the other.
If it is repealed, I have to check, my lord. Then I'll not include that.
In my
I'll
understanding,
delete
that has
that
been
from my argument. I'll delete that from
So then I cannot close arguments today.
my lord, I'll delete that from my argument. I'll delete that. I'll submit by 4 today.
Wait. Written notes of arguments filed by respondent number 3 today be kept on record. Full stop. Learned counsel for the petitioner undertakes to file the petitioner's notes of arguments during the course of the day. Full stop. Granting such liberty to the petitioner, comma, hearing in the matter is concluded and the matter is reserved for judgment. Yes.
Petition. Yes, sir. Contempt matter.
Madam, I am for the petitioner.
Item number
Madam,
9.
I am for the alleged contempt. Pursuant to your lordship direction, I have served the copy of the contempt application upon the contemptness.
My lord, what happened, my lord, after my lord has passed this order, the private respondents preferred an appeal, my lord. My lord, this is the order of the appellate court, my lord.
My lord's order has been affirmed by the appeal court.
No, my lord, yes, it is affirmed, but in addition to that, they have been asked, my lord, kindly cease. my lord, the page 4, my lord, probably
Yes.
I am turning to the penultimate page.
What was the order by the way?
My lord.
My lord's order was very clear, my
My
lord.
lord,
Page 2, internal page 2 and 3, my lord.
No, what was the nature of the order? I mean,
Nature of the order, the bank may give the money to the claimant, the petitioner, subject to satisfying, complying with the bank's formalities.
What was the modification, Mr.
Modification, in addition to that, you have to furnish one, my lord, indemnity bond.
Right. Yes.
Only the indemnity bond, my lord.
That in addition to my lord's order,
My lord,
not
may
in
kindly-
derogation.
Kindly see the order.
Page 4, yes.
Page
actually.
4, last
Yes.
paragraph.
Yes.
In our view, the respondent bank is not justified in insisting a bank guarantee, but the respondent bank can insist upon execution of an indemnity bond by the first respondent writ petitioner, indemnifying the respondent bank from any claims that may be made by the appellant at a later
You have
stage.
given the indemnity.
But it is under preparation. Only thing, my lord,
Contempt does not lie then.
may I just indicate to,
Contempt was filed before this.
yes,
Oh,
before this.
yes, yes.
The private
What is-
respondent before the writ petition in the.
Should I keep this pending? If they
My
don't
lord, kindly
comply,
keep it
yes.
pending, my lord. In the meantime, I will comply with I will file the indemnity bond as per the appeal court's order. Let it be after 2 weeks, my lord.
Learned counsel for the petitioner Learned counsel for the petitioner submits that in the meantime, a challenge was preferred by the private respondent in the writ petition to the parent order of this court, of which contempt has been alleged, full stop. Vide order dated August 23, 2023, passed in APOT 258 of 2023, the division bench affirmed the order of this court and in addition, directed the petitioner to furnish indemnity bond for the purpose of disbursal of the concerned money by the respondent bank. Full stop, next para. It is submitted that the indemnity bond is in process of preparation and the petitioner seeks a fortnight's time for furnishing the same to the respondent bank, for compliance with the order. Full stop, next para. A copy of the order of the division bench is handed over in court today and kept on record. Full stop. Next para. Since the order dated August 23, 2023, directs the petitioner to furnish an indemnity bond as a precondition for the bank to release the amount, it cannot be said as of today that the bank is in contempt. Full stop, next para. Be that as it may, for the ends of justice, the contempt application is adjourned till September 26, 2023, when it will be listed under the same heading, full stop. It is expected that in the meantime, the petitioner shall furnish the indemnity bond in question to the bank and, if so furnished, the bank shall take all endeavor to disburse the money in favor of the petitioner at the earliest.
My lord, with the indemnity bond, we have also submitted on format also. On format, we have also submitted.
If they comply with that, then give them. Yes.
The format, the letters and other things are also there, my lord.
If they don't, they point out to the court on the next day.
My lord.
Well, only the indemnity bond has been directed by.
No, in addition to what my lord said. That is in addition. My lord, that
Well,
is the
my
mistake
lord,
they are making.
I will not say anything. If you don't comply, then I'll issue a rule of contempt.
No, my lord, we are ready to comply.
Then comply.
No, they are saying I will only fund indemnity bond, nothing else. My lord has said you have to comply with the bank's formalities. That apart, the Honorable Chief Justice, the Honorable Division Bench said that
no other document is
Reserve your energies for the next day, 26th. Both of you. Yes.
26.
September, আমি কি বললাম? 29 or 26 বললাম তো।
My lord, may kindly note that we have already handed over them all the formats and all.
No, why needlessly these things? Yes.
Lord, kindly pardon me for interrupting the proceedings. But item 8, I was to file a notes of argument.
Yes.
But it is not ready. But if your lordship gives me one more day, but
I cannot give you one more day, Mr. Rai, because I have already recorded that the petitioner, I've concluded arguments.
Yes, that your lordship already did it on the last occasion. Today was fixed for only filing of the notes of argument.
No, today itself. Today 8 was taken up.
Yes, my lord, your
It was
lordship had-
taken up. One of the parties, respondent 3, already filed their
Yes.
written notes.
I was-
Petitioner will file during the course of the day. I gave them the WOT.
That is what I was told.
And I've
My-
closed arguments also on
Yes,
this.
I have to file my note also.
Yes.
I don't want to argue the matter. I've already argued before your lordship, but I had to file a note on behalf of the state. But that is not ready. If your lordship gives me one more day, I can file it on Monday.
One more day is difficult, Mr. Rai, because I'll not be there for.
Yes,
the-
I know that.
Yes.
But if I could hand it over to your lordship's officer on Monday or Tuesday, if your lordship permits, my lord. Otherwise, it will go without a note on behalf of the state. Though my submissions were very short.
Could have kept somebody when the matter was called on.
My lord, I was coming, my lord. I was on my legs. My lord, I was coming. I'm sorry, my lord. I'm sorry.
Because then I'll have to refer to that notes of yours without that it being recorded to have been filed. I cannot do that.
No, I have not filed, my lord. I cannot.
You have not filed.
I
I've
have
not
not
recorded that in the order. The order has been passed in
Your
open
lordship
court.
will consider my submissions, my lord. That is all. And pardon me for not filing the note. That's all I'm saying, my lord.
You have made your submission.
Yes, I have made my submissions.
Yes.
Your lordship kindly considers that.
Yes.
Agreed.
Item number 10, Sanjay Prakash Bansal and another versus Reserve Bank of India now.
Yes.
10 and 11, my lord, I am appearing for respondents number 2 to 4.
10 and 11 both.
Before my learned friend commences, my lord, I should bring it to your lordship's notice. I'm challenging the maintainability because this is an order. The impugned order, my lord, is an order passed by the Willful Defaulter Identification Committee. Without going to the review committee, they've come forward. I'm sure my learned friend will place his case. I was only saying this, my lord, there are a few judgments of your lordship passed on that. I'm not favored with them today. If your lordship so commences to your lordship, my learned friend could start. But I would be beseeching your lordship to kindly allow me to come back with those judgments once. My lord. Otherwise, I have the.
In that even, my lord, keeps it after my lord returns.
Learned counsel for the year for which authority?
2 to 4, my lord. This is
Learned counsel for
You go
respondent
back.
numbers 2 to 4 challenges the maintainability of the writ petition. However, learned counsel submits that he is handicapped, being not equipped today with the relevant judgments in support of his propositions. Accordingly, on the prayer of learned counsel for the respondent numbers 2 to 4, the matter is adjourned till September 25, 2023, when it will be listed under the same heading.
I'm deeply obliged.
I'm grateful, my lord.
25. 10, 11, দুটোতে একই order করো। হ্যাঁ, 25th.
Item number 12, Mohammad Afzal Solanki alias Mohammad Fazal Solanki.
Yes.
I'm for CSC, lordship.
Yes.
দিচ্ছি।
আপনি আছেন?
Here for the petitioner?
No, I'm
Private issue.
বলুন তাহলে সেটা আমি প্রাইভেট
I'm for the private issue.
Yes. Yes.
এইটা ভুল লিখেছে।
First file the affidavit of service, then move the writ petition. Yes.
This is evidence.
Yes. What is the writ petition about?
Madam, led by Mr. Huda, he is on the way.
Mr.
Mr. Huda, he is on the way.
Yes, yes, start the one. Yes.
As with this,
Take your break, take your break.
Respondent number 5 took electricity.
5 to electricity. One
Why
to-
surreptitiously? Who are you? With regard to the property, who are you?
I am for the owner.
Respondent 5 is my lord tenant.
You are the owner.
I'm
They have a right to get electricity.
Not only that, it's civil.
Yes, Mr. Huda, your writ petition is rejected. First of all, landlord. Secondly, painting. Thirdly, electricity being objected to. These are the 3 grounds of rejection.
My another important aspect is that let my learned friend submit, that is a suppression of material fact also.
Yes. You're coming from which building?
Code 38, my lord.
No building. You're pretending. You're coming from which building?
These I'll pretend.
From which building? Tell me only.
Code 38, my lord.
Code 30.
Annex 7.
Very yes. What is the matter? Take your breath. Take your breath.
The writ petition, my lord.
First, Dr. Shara, tell me what has been suppressed.
Yes.
That they can
Suppression
answer
is
that
that,
also.
that so far the original consumer is in the name of Messrs. WS Carpentry. Nothing, no whisper is there. So far he says that the meter should be transferred in the name of the petitioner. But the actual meter consumer is the Messrs. WS Carpentry. This is the lordship. May I hand over?
So keep it with you. Let us hear Mr. Huda on that. Yes.
But there is no whisper in the averment in this writ petition.
Yes, Mr. Huda, what is the one?
Yes, my lord. The petitioner, my lord, is one of the owners, my lord, of the premises, my lord.
Petitioner is there?
Is one of the owners, my lord.
Yes.
In respect of the premises, my lord, wherein, my lord, this electricity connection, my lord, is required to be transferred, my lord. There are various spaces, my lord, in this premises, my lord, of which, my lord, it is not sure, my lord, as to for which space this particular electricity, my lord, meter is concerned, my lord. My lord, what has happened, my lord? This space, my lord, was purchased by, my lord, the petitioners, my lord, and his family members, my lord, in the year, my lord, 2020, in fact, September 2021, my lord. There is no, my lord, dispute with regard to, my lord, the ownership. My lord, after purchasing the property, my lord.
Please take your seat. Take your seat. There is no. Yes, yes.
After, my lord, purchasing the property, my lord, my name was muted, my lord. Everything was done, my lord. Now, my lord, we are originally, my lord, residents of Khidirpur, my lord. Now, my lord, the private respondent, my lord, who has actually, my lord, got this electricity connection transferred in his name, my lord, is one of my relative. In fact, my nephew, my lord, my own sister's son, my lord. Now, my lord, these people, my lord, the private respondent, his father, his brothers, my lord, are, my lord, the local residents of that area. My lord, this being the fact, my lord, since, my lord, these two premises required some renovation work, my lord, so we had, my lord, given them charge, my lord, to carry out the renovation work, and we would, my lord, frequently visit the premises, my lord. And, my lord, in one of the spaces, my lord, one of the, my lord, the daughter of one of the owners, my lord, Varisha Solanki, my lord, who is an advocate of this honorable court, my lord, also has a chamber. Now, because, my lord, of the month of Ramadan, my lord, she stopped going to, my lord, her chamber.
Because of?
Ramadan, my lord, Ramzan. So
Ramadan,
she stopped going to her chamber, my lord. And, my lord, the one of the brothers, my lord, who was, my lord, the eldest brother, who was actually carrying out, my lord, supervising the entire repair work, my lord, visited China, my lord. Lord, it is our contention that in the meantime, my lord, taking advantage of the situation, or, my lord, being in charge of the repair work, my lord, we have no clue whatsoever, my lord, how he could have obtained this electricity meter in his name, my lord, the respondent number 5, my lord. But, my lord, this was done. Apart from this, my lord, there are 3 other electricity connections, my lord. I have given, my lord, the particulars in the writ petition itself, my lord, which were also transferred, my lord, surreptitiously transferred, my lord, in the name of, my lord, either the respondent number 5, his mother, or his brother, or his father, my lord. For that, my lord, we applied before CSC, my lord, and all of them were, my lord, transferred in our name, my lord. After, my lord, going through the papers, documents, because we were called in their office, my lord. In the office, my lord, they had also appeared, we had also appeared, we showed our papers, they said, no, fine, you are the rightful owner, therefore we will transfer. So those 3 electricity connections have been transferred, except the subject electricity connection. But in the meantime, my lord, the private respondent, my lord, and his family members were claiming to be the owner of the property, my lord. Or rather, my lord, they were, my lord, projecting themselves as owner, my lord, before the tenants. We got to know about this, my lord. So we filed a suit before the City Civil Court at Calcutta, my lord. We obtained an order of injunction, my lord. Now, this was, my lord, hotly contested, my lord. My learned friend was there, my lord. They also filed, my lord, an application for vacating the interim order, my lord.
What interim order do you get?
My lord, restraining, my lord, both parties, my lord, to maintain status quo as to, my lord, the possession and nature character, my lord. So we were happy with that because we were in possession, my lord. Now, well, and before the court, my lord, then, my lord, the matter was finally heard. The injunction application was finally heard along with their vacating application, my lord. Their vacating application got dismissed. My application was allowed, my lord, by the civil court, my lord. They have, my lord, thereafter, my lord, they have filed another suit, or rather, my lord, the father of the respondent number 5 has filed another. This has been filed by them, my lord, against us, my lord, wherein, my lord, they claim to be, my lord, the tenants of the property. Lordship would recall, my lord, as I said, my lord, firstly, they were projecting themselves as the owners of the property. Thereafter, my lord, once the suit was filed, my lord, they came up with, my lord, manufactured rent receipts and said that we are the tenants. Everything was considered, my lord. After considering everything, my lord, the civil court, my lord, was pleased to allow my application and to reject their vacating application. Very interesting to note, my lord, that apart from this, my lord, the entire this family of the Lodhi family, my lord, one of the, my lord, brothers of the respondent number 5, my lord, also incorporated a company, or rather, my lord, shifted the registered office of the company, my lord, to the premises in question, my lord.
What are you seeking now,
Wherein-
Mr. Huda? What are you seeking
My
here?
lord, transfer. Because I am the owner, my lord, they have no, my lord, respondent number 5 has no connection.
As of
no,
today, there are 2 suits pending.
There are 2 suits pending, my lord, of which, my lord, their application, so far as their application is concerned, my lord,
They claim to be a tenant, you claim to be the owner, and you have obtained a status quo order.
yes.
So this is the current position regarding the litigations.
This is the current position regarding litigation, my lord, wherein, my lord, I had disclosed photographs and other documents to show, my lord, that they are not in possession of even an inch of the premises, my lord, not even an inch. Even today, my lord, I have photographs to show and videos to show, my lord, that the entire premises is occupied by me. They never were there. They are not there today, my lord.
IFSC, they were in occupation because they were given this connection by the distribution license.
That is what, my lordship will see my praise. That is the reason why in my representation also I have said,
Why should it be transferred to your name at this juncture during pendency of the suits? These are hotly contested suits. At this juncture, why should it be transferred in your name?
well, then, my lordship will
Do you have a single electricity connection in your name there? You have.
Yes.
Because others were transferred.
Others were transferred. Why only this was stopped, my lord?
That will be subject to the result of the suit, Mr. Huda.
No, my lord, lordship will kindly
Cannot be at
appreciate
this
this,
stage.
my
No,
lord.
no.
In my representation as well, my lord, I had said that I had not executed any document in favor of, my lord,
The disputed thing. They are claiming tenants, they may not be.
as of now, my lord, since my learned friend has not made his submission, my lord, we do not even know.
No, in the suit they have. In the suit, they have claimed to be tenants.
No,
You
that
said
is,
that.
yes, my lord, that is where I'm joining issues, my lord. In the suit, my lord, the first suit was in respect of, my lord, a 700 square feet, my lord, space in the first floor and a 800 square feet floor on the second floor. The second suit, my lord, is in respect of some portions of the ground floor. We do not even know, my lord, that this particular electricity connection is in respect of which space of the suit premises, my lord. Which space?
Electricity
We're not even
connection may
aware
not
of
be-
it.
Electricity connection need not be in connection in the context of a particular space. It has been given to that premises. They are in occupation of some portion of the premises.
They are
so they are
not-
entitled. Yes.
They are not in occupation of even an inch, my lord.
That's disputed. You did not get any. What was the injunction sought by you? Did you ask for them not to restrain them not to disturb your possession?
Yes.
Show me.
Lord. Lord, will kindly, my lord, give me some.
And
time.
even if you did that, you have obtained only an order of status quo. So there is nothing on record to show without doubt that they are not in possession. Rather, they have obtained an injunction in their tenancy suit.
No, they have not.
Anyway, this tenancy suit.
They
is
tried
pending.
to. In their second suit, my lord, they tried to. The court did not give them.
Did the court hold that they're
No,
not?
the reason being that we were on caveat. So the court said no.
Court did not ever hold that they're not in possession also.
Lordship will kindly.
No, prima facie they're in possession. That's why connection was given. Mr. Huda, there is no scope of
My lord.
transferring it to your name when the titles are disputed. No.
My lord,
their occupation is there. They're
Lord,
entitled.
there were twofold, my lord, prayers in my representation as well as this writ petition, my lord. One being, my lord, that the electricity connection be transferred, my lord, and second, my lord, that since I have not executed any document in their favor, but they must have submitted some documents before the CSC, my lord. Otherwise, my lord, the CSC could not have, my lord, given a connection in their name, my lord. So I have asked for, my lord, those documents to be produced. What are those documents?
You're not entitled. No.
But not even the documents, because we filed an RTI application, my lord. CSC said that no, CSC is not under, my lord, the RTI Act, my lord. Therefore, my lord, that prayer was, my lord, not granted. Understood, my lord. But at least in, my lord, in this proceeding, my lord, let a report be filed by CSC, my lord, in the form of an affidavit, my lord. Let them at least show what are the documents that they had disclosed, my lord. Because see, my lord, X, Y, and Z, my lord. If today I go and say, give me electricity connection in the name of Victoria Memorial, my lord, the first thing that CC will tell me, show your, at least you must be a tenant or a lessee or a lesser or an owner of Victoria Memorial. Otherwise they cannot. So in this case, my lord, they must have shown some documents. They must have submitted some documents, my lord. What are those documents, my lord?
Somebody else, a third party may obtain that electricity connection in Victoria Memorial, Mr. Huda, but the owner of Taj Mahal cannot come and say, show me, disclose me those documents.
No, but I am the owner of Victoria Memorial.
No, you say so.
No, my lord, there is no dispute with regard to that. Ownership, there is no dispute, my lord. Lordship will,
civil court, we have
Lordship will
filed
kindly.
Let us hear them, yes.
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 in civil court, we have filed our copy of tenancy deed as well as the electricity bill and the trade license also in the civil court.
Do you have copies of those?
Yes, ma'am.
Any of those? Yes.
Yes, ma'am. But Xerox copy.
Xerox copy, I'll keep one on record.
At least the documents that they had, my lord, submitted before the CSC, my lord. But I'm sure, my lord,
yes,
the cat would be out of the box, my lord, if they produce those documents, my lord. Why are
out of the box, out of the file?
My lord, why are they shying away, my lord, from producing those documents that they had submitted before the CSC, my lord?
File. We are contesting there.
You have a provision of discovery, inspection, interrogatories in your civil suit. Do that.
No, but my lord, this electricity connection is not, my lord, in respect of that civil suit, my lord. But you will kindly appreciate that, my lord.
Not the same building.
It's the same building.
Then?
But my lord, there are various electricity connections in that building. Various electricity connections in the name of various persons, my lord. Lordship only, my lord. Lordship
No remedy here, Mr.
Lordship will, otherwise I am left with no remedy at all. But do I not have the right, my lord, to know, even if he's a tenant? Say, for example, my lord, he's a tenant, he's in occupation. Do I not, my lord, as an owner, do I not have a right, my lord, to at least, my lord?
Yes, you have a right under Order 11 of the Code of Civil Procedure in your suit. Nowhere else.
In the suit, my lord, they are not even claiming, my lord, that they have electricity connection in
sir,
their name. They have not even disclosed the bills, my lord.
Yes.
No, just now I have already submitted that the actual initial consumer was in the name of WUS Carpentry, not the petitioner even. Now petitioner is seeking for.
So they have purchased the property.
Yes, my lord. How do we know that?
Acha, একটা order record করুন. Learned counsel for the petitioner contends that the petitioner purchased the property in 2021.
1st September 2021.
On September 1, 2021. Footstep thereafter, certain repair works were being undertaken, comma, the charge of which was given to the private respondent number 5 by the petitioner, comma, since the private respondent number 5 and his family are relatives of the petitioner. Footstep, however, comma, taking undue advantage thereof, comma, the private respondent and his family obtained electricity connections at the premises and started giving out that they are the owners of the property. Footstep next para. Regarding some of the other electricity connections given to the other family members of the private respondent, comma, transfers in the name of the petitioner have already been obtained. Footstep. However, comma, regarding the disputed electricity connection, comma, the petitioner has given a representation to the CSC Limited, comma, seeking a transfer in the name of the petitioner of the electricity connection in question. Footstep next para. It is further contended that the petitioner has already filed a civil suit asserting his title and has obtained an order of status quo therein. Footstep next para. The private respondent, comma, although initially claiming to be the owner, comma, has filed a suit for declaration of his tenancy right. Footstep, however, comma, no interim order was granted in favor of the private respondent in such suit. Footstep, it is submitted that in view of such contradictory stands taken by the private respondent, comma, and that the private respondent was merely in charge as an agent of the petitioner, comma, the electricity connection ought to be immediately transferred in the name of the petitioner. Footstep next para. It is further argued that it is an admitted position that the petitioner is the owner of the property and the electricity connection was taken surreptitiously behind the back of the petitioner. Footstep next para. Learned counsel for the petitioner reiterates that the petitioner has already filed a civil suit and is entitled, comma, as the owner, comma, to know as to what are the documents which were produced by the private respondent to obtain the electricity connection from the CSC Limited. Full stop, next para. It is candidly submitted by learned counsel for the petitioner that when the petitioner sought for information in that regard from the CSC Limited, comma, such information was refused on the ground that the CSC Limited was not does not fall within the purview of the Right to Information Act. Full stop, next para. However, comma, otherwise the petitioner stroke owner, it is submitted, is entitled to know about such documents. Full stop, next para. Learned counsel for the CSC Limited contends that the writ petition ought to be dismissed due to suppression of the material fact that the petitioner was never a consumer of electricity in the premises. Full stop. The previous consumer was some other entity.
WS Carpentry. May I hand?
Whatever. Keep it. Comma,
It was in 2022.
It is submitted. Full stop. It is further argued that the said consumer name pertaining to the meter in question persisted even till the year 2022, comma, that is, comma, after the purported date of purchase by the petitioner. Full stop, next para. The petitioner claims to be learned counsel for the private respondent argues that the private respondent is a tenant in respect of the property and already produced relevant documents in that regard before the trial court. Full stop. Upon query of court, comma, learned counsel hands over photocopies of a purported rent bill, comma, as well as documents, as well as an electricity bill and a communication with regard to a statement of electricity bills and payments during the financial year 2022-2023 by the petitioner against his consumer number. Full stop, next para. As it stands today, comma, the proposition that the petitioner that the proposition that the private respondent is a tenant in respect of the property is contentious. Full stop. During pendency of the civil suits between the petitioner and the private respondent, comma, it would be unwise for the writ court to conclusively observe that the petitioner either has or does not have any locus standi or jural relationship with regard to the property in dispute. Full stop, next para. The petitioner has, comma, the private respondent has, comma, however, comma, furnished photocopies of a purported rent receipt and electricity bill before this court, comma, to indicate that there is sufficient prima facie proof of occupation of the petitioner with regard to the property. Full stop. In any event, comma, a presumption of correctness under section 114 of the Evidence Act is attached to the official acts done by the CSC Limited, comma, unless rebutted, comma, to the extent that the CSC Limited should be presumed to have ascertained whether the private respondent was in occupation of the property, at least prima facie, comma, for the purpose of grant of electricity connection. Full stop, next para. There being no rebuttal till date and the matter being sub judice before the civil court, comma, the writ court cannot dispel such presumption at this juncture. Full stop. Since the petitioner is already enjoying electricity connection with regard to the property and the CSC Limited, comma, being the distribution licensee, comma, is of the opinion that the petitioner is entitled to such electricity connection, comma, there cannot be any occasion or reason for the electricity connection to be transferred in favor of the petitioner. Full stop, next para. The petitioner has also sought to insinuate that it is unsure as to which portion of the property pertains to the electricity connection of the private respondent. Full stop. Next para. However, comma, even if the private respondent is able to show his occupation in respect of a portion of the property, comma, an electricity connection can be given in the name of the private respondent for whatever portion of the property, comma, showing the address of the private respondent to be the disputed premises. Full stop. Electricity connection need not necessarily be restricted to a particular portion of the property. Full stop. As such, comma, there is no scope of interference in the present jurisdiction. Full stop. Accordingly, WPO 1576 of 2023 is dismissed without any order as to cost. Full stop. The documents filed by the private respondent be kept on record. Full stop. Nothing in this order shall prejudice the rights and contentions of the petitioner and the private respondent in the civil suits pending between themselves. Full stop. It is further clarified that it will be open to the to the petitioner, comma, if the petitioner so chooses, comma, to approach the civil court under Order 11 of the Code of Civil Procedure, comma, for discovery, stroke interrogatory, stroke inspection of relevant documents. Full stop. If so approached, comma, it will be open to the civil court to decide as to what documents fall within the purview of the said provision to allow inspection, stroke interrogatory, stroke discovery to the petitioner. Full stop. No order as to cause urgent settlement.
My lord, may I just pray for one thing, my lord, since lordship has, my lord, mentioned the order about possession, my lordship will kindly, my lord, note that lordship has not gone into, my lord, as to who is in possession. Otherwise, my lord, they will.
I've repeatedly said it is sub judice before the.
My lord, but my lord, lordship has, my lord, noted that since CSC, my lord, there is a presumption.
The order is very clear.
Otherwise, my lord, what will happen, my lord? They will go and show this order and say that, see, the writ court has said that we are in possession. Otherwise, electricity.
The order is very clear.
This will, my lord, prejudice me ultimately in the suit, my lord. But only with regard to.
No, next one.
Item number 13, Tomojit Sen versus Authorized Officer SMFG India Credit.
This matter, my lord, service not yet completed, my lord, due to holiday, my lord. I could not able to.
Service has not yet been completed. Full stop. Accordingly, let the matter stand adjourned for the.
One not today, my lord.
Not today?
Yes, my lord.
Adjourned for the day.
Adjourned. Yes.
Oh, yeah, too. Service not yet complete, adjourned for the day.
অমূলাক্ষ জানাই হবে। For hearing, item number 14.
Your Lordship, I appear on behalf of the petitioner.
Yes, yes.
I'm being led by Mr. Sudhashoto Banerjee in this matter, Your Lordship. He's on his leg currently before court 9.
But we are suffering from lordships interim order. My lord, I have filed a vacating application.
Yes. If you shall refuse, if you insist, I'll refuse their prayer for adjournment. I'll take up your vacating. Yes.
Led by Mr.
Now I'll record that you have refused and you have opposed. Yes.
Because
I'll take up the vacating. Yes. If you want to move the vacating. Yes.
Lordship can see the vacating application. Lordship can see.
Yes.
Because Your Lordship missed.
Lordship.
That's it.
You want?
Yes. Yes, yes. Why should it be vacated?
Move, come this side. That the blank fault is on the part of my client because in spite of service, he failed to appear on that date. Had it been, my lord, he could appear, he could apprise your lordship's court that the order does not call for any interference at this stage, particularly in view of the agreement between the parties. The first instance, if they are in a dispute, this has to be decided by the authority concerned, not arbitration. And here, what happened, my lord? The blacklisting done
with show cause.
Yes, with show cause.
With show cause notice.
Yes, yes.
And that has not been placed before my. Only thing, my lord, which wait with my lord, that no personal hearing was given.
No person?
Personal hearing was given.
Yes.
Show cause replied, considered. This is the only way with the court that the no hearing was given.
Hearing may not be absolutely essential in all
That
this.
I have judgment with my lord. If they are not entitled to say anything else,
Yes.
because this is an admitted position. This is the clause. There is a clause that they have to deposit the money within a specific time.
Yes.
Admittedly, they have not done. So in the hearing, they will not able to say that no, they have deposited. And the condonation power is not there under the agreement. This is the only point, my lord. If you lordship can take up the
But if the interim order is vacated, Mr. Basu, then the writ petition,
I know,
because that is the consideration in the writ petition itself. Yes. So I'll reject your vacating application.
don't reject it, then
Yes.
prejudice.
No ground of vacating under Order 13 Rule 4.
Only no.
Which one?
39(4) prejudice.
Prejudice is not as such a ground.
Yes, this prejudice is absolutely.
Prejudice, no. Undue hardship?
Undue hardship. There is undue hardship to me. I cannot do anything. I
No.
cannot call for any tender for the remaining.
That is due hardship.
No, my hardship.
Due hardship, not undue hardship. So I'll reject the vacating application, Mr. Basu. Then
No, he has come. Then can I take up?
he has come. So what? The court is not dependent on Mr. Banerjee.
No, that's
I'll reject your vacating application irrespective of his presence. Yes. His presence is not necessary for me to reject your
Can I
application.
hear out both the applications?
No, I'll reject the vacating. I'll take up the writ petition after 2 weeks.
Can you do this? We are suffering. Sufferance is, my lord, I cannot issue the tender because I have issued tender. He has to be taken into consideration in his case.
Yes, Mr. Banerjee, argue properly. Mr. Basu has opposed your prayer for yes. Through
It
Mr.
has total
Kundu.
reach.
Through Mr. Kundu. Yes.
Your Lordship is hearing the main writ petition. Just gives me 30 seconds. My lord.
Yes.
Take your breath. Post.
Mr. Basu, can it be finished within half an hour? The entire thing.
I'll take time. My lord. May not be half an hour. May not be half an hour because we had shown 3 judgments.
No, we have half an hour. That's why I asked.
So I may not take, but I again don't want to say 10 minutes and take
Please.
1 hour. I don't want to do that like I did last time. But
If
unlikely
my
that I'll.
ask me as an officer of the court, Mr. Basu, my lord, did not be possible. But
Not as an officer of the court, as a senior advocate of this court. Yes.
whatever,
Your designation means something.
whatever. But it will not be. But difficulties, my lord, will not be available.
No, for 2 weeks. No.
But can it be done? Modification
Yes,
to that extent that
My non-availability, Mr. Basu, cannot be, rectified. I mean, even if I can't finish it within half an hour today, it does not inure to your benefit in any way.
No.
It will be
That is-
part-heard and I'll take it up
that-
after 2 weeks then.
that
Yes.
guys no. But is it possible, my lord? Can you allow us to proceed with the tender?
Yes.
I will let them participate, but I will not consider their candidates till the matter is heard out. Because your lordship directed them to be considered their candidature also, which I cannot do. So that I can proceed to some extent.
The tender is regarding what work?
This is transportation.
But could I just participate in the tender without prejudice to their rights and
That
conditions?
I'm saying. You
That
let
is what
them-
is.
let them
Very well do that.
participate.
Yes, yes.
We will keep as much hill cover procedure in service matter. We keep it and
You will not publish it,
yes.
and you will not issue any work order,
Let it
obviously.
proceed to some extent. Otherwise, after disposal, we will proceed. This what
They were
is being
rejected at the technical stage.
No, they are not rejected. What happened, my lord?
Acha.
They were unable to deposit the money within a specific time.
Oh, eligibility.
Specific time after allotment.
Very
Condition stipulates that if you are unable to deposit it, you will face the consequence of debarring.
Well, I'll record. Yeah.
Only one thing,
Yes,
Lord,
yes.
just one thing. Lord, I'm given to understand that the same tender, now they are floating in respect of which I had participated and thereafter your lordship was recorded very succinctly, my lord, because of not my fault, whatever. Now in respect of this, they are withholding my security deposit and bank guarantee. Now they're floating a fresh tender. Let them then refund it to me. without prejudice to their rights
No, I
and
cannot
contention.
refund because it is risk and cost.
This will be subject to the result
No,
of the.
not only that.
No,
It's
then risk and
subsequent
cost, then
tender.
your lordship, no, this is a different understanding. Risk and cost, then your lordship will not modify the order. Risk and cost is a completely
refund.
different thing.
I cannot refund. If your lordship sustain the order, our order,
No.
then my lord, it will be at the risk and cost.
No, if
If
the
they
new,
participate, we will keep it.
That is also one of the components of challenge, Mr. Bhatt.
Yes.
it is one of the components of challenge, but I agree, Manoj, this is actually going to be a final, but if the new tender is at the risk and cost of the petitioner, then your lordship will hear the petition, my lord. Then there is no,
Finalized.
no,
That
no,
is
my
not
lord, that,
finalized.
it's a completely
No,
different thing.
you are saying that, Mr. Basu, they will be permitted to participate in the new tender.
Whatever tender floated by our organization, he will be able to participate, but it can candidature or these bids will not be open.
The previous tender was cancelled.
But previous tender, it was allotted to me. I could not go ahead and do the work because my bank did not make the payment on time. They went ahead and forfeited the earnest money, all of that, blacklisted me. Your lordship has stayed that.
Yes.
Now, this,
Not only state. but
Your blacklisting will be diluted if you are permitted to participate, subject to the result of the lit petition.
Yes.
But regarding your cancellation of the previous one, that remains. Yes.
that will remain. With regard to my getting the money back, that will be final arguments after your lordship comes back. But if this new tender, this is not even in this writ petition. Today, my learned friend wants to get my learned senior friend wants to get a modification on the basis of a risk purchase action which emanates from this under challenge. Well, me participating. No, Malad, this is a far.
Mr. Basu, let us come back. Let's come back.
A far serious issue because then if I participate, then this gets.
Other tender also we cannot.
Learned
Let us at least phrase the other tenders.
Learned Senior Counsel for the respondent authorities presses the vacating application, full stop. It transpires from a perusal of the averments made therein that the allegations made in the vacating application primarily pertain to the merits of the writ petition itself and, as such, an adjudication of the vacating application in isolation would be a futile exercise. Full stop, next para. Hence, let the vacating application be heard along with the writ petition. Full stop, next para. Let the writ petition along with the connected applications be listed on September 25, 2023 for hearing. Yes.
Grateful.
Yes. Mr. Basu, not at this stage.
Yes, yes. Because I was thinking, well, not only this tender, there are other tenders we cannot participate because we have to ask him to allow him to participate. Not only this tender.
No,
That not only risk and cost. Sorry, I don't make myself clear. One tender he is opposing that if it is at the risk and cost, then writ petition may be prejudice.
Yes.
But so for other tenders of the FCI,
I have stayed the blacklisting.
no, you also said that any tender floated, he has to be allowed to participate.
So let him
Meaning that
participate, yes. That will be subject to the result of the
So that kindly make it clear then.
whatever I have, what order did I pass already?
My lord has said that whatever tender you will float, he will be allowed to participate.
So what should I clarify?
So clarify that I will not open his bid and keep it as it is.
That is sufficient protection. Let him participate. Yes.
If it is participate, I have to.
That will obviously be subject to the result of the.
I have to finalize it.
Don't do it within a fortnight.
FCI, my lord, the food.
Food what?
We'll come back.
Midday meals, that job from that go down. FCI.
Come back and trouble your lordship after 2 weeks. This is a.
If this part is modified, that I can float other tenders.
So that for that we have to go into the merits again. The same contentions will be raised by him. You'll have to controvert. Let us not go into that. Yes.
Grateful.
That order holo na? Order kore chis?
Dakun part.
Item number 15. Dolan's Food Products Private Limited and another.
আপনি গল্প করছেন বসে বসে আপনি ডাকুন yes
My lord, I'm appearing on behalf of the petitioner, my lord. My lord, in this matter, my lord, the affidavits are complete, my lord, the pleadings are complete, and the matter is ready for hearing, my lord. But my lord, Mr. Obrajit Mitra, senior advocate, he's appearing in this matter, my lord, and he's not in court, my lord. My lord, kindly grants an adjournment, my lord.
On the prayer of the ear for the petitioner?
Yes, my lord.
On the prayer of the petitioner, the matter is adjourned till September 25, 2023.
Grateful, my lord. Grateful, my lord.
item number 16
I'm for the
with
petitioner.
17, 18, 19 and 20.
My lord, actually, my learned friend has mentioned this matter all together. Might be he thinks that they all are analogous, but little bit difference is there. That my lord, if my learned friend has no objection, I have no objection.
Respondent, my lord. Similar
Let
issue,
it-
my lord, 206 notice could not have been issued because 206, 1, 2, 3 were not complied.
But I'm not objecting, but let my learned friend will be obliged by that order. If my learned friend is willing to obliged by that order in the one petition, then I have no objection.
He's the petitioner. I have no objection, my lord. These matters. Similar issues, my lord. I'll show the prayers, my lord.
Yes, what is the matter? Yes, your lordship, actually, my lord, on the last date also, my lord, basically, I'm just cutting short. I know the my lord's time, my lord. Basically, my lord, initially there was I have challenged their notice under section 206, subsection 4 of the Companies Act, my lord, which I challenged on the ground that as per section 128, subsection 5, my lord, kindly see, section 128, subsection 5 of the Companies Act, my lord. Yes. Well, it says that the books of account of every company relating to a period of not less than 8 financial years. Well, this is that which the company is required to protect. So, well, this is they are saying that actually not less than 8 financial years. It means that I am not actually required to thereafter, your lordship, the main section, which the legislature at its wisdom, my lord, even amended in 2018, my lord, section 130, your lordship. Actually, kindly see, my lord, section 130, my lord. 130 subsection 3, my lord, which is inserted in 2018. Yes. So keeping in line with section 128 subsection 5, it is inserted, no order shall be made under subsection 1 in respect of reopening of the books of account relating to a period earlier than 8 financial years immediately preceding the current financial year. So well, this was even made bound upon the NCLTs or other tribunals also. Whosoever court is dealing with that things, my lord, at that time. So, my lord, thereafter, my lord, they issued a notice to me under section 206, subsection 4, your lordship. So that section, basic thing was, this is not only for the courts, this is also binding upon you also, my lord. This upon them also, which I am saying that. And they are saying, so they issued me a notice under subsection 4 directly. My lord, here also, my lord, the name is there, the registrar. Yes, a register of company, my lord. Yes, yes. Yeah, sorry, my lord, here they are both, my lord. Yes, yes. So, firstly, my lord, directly they issued me a notice under subsection 4, my lord, where there are very conditions which they are required to actually, even if they are issuing me a notice under subsection 3, 1 and 2 deals with they may ask some documents from me. If I refuse, if he is not satisfactory, so then he will record a reason. They may proviso to section 3, subsection 3, my lord. Proviso to subsection 3 is that actually provided that before any notice is served under subsection, the registrar shall record his reason in writing for issuing such notice. Well, here even prior to subsection 4, he was required to record the reason. So he waived all such practice and directly issued me a notice under subsection 4, my lord. Here, my lord, again I challenge this thing because it's saying that if the registrar is satisfied, but first the satisfaction, how he derived that satisfaction, that is missing still now. He is satisfied on the basis of information available with or furnished to him or on a representation made to him by any person that the business of the company is being carried on. My lord, the word is being carried on is very much vital, my lord. Here he cannot say that the 20 years before you did that, which even the 8 year, beyond 8 year, even statutorily barred, my lord, it is going. Is being carried on for a fraudulent or unlawful purpose or not in compliance with the provisions of this act, or if the grievances of the investors are not being addressed, the registrar may, after informing the company of the allegation made against by written order, call on the company to furnish any writing, any information, explanation of the matters specified in the order within such time as may be specified herein, and carry out such inquiry, my lord, and carry out such inquiry as it deems fit, after providing me the reasonable opportunity of hearing, my lord. He can do inquiry after providing me that he cannot directly to. So, my lord, kindly see the second proviso of this subsection, my lord. Here, my lord, he clearing that provided further that where business of the company has been or is being. So, that word has been used very consciously in the subsection 4 is being, because it is dealing with both has been or
actually this is present continuous also is being carried on. So they have directly issued me the notice, and they assumed in themselves when they are exercising. So subsequently, my lord, they proceeded further to subsection section 207 also. They issued me a summon. They assumed the powers of the civil court also under section 207. So they are authorized to exercise this power during the course of proceedings, my lord. During the course of proceedings, they are authorized to exercise this power of the civil court, where as per, my lord, kindly see subsection 4 of section 207, even if I refuse to provide them this information, they can put me for a jail also for 1 year also. So they have invested with very much power. So they are supposed to exercise their power very much judiciously, my lord, from the beginning. On this ground, I challenge them, and my lord, I approach before this Honorable High Court in the beginning. So at that time, His Lordship Justice Manta has directed the actually opposite party who will consider these allegations which I have made in the writ petition and pass a reasoned order within 2 months, my lord. These all things have been specifically recorded in the order.
It was directed to be done within 2 months.
My lord, that order is annexed in my affidavit of reply, my lord, at page 11, your lordship. Page 11, my lord, that is the last paragraph.
Yes.
This page 2, this court is of the view that respondent must take a suitable decision on either of the representation. My lord, my representation was that on the basis of what complaint or what allegation you are proceeding, you issued me the notice. And the petitioner argument as contained in the writ application in course of adjudication and passing the final order. The petitioner shall be entitled to file a preferred reply notice under 4 within a period of 3 weeks from date. Upon receipt of such reply, the registrar shall take appropriate steps in the.
What was the representation about?
Well, representation, well, which they have issued me a notice. His Lordship directed me to file this reply to the notice also. Yes. And simultaneously, they were also directed to actually consider these things also. 128 subsection 5, how they are actually supposed to exercise that power, how they are entitled to waive that condition of section 2, which even the court cannot authorize to do that as per section 130. And how, my lord, that they can.
No, they ask for documents prior to 8 years.
Well, 2056, my lord, more than 20 years. That I will show. Well, even.
So you have two challenges, 2 prongs of your challenge. One is that 160, 206, 1, 1 to 3 were not complied with. Not complied. Secondly, that they called for documents prior to 8 years.
My lord, that is that
regarding the first challenge. Acha, let us read 206 once again.
My lord.
Is subsection 4 dependent on 1? I mean, these are independent. 1 to 3 is a separate exercise.
Yes, my lord.
Having a separate conspectus altogether.
Yes.
4 is different. 4 is not dependent on a prior notice under 1.
Yes, but it's saying if the complaint is being carried on also. So it's also being in the
our registrar can very well issue a notice directly under 2064 if he has information, etc., etc. And then they have to give a hearing to you, which has been given to you.
He's saying the registrar has the information that the affairs of the company is being carried on. So if my affairs is being presently
carried on. I am on the first leg of your submission.
Yes,
so you have also challenged it on the ground that 2061 notice was not given, but 2064 is directly given.
4 is given on the past allegation, where 2064 is.
Past allegation is the second prong of your argument. The first allegation. So 206, 1 to 3 have no nexus with 4.
My lord, this is no nexus if the allegations are present continuous, my lord. That is also connected, my lord. It has no nexus if the allegations are the affairs of the company is not being or is being carried on. So, well, proviso very much clearing this thing. In the proviso, they use both the words has been or is being, my lord. So both words has been simultaneously used in the second proviso of 266.
How does that matter? Even if it is past continuous or present continuous, how does it matter? Well, it says provided further that whether the business of company has been or is being carried on for a fraudulent or unlawful purpose, every officer of the company shall be punishable for fraud. That's a separate.
No, but that is your lordship
subsequent to their when they start their inquiry, only then this becomes German.
No, my lord, I'm reading section 3. This subsection
4, second proviso.
Yes, my second proviso, my lord, on that basis, this is for immediately stopping if something is going wrong immediately.
But how does that connect to say 206 1 to 3?
1, 2, 3, my lord, if the allegations are passed, my lord.
If 1, 2, 3 are not there, There is no step taken under 206(1)(2)(3).
Yes, my
Can't they directly start a proceeding under section 2064? Can the registrar not say, I am satisfied on the basis of such and such information available from anywhere,
yes, my
and ask you to furnish those documents and give you a hearing? Can they not do it? They have
If
done
your
this as
lordship
that.
saying that, then my lord,
No, not
actually,
me. You
I,
tell me.
I was under the assumption that here the word is doing is being carried on, and 1, 2, 3 is there. Subsection 1, 2, 3 is already incorporated in the act, my lord. And in the 4, in subsection 4, it is saying is being carried on for the emergency provision. They are vested with power to stop it immediately. So I was under that impression, my lord. Actually, ultimately, it's a lordship to decide, my lord. Second point was, my lord, that section is very much made mandatory.
Cannot ask for before 8 years.
Yeah, they cannot ask for before it. That is the main crux of my argument, my
They
lord.
have also asked for documents before 8 years in their notice.
My lord, kindly see, even in spite of the order of the Honorable High Court also,
Yes.
they remain stuck to same allegation. My lord, kindly see this page 47 of the writ petition, my lord, which is the impugned notice. So, my lord, thereafter, even after that 204, section 204, there was section 207, 8, 9, 10, 11, 12. If they were not satisfied, they can very much exercise their power under 8, 9, 10, 11, 12, my lord. There is a subsequently provision for them, but they have not remained them. And my lord, they directly jump to, they have not responded anything. They have not taken any decision for 6 months. So in their reply, in the first time, my lord, they said, my lord, is at page 47, my lord.
Yeah, 47. Yes.
Yes, my lord. This is at page 47. If your lordship kindly see, well, this is the, without waiving all their entire powers under 7, 8, 9, 10, 11, 12, which is vested with their power. If your lordship see, my lord, that sections also, my lord, previously, if your lordship kindly see section, please sit.
Yes, yes.
You will get a chance.
To assist your lordship, my lord, your lordship had asked for the notice that is at page 25, my lord. The
Notice,
at
my lord.
272 is at page 47, my lord.
Please, no, it is a notice under 272, which is before your my lord. My lord, even if they are not satisfied with their thing, your lordship, they are vested with the power under the 212, section 211. They can direct the SFIO. They have a further provision for investigation under section
Challenging in the writ petition 2064.
Well, I'm challenging. They cannot actually claim a documents which are beyond 8 years, my lord. Second thing, they are, my lord, directly cannot come to the section 206 subsection 4 when the allegations belongs to even statutory barred period, my lord, which is statutory, my lord. And yeah, this
Are you challenging the notice itself?
But that notice 206 subsection 4 notice has gone because they have already proceeded further without complying the order of the Honorable High Court.
So now what are you challenging? What is the challenge?
Well, this is the impugned notice at page 47, my lord, which they have directly jumped to the section 272 subsection 3, my lord. So they have directly jumped to this section. So your lordship, even in the first paragraph itself, they are saying that in the financial year 2056, you have did this, you have did that, my lord.
Yes, yes.
So that is, my lord, again, they are coming to 2056, my lord.
2064, after that, what happened? An inquiry was done.
Nothing done, my lord. This even the Honorable High Court.
After 2064, they have to exhaust up to 2078, everything. Then only they can issue a notice under section 271.
No, they have to exhaust that thing also. And even when the Honorable High Court directed them to communicate me within 2 months, they want to communicate me also what decision they have taken. And even if your lordship's order also, order dated 30 June 2023, my lord, in this petition, they made the submission that the order of the Honorable High Court has been complied with, and this proceedings has been filed to cripple that winding up petition before the NCLT.
What is the ground for their winding up petition?
Well, same ground which is under 206 subsection 4, my lord, may kindly compare this. Same that is at page 25 and this is at page 47, my lord.
See, in the winding up petition, can't you go before the tribunal and take these points?
My lord, that thing your lordship certainly take that, but they should not. Actually, that your lordship has given me a limit.
So 2064 notice they have given.
No.
They have abandoned it apparently, according to you. I mean, they did not proceed on that further. Then they took out this 272-3 notice petition directly. Are they precluded from doing that? Suppose they abandon that inquiry.
Yes,
and they file this winding up petition before the tribunal. You can very well go there, resist, say that 206 did not culminate in anything, and there is nothing on record. even irrespective of the 2064 having not been proceeded with, can't they take out a petition under section 272(3)?
No, but that is, my lord, that they are bound by then section the 128 subsection 5 and by section 130 also. So they cannot presume that they are authorized to exercise this power on 256 document.
128, what does 128 come in here? 128 comes in 2064 in pursuance of that. If they wanted ask for documents prior to 8 years, then only 128 would have come in.
Yes,
Here 2064 exercise you are saying they have abandoned. So where is the question of 128 coming in now?
128 is the main crux where I am dependent now, your lordship. Which was the same in 205 I have challenged when they have issued a notice under 206 subsection 4.
Now ultimately you are challenging only this notice under 272(3). That is
This
what
remains. This remains now, your lordship. Then
this remains.
This remains now.
How is 128 even German here in this?
Well, 128 is very much German. They have issued me the notice under this is under notice. They are calling me the document of 2056 from the very first paragraph, my lord. This page 47, your lordship, kindly see 90% allegations of beyond statutory period, my lord. Same, they are remaining stuck to that. They are not changing their mind in spite of the order of the High Court, my lord. This I am reading, my lord. On perusal of the annual return attached with the balance sheet of the company of the year 56 on the MCA portal, it is observed that the company has allotted this amount of shares to basic thing, my lord. I'm saying you are exceeding jurisdiction when you are asking for the documents. You are after nearly 20 years. They are saying that in 17, 18 years, you are saying that you produced me that document. So here, my lord, I will reply to them that the entire payment has been made by the bank, not by cash, nothing, my lord. The entire payments were made on the year 2005-6 by the bank. They cannot deny that the payment has been given in any cash. So my lord makes subsequent, it is 2067. Next paragraph again of the 5-6. They say in page 48, the second paragraph is the entire copy paste wherever they are pasting these things. Nothing when, where, to whom I have paid, nothing is stated. In the year 2006-7, that the company investment was in corporation of that company, again 5-6. So here in the second, only one allegation is there of the 16-17 to 19-20 in the third paragraph of the page 48, my lord. Here they are saying that to the Shri Ispat Limited, it is observed that the company has not disclosed any borrowing loan taken by the subject company during the year. So here, whose fault it is? It is the fault of the debt company who is not showing that thing as a loan. I have showed my loan. They are not asking from that company that why you are not showing. I have made my income tax return and everything by showing it as a loan. So if that company has not showed that thing alone,
so that you can very well go and oppose that winding up petition and take all this.
No, if you lost you that means then definitely I shall. I'm bound to go, my lord.
You have a better option there because the writ court's jurisdiction is rather limited. We cannot go into questions of fact and all these things.
No, but I'm not going to fight. There's only one thing, my lord, they can be restrained from.
Because even if I suppose you succeed on the issue that 128 years it restricts to 8 years and all, that does not circumscribe their power under 272. Well, 272 is not circumscribed by 128.
No, but that means this entire authorities are bound by section 128, my lord.
Yes.
This entire authorities are, even the court is bound by section 130, my lord. Then even in the year 2018, it was made to be only to not to compel me the document.
They're not asking you for the document.
No, I'm saying, it is saying the NCLT, which court, your lordship directing me to go before that court, the binding a petition is pending.
Yes.
So even that court cannot ask me to show me these documents, whether I am true or false.
If that court cannot ask you, that court has not asked you as yet.
No.
So if the tribunal, even if the tribunal asks you for that, you can cite very well 128.
No, but
and if the tribunal cannot ask for that, it will not ask. They'll fail on their on the previous allegations, the first few paragraphs.
Certainly, my lord.
Their last petition will fail on that.
Last one, but I am still in the dark that whether they are this outside the purview that whether
kindly allows me through some light, my lord.
Oh, my lord, please, I also want to be enriched from the knowledge from a learned friend.
My lord, may I?
Yes.
My lord, your lordship will kindly take, my lord, page, my lord, Justice Manta's order, which he's been placing, my lord, in what prospect it was passed, my lord. Your lordship will kindly, my lord, what had happened is, my lord, notice was issued under 2064. He comes before this honorable court without filing any reply to that for seeking quashing of that notice on the ground 206, 1, 2, 3 have not been complied. So 4 could not have been issued. The honorable court did not allow his contention, did not take that, my lord, in and passed a mercy gave him an opportunity to file his reply.
The court did not turn that down.
My lord, his writ petition is pressed. This was not allowed, my lord. It did not turn it down because the court did not feel.
The court directed only, they gave him an opportunity to give
file a
reply.
reply, my lord. So, my lord, this all his argument, my lord, that 201, 23, 204 could not have been, my lord, issued without complying with 201.
Justice Mantha did not decide on that.
My lord, that is, my lord, the way he's placing the order, my lord, that is why I'm just showing, my lord, this order. And he has also taken this point of section 128, my lord. This is also reflected in this order. What the Honorable Court held, my lord, said, my lord, it's not there in the order, that very well, if you think that the documents are of 8 years old, don't respond to that. What about the other documents? I will show the notice, my lord, in which there are documents of other years. Deal with those, my lord. So, my lord, as a mercy, my lord, the Honorable Court directed that very well, you have not filed the reply to the show cause, you file it, my lord.
What happened after that?
My lord, thereafter, now your lordship kindly comes to, my lord, page. My lord, after this order was passed, my lord, they do nothing. Sit over the order. Then we send them a reply that in terms of the order passed by the Honorable.
They did not reply.
My lord, then we send them a reminder, then they reply. Now your lordship will kindly see the reply. Lordship will kindly see the reply which they give, my lord.
Yes.
Well, may I place the reply, my lord? That is at page
43, my lord. Page 43 of the writ
my lord,
petition.
page 43.
Yes.
My lord, 38, page 38 onwards.
It is at page 43, my lord, of the writ petition.
My lord, may I just show the notice? This is very German, my lord. At page 25, my lord. This is the notice which is issued, which is the bone of contention that it could not have been done, my lord. My lord, just 2 minutes I will take of your lordship, my lord. This notice, my lord, if your lordship will kindly take it at page 25, serial number.
Mr. Kankani will continue the next day because in 2 minutes he will finish, but he'll reply and I cannot pass my order within him.
I will continue on the next day, my lord.
But my learned friend is also bound to, even if that order is passed by mercy, my learned friend is saying that order,
show, my lord,
but they are supposed to follow that order. They are supposed to bound to give the reply also. We have given a reply within time.
Hearing was commenced. Hearing was commenced but could not be concluded. Full stop. Let the matter be placed under the same heading on September 25, 2023.
My lord, may keep it as a part heard also, my lord, because the lordship has given a valuable time on that, my lord, 2 occasions.
I'll take it up lock, stock, barrel, decide it.
Well, both parties.
I'll start with Mr. Kankani on the next one.
My lord, I'm grateful, your lordship. I'm grateful.
Today, my lord, one application is supposed to be listed, my lord. I have inquired that, my lord, one can is not traceable because of that, my lord, it is not listed. My lord, I am only making prayer, my lord, if it will be allowed to be listed, my lord, I will keep one copy from my end. It is not traceable, my lord, it is in the address. My lord,
Appellate said no officer is there. You mention it when I take up appellate said matters next. I'll consider that. Yes.
Grateful. I am grateful.